This meeting will be recorded and will be available to view on the committee's YouTube channel soon after today's proceedings are finished. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Erin Sheehan for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of Ms. Carrie L. Linthicum, Esquire of Castle Hill, for appointment as a district court judge.
Thank you, Representative. I now recognize Senator Carney.
I second the motion.
Thank you. And as I mentioned at the outset, this is a nomination for the position of district court judge. A copy of the statutory requirements for this position is available online. The chair now recognizes Jerry Reed, the governor's counsel, for the purpose of making a statement concerning the nomination. Welcome, Mr. Reed.
Thank you. Good afternoon, Representative Harnett and Senator Carney and members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this afternoon to present Carrie Lee Linthicum as Governor's nominee to the Maine District Court. Attorney Linthicum's career has taken her from being a coat checker and candy seller at the Kennedy Center for Performing Arts to most recently serving as the highly respected Deputy District Attorney in Aroostook County. After graduating from law school in Washington, D.C., she began a 6-year career in private practice in Aroostook County, where she worked as a general practitioner on issues such as domestic relations, personal injury, landlord-tenant disputes, Social Security, workers' compensation, and employment discrimination. She accepted a position as an assistant district attorney in 1985, where she served for 12 years prosecuting felonies, misdemeanors, and civil infractions. Notably, as part of a unique arrangement between the DA's office in Aroostook County and the Attorney General's office, she also handled child protection cases for the state to provide coverage for these matters in the Madawaska, Presque Isle, Fort Kent, and Caribou District Courts. In 2007, she was promoted to Deputy District Attorney, a position she held until her retirement from that office in 2020. She holds a degree in history, magna cum laude from Dickinson College, and is a graduate of the George Washington University Law Center. Attorney Linthicum has received awards and recognition for outstanding service from the Department of Inland Fisheries and Wildlife, the Coalition for Family Crisis Services, and the Maine Animal Welfare Program. In addition to her distinguished legal career, she's also been active in her community, including as a board member of Legal Services for the Elderly. It's my pleasure to recommend her for appointment to the Maine District Court on behalf of Governor Mills. I'd be happy to answer any questions the committee may have.
Thank you very much, Mr. Reed. And I will now ask if there are questions from any committee members for the governor's counsel, Jerry Reed. So please raise your electronic hand and I'll look through the room. Seeing none, thank you very much for presenting the nominee today. Greatly appreciate it. I will now turn to John Hobson, who chairs the Judicial Selection Committee. Welcome back to Judiciary, Mr. Hobson.
Thank you very much, Representative Harnett, Senator Carney, members of the Joint Standing Committee and the Judiciary. My name is John Hobson. I am chair of Governor Mills' Judicial Selection Committee. And on behalf of the committee, I request that this committee act favorably on the nomination of Ms. Linthicum for the district court. Ms. Linthicum comes to this job with, as Mr. Reed said, about 40 years experience in the state's most far-flung county, Aroostook County. She has early in her career a background in private practice, about 6 years of private practice. So she has some familiarity with the private practice of law. She then went into the district attorney's office and had a very good, excellent career in the district attorney's office. And one of the issues that the committee looks at when someone has spent a long time in the district attorney's office is what their reputation is among the criminal defense bar. And these are tough positions. If you're a district attorney or in the district attorney's office, you have to make tough calls in terms of criminal charges and make judgment calls about those. And those are not easy. But the vast majority of the criminal defense bar in Aroostook County felt that Ms. Linthicum approached her job in a fair and even-handed way, that she was attempting in making decisions as a prosecutor that was trying to get to the best result for the state. And in the cases of an individual defendant, when the individual defendant could be helped with the manner in which the disposition was held, she would work with the criminal defense attorneys to achieve that. She had, among the vast majority of the criminal defense bar in Aroostook County, very good support. The other thing that I don't think can be discounted here is that in any group of applicants, Ms. Linthicum, because of her career achievements, would be an exceptional candidate. But she really is kind of an historic nominee. She is the first woman to be appointed to a judicial position in Aroostook County. And that's a county which is, because of its geographic location, can be somewhat insulated from the rest of the state. And I think it sends a signal in terms of the impartiality and that the justice will be blind to have the first woman judge appointed to that county. And the committee was very much in favor of having Ms. Linthicum become a district court judge, and her career in the trial and the criminal practice of the district attorney's office will have her get a running start on this job, and her having some familiarity with the other areas of civil practice from her days in private practice, albeit a good while ago. But she's willing to put in the work to be able to come up to speed, and she will be given all of those factors. The committee believed that she was an excellent choice for this position, and we would hope that this committee, after this hearing, would agree. So on behalf of the committee, I request that this committee act favorably on the nomination of Ms. Linthicum.
Thank you very much for your testimony today, Mr. Hobson, and thank you for your public service in this capacity that brings you in front of this committee very often. We greatly appreciate your input. Are there questions from committee members for Mr. Hobson? And again, seeing none, I thank you again for your time today and for your valuable input. I will now recognize the nominee, Ms. Carrie L. Linthicum, Esquire, for the purpose of making a statement concerning this nomination. Welcome to the Judiciary Committee, Ms. Linthicum. Please begin your presentation when you feel comfortable.
Thank you very much. Senator Carney, Representative Harnett, members of the Judiciary Committee, my name is Carrie Linthicum. I live in Castle Hill in Aroostook County, Maine, and I am here today to discuss with you my nomination to the position of Judge of the First District Court of Maine. It is such an honor to receive this nomination and a little bit overwhelming as well. You have in your folders my educational background, and thank you, Mr. Hobson and Mr. Reed, for explaining those as well. You have my education and professional background in your folders. You also have letters from my former boss, Neil Adams, and a longtime friend of mine who was a private attorney, David Dunleavy. Both were concerned about being here today, and so they wrote letters instead. So I hope that you will consider those letters. Let me tell you a little bit about myself that's not in the professional and educational background. I was born and grew up in Baltimore County, Maryland. I attended college in what seemed to me to be a small town at the time, Carlisle, Pennsylvania. After I got to Maine, I realized it wasn't that small anymore. I spent my junior year in Bologna, Italy, and then I returned to Carlisle for my senior year and graduation. I went to law school in Washington, D.C., and I took and passed the DC the bar exam the summer after I graduated. However, sometime between when I graduated and when I took the bar, I decided that I did not want to spend my life in DC. I decided that a better place for me would be Maine because my family and I had vacationed there for a short time when I was a kid, and I thought Maine is where I want to go. So I went to the placement office at my law school. The internet wasn't an option at the time, and I found one opening in Maine for a place in Presque Isle, a law office in Presque Isle. And with my little bit of French background, I thought, oh, Presque Isle here in Ireland must be on the coast. This is just going to be wonderful. So I applied for the job. Turns out Presque Isle is nowhere near the coast, but I finally looked at a map before I had my interview, and I flew up to Augusta for the interview, and I looked at a map and I thought, well, you know, what the heck, I'm here, I'm going to try it. So I took the, I was offered the job if I could pass the main bar. I passed the main bar when it was offered in the winter. And in March of 1981, I think it was late March, I was notified that I had passed the bar and that I could come to Maine and start. I packed everything that I owned into my little Volkswagen. I was at my parents' house in Maryland. I packed everything that I owned into my little Volkswagen, and I drove and I drove and I drove, and I continued to drive until it was dark in Bangor, and I still had to keep driving. I had no idea. And when I got onto Bangor, there were like no lights on the road. There were no cars on the road, just me and millions of trees everywhere. And I was thinking, I can see where Stephen King gets his inspiration. Anyway, I finally got to Presque Isle. It was April the 6th, I think, the day I arrived in Presque Isle, and there was still snow on the ground. I left green grass and flowers, and I came to snow. And I thought, oh, what have I done? I mean, here I am. I don't know a soul except this is the person who hired me. And I thought, well, I can always get in my car and drive south, but I'll give it a shot. Well, giving it a shot was the best decision I ever made. I am from away. I'll always be from away. But the people that I met here were always friendly to me. They were always willing to help when I needed help. They offered help. And it's just been a wonderful experience. Some things have changed along the way and people are different. Aroostook County is not as far away from the rest of the world as it used to be with the internet, but still the people are the same here and this place is my home. I want to be a judge in Aroostook County because I feel that I have more to give to this community and I would be most proficient at doing so in the legal realm. In that realm, I have vast experience in dealing with a wide variety of people in all sorts of situations in all walks of life. Some who wanted to be involved in the legal system and most who didn't. And yet I had to deal with all of them. I believe that it is the job of a judge to ensure that all of those people who come to the legal system feel like they will get and actually do get a fair shake when entering the courthouse door. I am a very good listener. I have learned that while I may not agree, if I take the time to listen respectfully to what people say and try to understand what they mean and keep my mind open, I will be much better able to address any issue that arises. I believe that will help me to be a very good judge. Thank you very much for your time and consideration, and I am happy to answer any questions that you have. Thank you.
Thank you very much, Ms. Linthicum. I did note that Mr. Hobson said you recently retired. This will be a very short-lived retirement if this
It will.
nomination moves forward. Are there questions from committee members for the nominee, Ms. Linthicum? Representative Galgay-Reckitt.
Good to meet you, Ms. Linthicum. And I'm very glad to see that you might well be the first woman judge in Aroostook County. Having spent my life trying to make sure there would be women judges everywhere in the world. I wanted to ask you a question about something that was on your resume, and it may not be, it's a two-part question of which you may not want to answer and be able to answer in specific either part, but a general answer around this topic. I noted that you in the early 90s taught a course on police and the community.
Yes.
And I can't remember what institution it was at, but I serve on the Criminal Justice Committee as well as the Judiciary Committee. And so I've had a lot of interaction around police issues this year. So my question to you from that experience in the early 90s is, 20 years later, not that I expect you to remember every detail of what you taught, but what might you have taught differently, or what discussions would you encourage in your class that you might or might not have done in the early 90s?
In the early 90s, there was not, let me backtrack for a minute. When I came here in the early 80s, we still had Loring Air Force Base, and Loring Air Force Base had more, it helped a lot with the population, gave a lot more people. But one of the things was it was more of a colored population. Northern Maine, when I arrived, was pretty white. There weren't very many different people. And so when I was teaching my class in the early 90s, we weren't dealing with the racial issues. We did have Native Americans, but it wasn't, the issues were not out front like they are today. So if I was teaching that class today, I would be talking more about being aware of the racial issues all of the way around. And it would be, not just when to stop people and how to stop people and how to treat them, but to be aware that everybody is looking at you all of the time and that you have to present your best self and pay attention to the fact that everybody is a citizen and everybody deserves to be treated equally.
Thank you.
Thank you, Representative. Did that end your questioning? I thought you said you had a two-part.
Yeah.
Well, no, they were both there. That was the, what did you do and what would you do? What would you do differently and what kinds of discussions would you encourage? And I feel like the answer covered both those pieces.
Thank you very much, Representative. Representative Babich.
Thank you, Mr. Chair. And again, nice to meet you, Ms. Lithicum, and I appreciate your resume and your story about how you got to Aroostook. That's wonderful. Most of the judges on the main bench, come out of the prosecutorial side. And I just had a very general question for you about empathy. Is there such a thing as compassion fatigue? And do you suffer from it after having had a long career? Yeah, thank you.
Yes, there is a thing as compassion fatigue, but every day you get up and you do what you need to do. I found that being a prosecutor is, there are a lot of things I could do as a prosecutor to help people, because I could, when I could work with when I could work with the defense attorneys, we could come up with decisions that didn't require going to court and making somebody do something that could be avoided by them following a different path or giving something else a try. So that works sometimes. The hardest part is of being a prosecutor, I think, is dealing with victims. And you never know when you start a case how the case is going to turn out. And sometimes it can be so devastating for the victims when it doesn't turn out the way they want, or it turns out the way they want, but then they don't get the relief that they thought that they should. That's where the compassion fatigue comes to pieces.
Okay, thank you.
Thank you, Representative Babich. Representative Moriarty.
Thank you, Mr. Chair. Good afternoon, Ms. Linthicum, and it's good to meet you and to hear from you. Had a couple of questions. If confirmed, will you be based primarily in Presque Isle, or will you rotate among the various district courts in Aroostook?
My understanding is I will be doing the northern courts, which would be Caribou, Fort Kent, and Madawaska. And the second district would be Presque Isle and Holton. And I'm sure that there would be some changes, switching seats sometimes. So mostly it'll be the northern courts.
And have you practiced in the northern courts during your career?
Yes, I have. When early on in private practice, I go to Caribou all of the time for Superior Court. I did when I was working. But for the northern courts, I did those mostly when I was involved in child protection and child support cases. I covered those courts quite a bit. And so I was up there a lot.
Okay, thank you. I had one other question, and that is, given your years of experience on the prosecutorial side, what are your thoughts about the learning curve that you will inevitably face as a judge when it comes to the civil side, to include family law, child protective matters, civil disputes, landlord-tenant, and all of that is not pertinent to prosecution?
In some ways, yes, it is pertinent to prosecution. In a lot of ways, it's pertinent to prosecution because a lot of our cases that we ended up prosecuting were cases that started off as domestic violence or child protection cases where there was crime, where there were crimes involved as well. So in order to keep up with all of that, all of the prosecutors have to keep up with what the civil laws are, so that when something happens, if we get a report from a police officer and the police officer says, is this a crime? And then we know, or if we don't know, then we have to look up what the law is regarding that and whether or not it's a crime. I guess let me give you an example, like bankruptcy. Let's say somebody filed for bankruptcy after just taking a whole lot of things that the person shouldn't have taken, but it wasn't criminal taking, it was just not being a good person. Is that a crime? No. I mean, there's nothing that's going to happen with that, and the bankruptcy court would deal with that. So we have to know, in order to prosecute, you really have to know what all of the laws are. And the other thing is, every year when the new legislation comes out, most of all of us always read all of the new legislation, not just the criminal law related stuff, but all of the new legislation as well. But I don't have any of that committed to memory, and so I would have to go through and review it when something came up.
Sure. Okay. Thank you.
Thank you, Representative. Senator Carney.
Thank you very much, Chair, and welcome, Ms. Linthicum, to the Judiciary Committee. It was wonderful to hear your personal story of your journey to Maine. I too grew up in Baltimore County, Maryland, so it's very nice to meet you, and I'm happy that we're both in this wonderful state.
It is, isn't it?
I was wondering if you could describe for the committee your experience doing civil litigation when you were in private practice, because I was thinking along the same lines as Representative Moriarty about as a district court judge, your involvement with civil matters as well.
Most of the civil matters were landlord-tenant or occasionally small claims, but divorces, a lot of divorces. And then there were occasional cases, not personal injury cases, but like business violations of business. But I also, during my time in private practice, was a court-appointed defense attorney often. I was a guardian ad litem for a lot of child protection cases. I did some child support cases before I did them for the state. So I was well aware of all of those.
Thank you. It's nice to hear about your breadth of experience in that area. Thanks.
Thank you.
Thank you, Senator Carney. Representative Craig.
Thank you, Mr. Chair, and it's good to meet you, Ms. Linthicum. Are we saying it correctly?
Yes.
Good. I can't resist asking you about your IF&W award. Could you talk about that?
I guess I do a good job taking care of dead moose and dead deer because it was presented to me because I represented their inland fisheries and wildlife, and I didn't discount their cases, and I followed through. That's my best explanation, I think.
Thank you. And a follow-up, or actually a second question?
Absolutely, Representative.
Thank you, Mr. Chair. Could you speak a little bit more about Representative Galgay-Ricketts' question about the differences between the 90s and now, and the changes in terms of perhaps the population that you're dealing with and the kinds of issues that are coming up that might be different than they have been in the 90s or 2000s, with the change of population, but also just with changes in the world around equity issues, around poverty, around rural nature of the county. Anything along those lines?
Since I came here, since I arrived, the county, there's been a lot of poverty. There was a whole lot of poverty. It was one of the first things that I noticed. And it seems like it's not going to change. We need something else more to happen. So when we lost the Air Force Base, even though a lot of the poverty was still here, when we lost the Air Force Base, and some of the marginal people lost things as well. So that was a big blow. And we really, there's so much that the county has to offer, but until somebody wants to drive up from Bangor, you know, it's just not going to happen. So we need more money. You know, that's one thing that we need is more money. In terms of the charges, since I first arrived here and was given court-appointed cases as a guardian and as a defense attorney, child abuse, sexual abuse of children has always been a big issue. And that's remained consistent. During the 90s, I think I would say, drug issues became much worse. It just exploded. There were always drug issues, but it just exploded to the point where it seemed to take over everything. And people who might have been in a little bit of trouble before were getting involved in drugs, and we don't have a drug court up here, so it was difficult to find something to do with them. And again, it seemed like an issue that wouldn't stop, although some people managed to make it stop. In terms of the other crimes, and the things that I dealt with from the very beginning were domestic violence. One thing about domestic violence is I think that because of the publicity that it's getting earlier, people listen to it more. It doesn't get discounted from the very beginning. I remember representing a woman who talked about, this was in a divorce situation, and talked about how abusive her husband was to her, and she wouldn't go to the police ever. You know, she thought it was her fault or something, and it was devastating. So the good thing about the world creeping into Aroostook County is I think some people are more energized to go out and do something about it. But some of the bad things would be like drugs and it just keeps going.
Thank you very much.
Okay.
Thank you, Representative. Senator Keim.
Thank you, Mr. Chair. Welcome, Ms. Linthicum, and thank you for your willingness to serve in this way, and congratulations on your nomination.
Thank you.
And also on being accepted in the county when you're from away. That's a feat in itself as well. When I reached out to try to get some information and see what people thought of you, one of the first reports I got back was from Trey Stewart, and it was a glowing report, Senator Trey Stewart. And so it's definitely obvious that the people have accepted you there and appreciate you. My question is, you had already retired before this appointment. What made you want to begin working again and be a judge?
I felt like it was unfinished business. I thought it would be a good judge because I do have all of this experience and I've dealt with a lot of different people, and I really am a good listener. And so I thought retirement's not bad. It's really pretty nice. So it was a hard decision to make. But I thought I think that I could really do a good job, and I'm willing to put myself out there and do that good job. That's why.
Thank you for that. And we do need good people doing that job. So thank you so much.
Thank you.
Thank you, Senator. Representative Poirier.
Thank you, Mr. Chair, and thank you for joining us today, Ms. Linthicum. I appreciate your time with us.
Thank you.
I would like to know if you could elaborate for me on one of the questions in the questionnaire regarding basically how you thought the system of justice in Maine could be improved. You had responded spending more money on preventing problems that result in people committing crimes. Can you give us some examples of areas where you think that could happen?
Early education is one I can think of. Putting a lot of money on early education, helping people with problems, giving them a place to go, I don't, a drug court addresses issues afterwards, but we really could use a drug court. But the places for, I guess I'm mostly thinking early education and also counseling. If you want, a lot of people are reluctant to come forward when something bad happens to them, but if they had a place to go where they could deal with the issues and there wouldn't be a report and until they wanted to give one, I think that's one thing that could help.
Thank you.
Thank you, Representative. Representative Cardone.
Thank you. And my question addresses the lack of a drug court in Aroostook County. We were in some hearings or conferences with the Appropriations Committee, and we were told that the only reason there isn't a drug court in Aroostook County is because the district attorney doesn't want a drug court in Aroostook County. You seem to be of a different opinion, and I wondered if you could elaborate why and whether it is the district attorney's office that's blocking this action. I know you have to be careful politically here, but I would be interested to know what's going on with this issue.
I know that the district attorney's office has a program for people that's similar to a drug court, but isn't a drug court. And so that was run out of the Caribou office. And I think that it needs more money. If it's going to run well, it needs more money. And I don't know. And so it's being funded, I think, mostly by grants. But we need something because there are a lot of issues and they just have to be dealt with.
Thank you.
Thank you, Representative. Representative Gallagher-Records, do you have additional questions?
Yes, I do, if I could.
Sure.
I'm sort of debating because I have two and they're not even faintly related, so I think I'll just choose one. And the one I want to choose, I think, is what has been your interaction with the Native American tribes that are in Aroostook County, where I had the privilege to drive up to last year to visit one of the reservations. And I'm just curious as to what your take is on what could realistically happen to enhance the well-being of the two tribes, I think, that are in Aroostook County. Maybe there's three, actually, now that I think of it.
I think there needs to be more organization. When I came here, there was a tribe, but not a tribe. It was people who were all Native Americans, but they didn't have any kind of organization. So like any organization that's getting started, they need time to get going to make things work. I interact with them, but not on a not as them as an organization, because they're really not acting as an organization. Does that make any sense? So I interact with people in the tribe, and people in the tribe when they have a case would give me information, or I'd give them information if I could. But in terms of like interaction office to office, I can't say that there was any.
Thank you.
Thank you, Representative Reckett. Representative Newell.
Thank you, Mr. Chair. Good afternoon, Ms. Lithicum.
Yes.
Did I pronounce that correctly?
Yes.
I'm Raina Newell, and I serve as the tribal representative for the Passamaquoddy tribe here in Pleasant Point, representing both Pleasant Point and Union Township. And I kind of took notes, following your introduction and where you resided in Carlisle, Pennsylvania. Is that correct?
Yes.
So what came to mind immediately, as you probably are aware, boarding schools.
Yes.
The boarding school
Yep.
that was located in Carlisle, and which often housed, following the forced removal of, Indigenous students, not only to Carlisle, but across the United States and Canada.
Mm-hmm.
So I think what I would like to ask, following that, since I think that practice has since stopped. However, in regards to child welfare cases, were you going to be located up in the county? You mentioned the northern portion. However, if you were to work out of the second district covering Presque Isle and Holton, you are aware that the Holton Band of Maliseets and the Micmacs from Presque Isle neither have a tribal court,
Right.
Which is different than the Penobscots and the Passamaquoddies.
Right.
So I think I would ask if you could potentially speak to your familiarity of the ICWA federal law, Indian Child Welfare Act of 1978, and whether you have any experience with that federal law and how you would approach that within this position. Thank you.
Yes. Yeah. When I was working for when I was doing child protection work, when I started, nobody paid attention to it. But after I started, then it became an issue, and we addressed it frequently. There were a lot of Native American children who were coming into care for different reasons, and so we had ICWA, and actually I found it helpful. One of the things that it did was to make at the point I was doing it, there wasn't really a tribe, so it would be family members who would be coming in and being more responsive and having to take the children, and it seemed to really increase the ability of them to do that, and it increased the ability of the state to allow that to happen, I believe. So we, let's see, I stopped, I can't remember when I stopped doing child protection work, but the Indian Child Welfare Act all along the way would make a big difference in how we did things.
Thank you, Representative. Representative Evangelos.
Thank you, Mr. Chair, and welcome, Ms. Lipcomb. I just wanted to follow up on your description of the Native Americans up there in Aroostook. The way you describe them, do you think the state of Maine's refusal to recognize their federal inherent sovereignty may have contributed to the way you described their tribal organization status?
I don't know to what extent they've been involved in that. I know to what extent I've dealt with people in the tribe, but to the extent that they've dealt with the government, I don't know.
Well, we are involved in a highly important issue regarding the federally recognized sovereignty of our tribal nations in Maine, and that includes the Maliseet. The Micmac are involved at a different level, but are you familiar with the problems that came as a result of the 1980 Indian Land Claim Settlement Act?
Some of the problems, but not many. What specifically?
Well, what I'm driving at is if your description of the native nations up in that locale, you indicated that they weren't organized entities to an extent. So my question is surrounding the issue of Maine's refusal. Unlike the other 49 states in the nation, Maine has refused to recognize the tribal nations' inherent federal sovereignty. We have denied them that, and we are in the process of trying to change that. If you're contending that they lacked cohesion as a tribal government entity, which I'm not sure I agree with, do you think Maine's failure to cooperate in recognizing their sovereignty would have contributed to that?
I guess I think what I meant to say was that when we started, when I started doing child protection work, they were not organized at all. They have become more organized, and it's a matter of them learning, like any new government, about organization and how to get through with organization. So while in the beginning, there was a lot of disorganization, now there isn't so much, and they have the Micmac Health Center, which helps the kids a lot. They have the Micmac preschool. They do support each other much more than they did before. So that part's good. And how they, whether they're not being accepted by the government, I don't know how that affects their ability to unite and work together.
Well, both the tribal nations in Aroostook have formal elected governments.
Yes, right.
And they have a democratic process for electing those people.
Right.
Yeah.
Yes.
So they're doing the same things the white folks are doing in Maine, aren't they?
They are.
Thank you.
Thank you, Representative. Are there additional questions from committee members? Representative Babbage.
Thank you, Mr. Chair. Ms. Linthicum, before I let you go, I was pleased to see you were a history major and undergraduate. And I wondered, when you were in Carlisle, what is the status of what was the Indian School? It's part of the War College now, is that right? I mean, did you ever get a chance to visit, or is that a museum? Or I wondered what the status.
I think that is a museum now, but I can't tell you for sure.
Okay.
We went there once when I was in one of my classes because we were there and we learned, all about it, but we did go.
Okay, thank you so much, and congratulations on your nomination.
Thank you.
Thank you, Representative Babbage. Are there additional questions from committee members? Seeing none, I do have just a couple questions, Ms. Linthicum.
Sure.
And thank you for being here, and thank you for sharing so much about your personal story and history in Maine and Aroostook County. Having been in the district attorney's office for so many years, do you have a view on the state of representation of indigent legal defendants in criminal matters and also in termination of parental rights cases?
Well, my view is that they should be represented, but, is there something more specific?
I'm just wondering what you think about the state of their representation in Aroostook County, the services being provided to them, both as criminal defendants and also in termination of parental rights cases.
We have a small bar in Aroostook County. And I would say, without exception, every member of the defense bar does their best to represent their clients as best they can. This is part of it's hampered by the fact that there are very few defense attorneys in Aroostook County and many courts. So the defense attorneys are having to go from, I know sometimes they'll have a case in Fort Kent and on the same day they have to go to Holton for another case. That you can't do a good job when you have to run around like that all of the time, and yet they are holding it together and doing a really good job all of the time. And they also, because of the small bar, there will be a lot of conflicts. So when you have a family, like especially an extended family in a child protection case, where you have a mother and maybe several fathers and grandparents involved, everybody gets representation. We don't have enough people, defense attorneys in Aroostook County, to do that. And so we end up having to get people from other places to come up. And when they come up, then that adds more really stress on the whole situation, because we have to wait till they're available. Things get continued all of the time. That's where I see the problem, not in the defense attorneys themselves, because they do a great job with what they have. But just the situation, the setup is difficult.
Do you think it would benefit from a more structured response, perhaps a public defender type of operation?
It might, if it had I looked over the the Sixth Amendment report. Yeah, I looked over the Sixth Amendment report. And one of the things that it talked about was not allowing attorneys to have other attorneys stand in for them on a matter of that's really, you just need a warm body to show up. And they recommended against that. Well, in Aroostook County, you can't do that. If you're an attorney representing somebody in a child protection case in Fort Kent, and you have to go to, say, Presque Isle or Holton, you can't do both things, especially if the thing in Presque Isle and Holton just requires somebody to stand up and say, this is continued, or we've talked and there's no agreement. If there was a defense, a public defender's office, then it's easier to have people from that office covering different places. And so the idea that was presented in that report of perhaps some sort of a hybrid where you have people, a public defense and some private defense to help, that seemed like at least a good thing to start talking about to give everybody a chance. And then the other thing that happens is you have, when you're having to go here and there, when you have to make these long trips, the attorney can't do any work in the car. I mean, you can't even use the phone in the car. You just are mostly driving. So you don't, you can't get work done during your 40 hours, and you have to just keep working. And you get tired. So there seems to be, I think that probably a hybrid is not a bad idea.
Thank you very much. Representative Moriarty.
Thank you, Mr. Chair. Ms. Linthicum, I just want to follow up on the chair's questions, because we spent a lot of time and energy this session dealing with indigent legal services. And I fully appreciate your comment regarding the scarcity of attorneys in the county to provide that essential service. But I'm just curious, because we've also heard comment as we've dealt with this issue about the quality of those who serve as indigent counsel on a statewide basis. Based on your experience in Aroostook, as you transition from prosecution to the bench, do you have concerns or reservations about the quality of the representation that currently is and would be, at least for the short term, provided to indigent criminal defendants?
No, like I said before, the attorneys I have worked with here, and I've worked with all of them, all do a good job, all work really hard for their clients. I know that there are complaints made about the defense attorneys not going to the jail to visit their clients all of the time. And I've also heard from defense attorneys about how difficult it can be to go to the jail. There's a limited time. I mean, the jail has to be the jail. So there's a limited time when the defense attorneys can go there. There's a limited time that they have to talk. Sometimes when they go to talk to their clients, when other inmates see a person talking to their defense attorney, they become suspicious of the defendant, like that defendant is somehow involved in talking about other things or making deals or something. So that whole thing is very difficult, but yet the attorneys are still striving to do their best to go and represent the client. Also, there are just a lot of times if a defendant is not in jail, the defendant is not always particularly inclined to follow through with the defense attorney until they actually have to. It's just what happens. And so the defense attorney sometimes will come to court not having spoken to their client until the day that they came to court, like for a conference, a dispositional conference. More often that is because the defense attorney has been unable to reach the client, and then that the defense attorney is simply not prepared. On occasion, you'll have a defense attorney who has so many other things going on that he or she has to continue a case or move it along, and that's understandable. But when you have too many of those cases, then the system has to work, I think, to change it somehow, make it better.
Okay, thank you.
Thank you. And Representative Babich, additional question?
Mr. Chair. Ms. Linthicum, in listening to judges testify about concerns, relating what comes before them, substance abuse, broken down familial relationships, domestic abuse, and so forth. A lot of this applies to women particularly, but I think a common thread of a problem has been the lack of a place to go. Especially in rural areas is what I'm talking about. I know the northern county, north central counties of Maine, and of course, you're from Aroostook. I wanted to know if that has changed during your career, and is that still a major concern, housing, as far as that aspect?
During my career, there have been different projects that have established safe homes for people who need safe homes, and they have continued to do that. And there are more now than there were. When given the opportunity to go to a safe home, there will be one available. That's been my understanding if a person wants it.
Good. Thank you.
Thank you, Representative, and thank you for your responses, Ms. Linthicum. One last check through the committee. Are there additional questions from committee members? Seeing none, again, thank you very much for your time and responses to all of the questions from various members. Thank you. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk or online prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to a panelist status in Zoom and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence before delivering your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from members of the committee, you will be returned to attendee status and the next person will be called upon to testify. At this point, I will ask persons in the attendee room who wish to speak in support of the nomination to please raise your electronic hand and keep it up so that the committee clerk can move you over and promote you to panelist status. And the first person I see testifying in support of the nomination is Lori Boxer-McCumber. Welcome back to the Judiciary Committee. Ms. Boxer-McCumber, please begin your testimony as soon as you're comfortable.
Yes, thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Lori Boxer-McCumber. I'm from Portland, Maine, and I am here testifying on behalf of the Maine Trial Lawyers Association today. On behalf of the association, we are pleased to recommend that you support the nomination of Carrie Linthicum for the Maine District Court. Before I begin my testimony about the proposed candidate, I thought I would point out the MTLA's procedures for coming up with their recommendations. We generally survey our membership and give our membership as much time as possible to let us know how they feel about the candidate's traits, their temperament, skill, and ethics. And then we review those results with our board when possible, or our executive committee. And in this case, it was with our entire board. And we make our recommendation. In this case, our survey showed that people universally ranked the nominee highly for her experience, temperament, skill, and judicial demeanor. One respondent said that he or she, we didn't know which, how they identified, but they said that they cannot say enough good about her personality, command of the courtroom, fairness and compassion, and overall great impression as a citizen of the world. Another respondent also noted that she was consistently fair and open to listening and carefully considering the mitigating and aggravating factors about any case that she worked on with her. And we also make note of some of the things that you've heard before, that she had 36 years of public service with the Aroostook County District Attorney's Office, 6 years of private practice, and has received awards from, among others, the Department of Inland Fisheries and Wildlife. So based on this evaluation that we conducted of her, we highly recommend that you support her candidacy, and I thank you for your time today.
Thank you very much, Ms. Boxer-McCumber. Are there questions from committee members for Ms. Boxer-McCumber? Seeing none, again, we thank you for your time and your input today. We greatly appreciate it.
Thank you.
Going back to the attendee room, I will ask if there are any other persons who wish to speak in support of the nomination. Seeing none, I will ask if there are any persons in the attendee room who would like to speak in opposition to the nomination. If so, please raise your electronic hand and keep it up so we can move you over as a panelist. And seeing none, I will move to the next portion of today's hearing. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. Are there any such documents, Committee Clerk Burnett?
No, Mr. Chair, there are none.
Thank you very much. We will then vote on the nomination and notify the President of the Senate pursuant to Title III MRSA, Section 157, and the joint rules. This vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. With that, the hearing by the Joint Standing Committee on Judiciary for Ms. Carrie L. Linthicum, Esquire of Castle Hill, for appointment as a district court judge is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. Therefore, at this time, I will ask whether any member present objects to proceeding to take the vote immediately. If so, please raise your electronic hand. Seeing that, I'm just going to check that I have everybody in front of me. Seeing that there is no objection, the pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of Ms. Carrie L. Linthicum, Esquire of Castle Hill, for appointment as a district court judge be confirmed. In accordance with 3 MRSA, Chapter 6, Section 157, and the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the nomination, the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 11 members voting in the affirmative, 1 member in the negative, and 2 are absent.
Thank you very much, Committee Clerk Panett. 11 members of the committee having voted in the affirmative and 1 in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of Ms. Carrie L. Linthicum, Esquire of Castle Hill for appointment as a district court judge be confirmed. Congratulations, Ms. Linthicum. In more normal times, we would all be in a room together celebrating this achievement with you by coming around and introducing ourselves and shaking your hand and offering our congratulations. Unfortunately, we all know we're not in normal times. So what we have sort of resorted to is giving you our virtual round of applause and our heartfelt congratulations for the work that you're taking on for the people of the state of Maine.
Thank you so much. Thank you.
And congratulations, and the world's shortest retirement is coming to a close.
It was fun. Thank you.
With that, that concludes the confirmation or the nomination hearing for our district court position. We do have a second nomination hearing at 2 o'clock with Justice Mead. And I will turn to my Senate co-chair, who might have been texting me during this, and I haven't had a chance to see them, to see how you would like to proceed with our next 50 minutes.
Thank you. I haven't been texting you, but I do think we should perhaps take a short recess, say till 1:15, and then check in with our clerk and analyst to see if there's any work that we can do in the interim.
Okay, I will do that. And did you say, there was somebody else texting, did you say 15 minutes? I'm sorry. What did you say?
I think maybe just a 5-minute break while we check in, and then perhaps we'll come back and tell everybody that there's nothing to do between now and 2.
Okay. I will look into that over the next 5 minutes, and for others, just shut off your video and mic, and we'll see you at about 1:15.
Okay.
And again, congratulations, Ms. Linthicum.
Thank you. Thank you very much.
Good job.
Okay, committee members, when you return, if you could activate your video cameras so I know that you are back and I can let folks know how we are going to proceed. Thank you, representatives. We could get more folks online. Well, I'll tell you what, we do not have work that we can accomplish between now and 2 o'clock. So I will let folks, you don't have to sit around to wait for other people to come for me to tell them that as well. So we will pick up again with our next nomination at 2 o'clock. I will stay online again in the event that somebody comes back after you guys all shut off your cameras again, but you can all come back at 2 and I'll wait here to let others know and see you
Okay.
at 2 o'clock.
Thanks, Tom.
Thank you, Tom.
Yep. And Soupy, if you can hear me, if you could just change the return time to 2 o'clock in your square, so others will see that when they return. Sorry about that. Committee members, we will return at 2 and I will update the screen or have it updated so all are aware. We will begin our confirmation hearing on Justice Meade at that time. Thank you. I made the mistake of walking outside. I should not have done that.
Yeah, on a day like today, that's a mistake. Very tempting.
The notion to just keep on walking.
Now, there are those temptations.
Well, they put us on a short leash, so they know what they're doing. Oh boy. Welcome back, committee members. We still have a couple minutes to go, but as you get back, if you could activate your video so I know that you are here. Welcome, Justice Mead. I see your name somewhere. I don't see your face yet.
How's that?
That's your face. That's good.
Good afternoon.
Good afternoon. How are you today? Just waiting for committee members to get back. We'll start right up at 2 o'clock.
You've had some busy days recently and for the future.
Yes.
We have indeed. The overtime pay is really kicking in. It's been quite remarkable.
Justice Mead won't be able to say hi during the hearing, so I just wanted to say hi.
Hey, John, how you doing?
Doing well, doing well.
Long time no see.
That's right. Well, these are good circumstances to see each other.
Yep, this is fine. This is good.
Going to give it another minute or two. It's not even 2 o'clock yet. Again, committee members, if you could activate your videos so I know that you're back when you return. Okay, we have most of our members returning. I hope you all enjoyed our short respite. We will now turn to our second confirmation hearing, and I'll begin the proceedings. Welcome back, everyone. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Andrew Mead of Bangor for reappointment as an Associate Justice of the Maine Supreme Judicial Court. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor's representatives, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and will be available on the committee's YouTube channel at the end of our proceedings for the day. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee. Chair recognizes Representative Steve Moriarty for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Andrew Mead of Bangor for reappointment as an Associate Justice of the Maine Supreme Judicial Court.
Thank you, Representative Moriarty, and I now recognize Representative Babbage.
Mr. Chair, I second the nomination of the Honorable Andrew M. Mead.
Thank you, Representative Babbage. We have a motion and a second. For those folks listening, a copy of the statutory requirements for this position is available online and has been distributed to all committee members and was part of the public notice. At this point, I now recognize Jerry Reed, the Governor's Counsel, for the purpose of making a statement concerning this nomination. Mr. Reed,
Good afternoon. Good afternoon, Representative Harnett and members of the committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and it's my pleasure to be here this afternoon to present the Honorable Andrew M. Mead as the Governor's nominee for reappointment as Associate Justice of the Maine Supreme Judicial Court. Justice Mead is a pillar of the Maine judiciary. He has had a long and distinguished career that is remarkable for both breadth of experience and commitment to public service. Few can match his record of leadership as both a judge and a lawyer, and particularly his devotion to the cause of access to justice for underserved populations. He began his career in private practice in Bangor. During that same period, beginning in 1979, Justice Mead served as the first Chief Judge of the Penobscot Tribal Court, a position he held until 1990. In that capacity, he authored all of the procedures and forms utilized in the tribal court and was instrumental in the court's establishment as a well-functioning institution. In 1990, he was appointed to the Maine District Court, where he served for 2 years before being elevated to the Superior Court, where he served for 15 years until 2007. Between 1999 and 2001, Justice Mead was the Chief Justice of the Maine Superior Court. In 2007, Governor Baldacci appointed him to be an Associate Justice of the Maine Supreme Court, where he has ably served for 14 years, including as the court's acting Chief Justice since 2020. As acting Chief Justice, he effectively led the judicial branch through the unprecedented challenges of the COVID-19 pandemic, while also overseeing the court system's critically important transition to an electronic filing system. His work as an appellate judge has been characterized by fair, thoughtful, thorough, and well-reasoned decision-making. And Justice Mead has a record of advocacy for equal access to justice for all people, and particularly, as I noted, underserved populations. In recognition of these efforts, in 2020, the Volunteer Lawyers Project established the Andrew M. Mead Fellowship for pro bono legal services, a tremendous honor that reflects the Maine Bar's appreciation for his tireless work in this area. Justice Mead holds a degree in psychology from the University of Maine at Orono and is a graduate of the New York Law School. Justice Mead has published numerous scholarly articles and held numerous leadership positions within both the bench and the bar, including as president of the Maine Bar Association, the director of the Maine Bar Foundation, and chair of the Maine Justice Action Group. His reappointment to a third term is richly deserved. It's my pleasure to recommend him on behalf of Governor Mills for reappointment to a third term as Associate Justice of the Maine Supreme Judicial Court. I'd be happy to answer any questions that the committee may have of me.
Thank you very much, Mr. Reed, for presenting the governor's nomination. Are there questions from committee members for the Governor's Council? Seeing none, again, thank you very much for bringing this nomination forward. I will now turn to and welcome back to the Judiciary Committee, John Hobson, who serves as chair of the Judicial Selection Committee, Mr. Hobson. Welcome back.
Thank you very much. Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am Chair of Governor Mills' Judicial Selection Committee. On behalf of the committee, I request that this committee act favorably on the nomination of the Maine Supreme Court of Justice Meade. Justice Meade, as Mr. Reed has cataloged already, has a long career in the Maine judicial branch. He is known, since he's been on the law court, to be a consistent and thoughtful voice on that appellate court. And he is someone who is and I think Mr. Reed put it correctly, a pillar in the Maine judicial system. A couple of aspects of Justice Meade's career stand out. One is, as Mr. Reed pointed out, his commitment to access to justice issues. I mean, you don't get a award named for you simply because you sit in the judiciary. You do it is only accorded that honor. Someone's only accorded their honor if they've done the hard work, and often, candidly, the thankless work related to those issues. And Justice Meade has done that work. In addition, Justice Meade brings to the position, and not that every judge shouldn't have these skills, but I'm not sure every judge does. He has kind of, and maybe it's his degree from his undergraduate degree that brings it, but his ability to basically bring people together, his ability to be collegial and still disagree. Something, candidly, that's a skill that perhaps society as a whole could benefit from. He is, although a important presence on the law court, he is somebody who basically makes his views known and exerts his influence not through a raised voice, but by his presence and by how he treats others. He is another hallmark of his career, which the bar is very appreciative of, is Justice Meade's involvement in bench bar activities throughout his entire career, not just on the Maine Supreme Court. Justice Meade has been one of the go-to individuals in the judicial branch in terms of getting cooperation with bench bar activities, input related to trial bar issues, anything involving the trial bar or the bar at large, and also the public at large, given his access to justice issue. You put all those factors together, and the fact that he was able to steer the judicial branch through what is hopefully the worst days of the pandemic, and we've come out the other side, which is no mean feat. So with all those qualifications in mind, the committee highly endorses the renomination of Justice Meade to the Maine Supreme Court, the Maine Supreme Judicial Court. The citizens of the state of Maine will be well served if this committee will act favorably on that. Thank you. I'm happy to answer any questions.
Thank you very much, Mr. Hobson, and thank you again for your public service in serving as the chair of the Judicial Selection Committee for, these many years. Greatly appreciate that. Are there questions from committee members for Mr. Hobson? Seeing none, again, thank you very much for your time and testimony today. It's now my privilege to recognize the Honorable Andrew Meade for the purpose of making a statement concerning this nomination. Welcome back to the Judiciary Committee, sir. Please proceed when you feel comfortable.
Thank you, Representative Harnett and Senator Carney, and distinguished members of the Joint Standing Committee on the Judiciary and members of the historic 130th Legislature. Good afternoon. It is once again a great pleasure and a great honor to be before you as this my 7th judicial confirmation hearing, in this instance having been renominated as an Associate Justice of the Maine Supreme Judicial Court. I'm accompanied here today by my best friend and wife of 43 years, Kelly. She's an Auburn native and has just retired after a distinguished 43-year career as a teacher and educator. Seems like every time we're out, we run into one or more of her former students, and it's obvious that there's still a strong connection between them even after all these years. It's hard to imagine that 31 years have passed since my initial appointment as a judge of the Maine District Court, I distinctly recall that sense of wonder and responsibility I felt at that confirmation hearing, and also at every one of the 5 confirmation hearings that followed, and certainly today. Prior to my 31 years on the state court bench, as you may have heard, I served 10 years as the first chief judge of the Penobscot Tribal Court. So I actually have a total of 41 years in the judiciary. I'll mention that my time at the Penobscot Tribal Court really, truly was life-changing. I'd be happy to speak further about that if you wish. I did participate in the Wabanaki State Child Welfare Truth and Reconciliation Commission study a few years back. I gave 20 pages of testimony as part of that landmark and deeply moving project. I've served as Chief Justice of the Superior Court, and as you know, most recently as the Acting Chief Justice of the Maine Supreme Judicial Court. I believe you have my resume and the materials that were provided to you, so I won't belabor the items referenced there, but I would certainly welcome the opportunity to elaborate on any of those items if you wish. I've known many of you for quite a while, and others I met for the first time at the orientation session earlier this year. I'd like to take a moment just to share some personal biographical information with you. I spent some of my very young years living in Rumford with my maternal grandparents. I still enjoy taking a spin through the old neighborhood whenever I'm in the area. I spent my formative years in New Jersey, but we always summered in Maine, typically camping at Dummers Beach in Weld. I have many fond memories. I attended the University of Maine, class of 73, where I met Kelly, and New York Law School, class of 76, where I received the school's National Moot Court Team Award. Kelly and I were married in Bangor in 1978 and have been here ever since. We are blessed with 2 wonderful children. Our daughter is a college professor. She is currently teaching at the Emirates College for Advanced Education in Abu Dhabi. She's a professor in the Counseling, Special Education, and Neuroscience Division with a specialization in applied behavioral analysis, which is a science-based approach for working with individuals with developmental disabilities or autism. Our son is a chief operating officer in a media company based in Lake Tahoe, California, but he's able to work for the most part from Portland. He and his wife, Anna, who is a nurse practitioner, welcomed our first and so far only granddaughter, the wonderful, amazing Madeline, in September 2020. Recreationally, I love basically anything in the outdoors: hiking, biking, paddling, camping. As a Boy Scout and ultimately as an Eagle Scout, I was always deeply grateful for the people who contributed their time to teach and guide us. I always felt that I would someday be a Scout leader as sort of a pay it forward for the time that was invested in me by those individuals. However, our children didn't take to Scouting, but they're both very invested at the local Y Young Leaders program at Camp Jordan. The director there recruited me to set up a wilderness immersion program where the participants who had completed the preliminary programs would live out in the woods self-sufficiently for a week under the guidance of 2 college-age counselors. I taught courses like backwoods navigation, backwoods first aid. I was a certified wilderness first responder at one point, rustic shelter construction, and wilderness survival techniques. I also enjoy music, listening, and making it. I play hockey once or twice a week, year-round. Additionally, I do look forward to speaking about the law and the courts whenever invited, and I have spoken at local schools, college classes, and at the senior college. On the professional side, as a lawyer, my 14 years of practice with 2 firms focused on litigation. I represented defendants in criminal matters, both retained and court-appointed, on matters ranging from disorderly conduct to murder. On the civil side, I represented both plaintiffs and defendants, in many instances on a pro bono basis. As a Superior Court Justice, I was one of the first judges to preside at the newly formulated Adult Drug Treatment Court. That experience provided me with a unique view into the challenges and the complexity of recovery from addiction and the need for support and structure in making that difficult journey. As a judge, my particular passions have been jury management and access to justice. I've served as the chair of the Maine Justice Action Group, JAG, for the last 7 years. JAG's core missions are to advocate for funding for civil legal services and to strive for civil representation for Maine's underserved populations. Until recently, I served as the SJC liaison to our JB Access team, the dedicated and committed judicial branch employees who administer the Americans with Disabilities Act and provide language access resources. They have created, and the SJC has adopted, a comprehensive language access plan, a copy of which I'm happy to provide if you are interested. Our access team has also produced an exceptional ability for the courts to provide language access for Maine's people with limited English proficiency, as well as the deaf and the hard of hearing. Again, if you are interested, I would be more than happy to provide you with a copy of our annual LEP report. It has been such a privilege to work with this very special group. If you have any questions about my biographical facts or professional experiences, again, I'd welcome the opportunity to elaborate or expand on what I have said or presented. This pandemic took us all by surprise. For Kelly and me, we were in Guatemala in early March 2020 on a mission type trip with university students when the magnitude of the virus really became obvious. We returned to Maine late in the evening on Sunday, March 15. An emergency meeting of court leadership was called for early the next morning on March 16. And our world, as we knew it, was immediately turned upside down. Chief Justice Softly had previously committed to accept the dean position at the law school, and I, as the senior associate justice, as a matter of law, was then to exercise the prerogatives of and undertake the duties of the Chief Justice in the absence of a duly appointed Chief Justice. The 14 months preceding this hearing have been exhausting, but exhilarating, and challenging, but rewarding. And I am immensely proud of what we've accomplished during this time. We kept the doors of justice open to the maximum degree possible while keeping the public and our people safe. I spent countless hours along with the trial court chiefs, the SJC, Ted Glessner, our state court administrator, and my indispensable colleague, Justice Ellen Gorman, as we struggled to innovate and recreate how we do almost all of what it is we do. Now the siege seems to be abating. We're taking a look at our COVID era practices to see what should be maintained and what should be discontinued as we move forward affirmatively to address the backlogs. That is the next step in the course that we have charted. In addition to the materials I've provided in my remarks here, I've also asked some extremely accomplished and extremely humble people to make some comments on my behalf a bit later in these proceedings when invited by the chair. But because they are exceptionally humble, I suspect that their self-introductions will not convey the magnitude of their accomplishments. While I certainly cannot fully do justice to their accomplishments, I offer these utterly inadequate comments on their backgrounds by way of introduction. Lee Ingalls Softly. If there ever was a person for whom the introduction is needing no introduction, it has to be Lee Softly. During her exceptional 30-year judicial career culminating in an inspired tenure as Chief Justice, she introduced one innovation after another, attempting to itemize them all would take all afternoon. Chief Justice Softly is now Dean Softly, where she continues to innovate and boldly move things forward at the University of Maine School of Law, one of Maine's cherished institutions. Paul Chaikin is a revered senior member of the legal community in Eastern Maine. He has served as a deputy district attorney and was a senior partner at the Bangor law firm of Rudman and Winchell. He is one of 3 delegates to the prestigious Uniform Law Commission. He occupies a seat previously held by attorney Louis Vafiatis. He was instrumental in the massive reworking of the Maine bar rules. He received the Judicial Branch's Advocate for Justice Award in 2007. He is held in the highest regard by his colleagues in the legal profession. Nan Heald. I can only introduce her as the legendary Nan Heald. She is the long-serving executive director of Pine Tree Legal Assistance, Maine's premier and nationally recognized civil legal services organization. She has received basically every state and national recognition award from the Access to Justice to Community, and she continues to guide and inspire legal services attorneys to this day as they provide civil legal services to Maine's underserved populations. Mark Woodward is, among other things, the former editor of the Bangor Daily News. As a longtime journalist and editorial page editor, he influenced and informed innumerable public policy issues. Now retired from the newspaper, Mark continues volunteer work for the greater Bangor community, which has included chairing numerous boards for economic development and healthcare, the Children's Museum, and the Bangor Public Library. I just want to express my deep gratitude to these accomplished individuals for their willingness to speak on my behalf today. Before concluding, I would like to briefly share some of my thoughts on judging and the courts and the role of law in society. Bottom line, the courts exist to serve the people, not to dominate them. The enormous power that is wielded by the courts must be exercised as a means to an end, which is the good of all. It must be used to improve lives, not to make them more difficult. And the role of a judge is central to it all. And a few words about that. I can't stand to watch TV and movie courtroom dramas. I just can't. In addition to presenting a completely unrealistic view of how courts actually work, the judge is almost universally depicted as arrogant, condescending, insensitive, biased, abrupt, dismissive, stuffy, and just downright crabby and rude. In other words, all the things a judge must not be. I view the courtroom proceedings as ceremony. Everyone, particularly the judge, must treat all others with dignity and respect. As a judge, I must listen and truly hear what the parties are saying. And the parties must understand and appreciate that I did listen and I did hear them. The courts are places where people come for peaceful resolutions of human conflict. They rely on us to make the right decisions. We serve the people of Maine. We preserve and sustain the rule of law. We take a sacred oath. We must give nothing less than our best. I thank Governor Mills for her renomination of me. I thank the committee for your time and consideration of my nomination. If confirmed, I will again dedicate myself to the highest ideals of the bench and look forward to serving the people of the state of Maine. It will be my pleasure to address any questions or comments at the invitation of the chair. Thank you for the opportunity to make these comments.
Thank you very much, Justice Mead, for your well thought out comments this afternoon. Before turning it over to the committee for questions, I have one. You served as the first chief judge of the Penobscot Tribal Court. I'm curious as to how and if that influenced you as an attorney in private practice and then subsequently as a judge in all levels of Maine State, the Maine State judicial system.
It did. It was instrumental in my development. I was 28 years old when I took over that helm. There was nothing there, as you may recall. It was a very difficult and contentious time. The land claims were proceeding. The Land Claims Settlement Act was being negotiated. And at some point, the law court handed down a decision that said that the state has no business in Indian affairs. Prior to that, there had been a Department of Indian Affairs. At that point, the state abruptly pulled back. There was no law and order at the tribal properties. They recruited a judge to create the court. And at 28, we invented it from whole cloth and jumped right into it. I'll just one side story here. Early on in the process, they were trying to ratify the Land Claims Settlement Act. As you may recall, it was a house of cards, but Tom Tureen had put together a very complex configuration that involved the federal government, the state government, and the tribe itself, and sort of pulled things together. The tribe was not speaking with one voice, and someone got the idea to file a motion for a preliminary injunction to stop the vote and filed it in the tribal court. So one steamy evening, lawyers from Boston and New York and DC gathered on Indian Island to a packed crowd. And I was down front at a card table with a very large gavel, and we proceeded to conduct the hearing on the motion. After the hearing, I did deny it because the notice issue was not made out and the likelihood of success was not demonstrated. But I do remember the way Tom Tureen slammed his briefcase closed and stormed out of the room. So it immediately brought home to me the enormous power and consequences of the exercise of that power that judges hold. The other side of that was my own personal development, which was spending 10 years among the Penobscots. And I grew up in a suburban town in New Jersey that I thought was a community, but I didn't really understand what a community was until I spent my time on Indian Island. It changed how I felt about things. I actually wrote an article about my experience back in the 80s called The View from a Different Kind of Bench. But I gave you a very long-winded answer that my time as the first chief judge affected how I perceived the role of a judge and the role of a person as part of a community.
Thank you very much, Justice Mead. I appreciate that. And now turn to committee members. Are there any questions from committee members? I'll begin with Representative Evangelos.
Thank you, Mr. Chair, and good afternoon, Justice Mead.
Good afternoon.
Everything that Jerry Reed said in reference to his introduction was absolutely true. And
thank you.
You've been a man of integrity, and I thought our discussions this year were growing, and appreciated the understanding that you had regarding certain deficiencies and reforms that might be necessary in our criminal justice system. You also showed remarkable leadership during one of the most difficult periods in our court system's history. So, and you don't have to answer this one if you don't want to, but did you want to
fire away?
Did you want to continue as our Chief Justice?
That it's you and I've spoken about separation of powers before, and the prerogative for nominating judicial positions is exclusively that of the executive. So, end of conversation. So I'll just leave it at that. Okay.
Thank you for that, and you just bring such depth and great resources, and you just demonstrated to Representative Harnett your depth of understanding of an issue that's still facing us today regarding the Native American sovereignty issue. So I can't overstate that. I only had one other question, and I'm not going to elaborate on it. But I was reading a case out of New Hampshire that has nothing to do with anything you ever did, but it was a deadly force case, and the Attorney General flipped the ruling from justified to unjustified based on subsequent conduct of the officer involved. So the conduct came afterwards because it raised questions about his credibility. So the question I have was, and I don't even remember the name, but in relation to Mark Westrom, did you have any concerns regarding the subsequent problems he was having after he was serving as a police officer, which would have raised reasonable questions regarding his credibility?
I can't talk to specific cases that have either been presented or are likely to present down the road. But your question, generically speaking, is if a public safety officer is a party to a case and the case is completed, I think this is your question, and the case is completed, can subsequent acts understood to have occurred afterwards that might have cast light on the original event itself, but couldn't because they hadn't come to light at that point, to what degree does that play a role? So if we're talking about a case that has gone to conclusion, gone to, we'll say, conviction, As you know, our post-convict, well, of course, there would be nothing on direct appeal. It wouldn't be part of the case itself, but the avenue for reviewing those after-the-fact events fall under our post-conviction review statutes. And again, you and I have had a conversation about that. They are tightly woven, unquestionably, and whether they should be expanded or not are public policy issues that I cannot comment on. But in the instance that you served up here hypothetically, it would appear that the door would be closed to retroactively, under our post-conviction review statute, to retroactively reopen it at that point. And beyond that, I really can't say because it would require comment on written decisions and possible cases that may come down the pike.
Sure. Just to be clear, I wasn't suggesting that any of the subsequent conduct had anything to do with the original incident.
Oh, I see. Okay.
It would have been that in this New Hampshire case, it just said that it raised concerns about the police officer's credibility because later on the police officer was doing dishonest things, got caught, and had some problems. And so the AG came forward and said, I no longer can trust the stuff he's done in the past. So in relation to this particular officer, I was just wondering, so that is something that a post-conviction review attorney should have raised within the time limit available?
No, I can't say that for certain. It sounds, it's not clear from your example whether this is a Giglio situation or whether it's something that would have been admissible at the actual trial itself to undercut his credibility, whether it be admissible as a prior bad act to address admissibility. But I think there are too many uncertainties about the hypothetical that I can't give you a definitive yes or no answer.
Yeah, well, it didn't happen at the time of the trial. It was just like New Hampshire. The stuff happened later, you know. And I'm not going down the rabbit hole on this, but it was the Dennis DeShane case, and one of the key officers was Mark Westrom, who had interviewed DeShane, and he's had some pretty serious issues since then that would raise my concern about his credibility. But that would have been something the post-conviction attorney should have raised at the appropriate time then, right? They had a chance.
Because DeShane is a case that has several decisions, including post-conviction, including one of which I authored, I can't comment on that.
Okay.
I'm sorry.
I was just comparing it to what the AG did. Different circumstances, because the attorney general in that case had authority to make that decision, and you're a justice, it's a little different. And I understand. I just did want to get on the record that that officer would have some, under that standard, he would have some serious credibility. Thank you for your service. I'm definitely voting for you, and I won't say any more, but I wish, I'm going to miss your continuing visits to our committee. I thought they were productive.
And thank you, Representative. I've also enjoyed our exchanges.
Thank you, Representative. Representative Babbage.
Thank you, Mr. Chair, and welcome Justice Mead. And it's a great opportunity whenever we get to meet with you like this and on this happy occasion. I very much and always do appreciate your eloquent and wise words, and appreciate especially your leadership during this difficult time. I did want to ask about something that you know more. No matter how much study I may attempt, I will never have the appreciation for tribal life and all of that you have experienced in your young life, particularly. But as you know, also as a member of the judiciary, you know, as we push forward in our path to expand autonomy and create parallel rights and procedures in the tribal court, I wondered if you have anything to share with us that would be cautionary or encouraging, or just recommendations as we go down this road that of that expansion and autonomy?
Sure. I can't go too far down that road because I know there's legislation pending, but I'll just say historically, my experience, after the Land Claims Settlement Act was ratified by all parties, the tribal court started with a very limited jurisdiction, just Class E of misdemeanors and internal tribal matters. And as the court gained credibility over the years, the legislature acted to supplement that jurisdiction, to expand it as things went on. After the Land Claims Settlement Act was enacted, it has been invoked as a pushback to further progress in certain settings and situations. But I think our experience at the tribal court showed that, no, there is some wiggle room there, that the sovereignty, the exercise of jurisdiction was revisited, at least in the context of the tribal court. So there is some historical basis for that, and that the Settlement Act itself is not an impenetrable iron curtain that prevents anyone ever looking at the issues again. And that is as far as I can go on that particular topic.
I appreciate that, and once again, I can't beat pillar. Once I heard that word, I think I said, well, that's well deserved, but wow, that's really how I think we on this committee respect you and your contributions, especially to us in this past year. So
maybe they meant I just look like a cylinder of marble that doesn't move. But, it all depends on the interpretation.
Thank you, Representative. Representative Moriarty.
Thank you, Mr. Chair. Justice Mead, I want to begin with a not very serious recommendation, and then I have a serious question. You and I are contemporaries, and I'm sure that you have the same memories of a particular event that I do. But given your comment about the portrayal of judges in the movies, I recommend that you don't watch the trial of the Chicago 7.
All right, I have not seen it yet.
Okay,
don't recommend it.
I liked it, but if you're sensitive to courtroom portrayals of our judicial leaders, you better not watch it.
I remember it well. I mean, I remember the pictures on the front page of the New York Times with bound and gagged defendants.
Sure.
And Judge, what was the judge's name?
Julius Hoffman.
Julius Hoffman, yes, entered into the lexicon of legal terminology and memorable moments. All right, I will not watch it then on your recommendation. Thank you.
All right then. Are you now, or will you be, the senior associate justice?
Yes.
So in that capacity, as you go forward into the next 7 years of your career, and given your background over the past 15 or 16 months and the impact of the pandemic upon the system, what will your recommendation or advice be regarding delegation of responsibility for the restoration of the system, given the backlog of cases and, of course, the current inflow of cases, and getting things back on track?
Sure. Yeah, as the senior associate justice is not a deputy chief justice. It's written into statute, and really only kicks into force if there is no currently duly appointed chief justice. But I do have the experience of having been at the helm during this time. I watched the problems accrue, and I've, with this committee and anyone else who will listen, have run the numbers by. So I'm hoping that the incoming chief justice will leverage some of that experience. She and I have already met, by the way, to talk about pending issues. So if she is confirmed, she will have the benefit of my institutional knowledge to this point. But we certainly need to be creative going forward, keep some things that are efficiency tools. One of the biggest things was the dropping of capacity controls, because as you know, for anybody who practices in the courts, one of the tools we use with the large docket calls. It gets a lot of people into the courtroom and processes a lot of cases in a hurry. It's not the best way to do it, but if one thing, the pandemic has shone a light on an under-resourced court system. We have come up with all sorts of modes of efficiency moving ahead with the capacity controls lifted. That is one of the things we will leverage. And I will continue to be active and offer my input. And we are committed. I want to tell you, everyone from a brand new clerk with 6 months experience up to old timers like Justice Gorman and me, we are all just in the gates ready to charge out. We want to attack this backlog. I'm not going to set any timelines or any numbers because that will fall into the jurisdiction of an incoming Chief Justice, but we just want to get the horses out of the gate and running.
Sure. Good. Thank you.
Thank you, Representative. Senator Kime.
Thank you. Good afternoon, Justice Mead, and congratulations on your renomination, and thank you for your service up to this point. I had a question, and I was hoping you would tell me your thoughts on the idea of administrative deference as it's applied to the interpretations of law by the agencies.
Sure. I'd be happy to talk about that. I mean, the background on this, and I'm sure you've been part of these conversations, is the legislature simply doesn't have the time, the expertise to legislate at the micro level on particular subject areas. So you delegate rulemaking authority to agencies and commissions to hand off to their expertise. And they do that. And as you know, they produce volumes, thick volumes of rules sometimes that do have the effect of law. And every now and then we hear people speaking out saying, wait a minute, I did not elect Commissioner Jones, but Commissioner Jones is making laws that govern me. So critical to that conversation is, to what degree does the administrative agency's adjudicative function control the proceedings that follow afterwards? And I think what it comes down to is, as you know, if an administering agency has a particular expertise in an area, and if something comes up in the process of interpretation where an ambiguity is raised, deference is given by the court, and it really should stop there. So for instance, if there is a regulation that says, say an electrical code, that you must never use a current valve in a direct current system or something like that. I have no idea what I'm talking about. I'm making it go. And someone says, well, why is there a valve on this? Did something you turn off? And it turns out, actually, that's a part. It's a part you can buy in an electrical supply store. So the administrative agency would say, no, there's no ambiguity there. We're simply talking about this. We go, oh, okay, thank you. But where the rubber hits the road, where that dividing line goes, is if it's not a subject of expertise of the agency itself, simply interpreting the law, then we give no deference to the agency. We look at the law itself, we take it from there and run, but our case law says that a review of an agency decision is deferential, limited to whether the agency's conclusions are unreasonable, unjust, or unlawful in light of the record, and we refuse to second guess agencies on matters within their expertise. So I don't know if I muddied the waters or tried to make them clear, but there is a dividing line there. If it is something that is unique to the agency's expertise, something that average people wouldn't know, if there's a term of art that they use in a particular area, we'll defer to that. But otherwise, we're expected to exercise our independent judgment. We've handed down a number of cases where we have talked about agency deference, which I'd be happy to provide to you if you're interested after the fact.
Yes, thank you. I just hearing, different cases, and I know that for people when they come to the court, they're looking for the independent opinion and looking for justice. And I think that the deference is difficult because you walk in feeling that the other side is already won, so to speak, sometimes for some people. And so it's one of the issues that I have heard quite a bit about and continue to kind of want to drill down into and see if we're doing it right, or how we can fix that. If there's something more we should be doing legislatively to guide that, rather than at this point it's all case law. Is that right?
Yeah, I think that's probably a safe assumption there. It has evolved in the case law, the level of deference. I mean, you create these agencies because they have expertise, and they should be a resource to the legislature and the legislative process.
Thank you.
Thank you. Are we locked up, or am I missing something?
I think. Tom, you're muted.
We're not able to hear you, Tom.
Oh, Tom, yeah, you're muted.
Yeah, that's me. That's me. Sorry about that.
Okay, here we go.
Representative Poirier, I apologize for that.
Chair. And thank you, Justice Mead, for coming and being us today. I appreciate your openness and willingness to answer all of our questions. I do have a two-part question for you. I would like to know your opinion on how promptly decisions should be written, and how you think the Maine Supreme Court is doing on that front, if they're doing it well and in a timely manner.
Yeah, it would be great to have a bright line for deadlines for decisions. And the problem is some cases take longer than others. The problems occur when we look at cases or stringing out there, 9 months or longer. That indicates, at least in my experience, that there's some problem going on that needs to be looked into. If it occurs in the trial courts, the trial court chiefs need to be in touch with a judge and say, hey, you've had this post-conviction under advisement for 2 months now. Are you working on it? Have you reached do you need some time off? And when I was the Chief Justice of the Superior Court, I actually used that as a tool. I would call a judge and say, we have your under advisement list and you've got a bunch of cases out here. Do you need some time off to catch up with this? If the judge says, no, I've got it, but the cases don't catch up, I would call again and say, I'm going to give you some time off. And they'd say, I don't need it. No, you're going offline next week to sort of move it along. Not to browbeat anybody, but if there's no adequate reason for delay taking place, then I think the chiefs need to step in. In the law court, as you know, we have 7 justices involved in every decision. And sometimes we line up and sometimes we are marching off in 7 different directions. We try and work towards consensus, finding out which points are really subject to different interpretation, and the multiple drafts. It is not unusual for us to go through a drafting process that involves 6, 7 drafts. And unfortunately, the answer I have to give you is it takes as long as it takes. But I'm satisfied that the chiefs, the Chief Justice of the Supreme Court, the Chief Justice of the Superior Court, and the Chief Judge of the District Court are keeping an eye on that and moving it as best they can. I think that's all I can say at this point.
Thank you.
Thank you.
Thank you, Representative Poirier. Representative Galgay-Reckitt.
I'm fearful that as I speak to you, Justice Mead, that I'll get chastised for not really asking a question. So feel free to put a question mark at the end of everything I say. But I'm sure that you know that I've been sort of following the courts for my entire career, and occasionally being a annoying person at judicial confirmation hearings, or contentious person at those hearings. It's a true testament to your time on the courts that I have never spoken to you in a confirmation hearing before, because it wasn't worth my time, no offense, to come up and testify when you were so good. So I think it's a sort of a backhanded compliment that I never came to
Thank you.
testify.
I'll take it that way.
I wanted to, and I just discovered today that apparently you and I are both Advocate for Justice Award people, which
Yes, yeah, I know.
So
Yep.
that was kind of fun.
Yep, you received it. Was it 2006 you got it?
No, it's from Judge Waltham, I remember, because I had a broken, yeah, I had a broken leg, and because he gave me the award in a wheel, I was in a wheelchair.
Oh,
so
yeah, I remember that. Yes, yes.
He kneeled down to give it to me, so that was he got ribbed about that for a while.
Yeah.
But my real regret, and it's tangled up with the person who is being considered to replace a person who was my dear friend and still is, Lee Softly, on the as chief of the law court, which I believe you have ably handled for the last year. I have to say, is that my only regret about the times that I was privileged to go with the Rule of Law Commission to Russia, which was twice, and one of those times was with Justice Stanfill. So so my regret about that, and I have very few regrets other than being chastised for doing a dance that Russian women are not supposed to do, and so they pulled me off the dance floor. Believe it or not, my bad legs. It was early 2000. For those of you that are wondering how in the world I even. But I really regret that you never was along on one of those trips, because it was an opportunity to know people in a different way in the judiciary, and I think it freed up my I don't know what part of my being, but it allowed me to be more comfortable calling judges when you ought to do that. And I think most people don't understand that if something is amiss, that's not on a specific case, that you should, somebody in your organization or you should call and express your concern. Because I think that my experience has been is that judges really want to do the best thing. They just sometimes don't have, they have guidance from inside the court system, but they don't necessarily have feedback from outside. And I think that that's important too. So my question is, I knew I could get to one if I just worked at it long enough. Do you think there's a structural way that consumers of the court services, not just litigants, but people who are working with them or around them, should be able to contact the judiciary with feedback? Is that even thinkable?
You say contacting the Judiciary Committee with feedback?
No, contact the judiciary,
itself. Okay.
Yeah.
Yeah, we, having served as the acting chief for the last year, I've discovered something that Lee didn't tell me about, which is part of the job duties of being the chief, is also handling the complaint desk. We're a small enough state that everyone seems to feel quite comfortable writing to the Chief Justice if they have a concern. But I think you make a good point. Perhaps there should be a formalized portal. During my time as the acting chief, we created a comment email address for the electronic filing system. We created a comment filing address for stakeholders who had issues during the pandemic, and we created a portal most recently for parties to comment on our post-COVID planning. But yeah, there should be an ombudsman position, perhaps within the judicial branch, who reaches out and invites the comments. That's a great suggestion. Could I also follow up on your other point about, I wish I was on the Russia trip too, but I actually took one in a slightly different context. It was kind of a cultural exchange, but in 1987, Mark Woodward may talk about this, I was part of a hockey team that went to Russia to tour Russia playing Russian teams. We played on an outdoor rink in Leningrad. And after the game was, and the whole town showed up to watch us. I wanted to see the Americans, but when it was over, we had to skate back to the warming hut, which was probably, I don't know, 50 yards away. So I'm skating across, and an older Russian gentleman was running beside me and talking, didn't have any English, but he's trying to connect. And he said, Reagan, Gorbachev, people. And I knew immediately what he's saying. So I said to him, people, and he smiled, he patted me on the back and walked away. So, I think people are people all around the world, and the more culturally exposed we can get, we can understand they may come from different culture, but still people.
Thank you.
Thank you very much, Representative. Senator Carney.
Thank you very much. Justice Mead, I just want to express a lot of thanks to you for your leadership of the judicial branch during the pandemic, for your advocacy before this committee, supporting the judicial branch and all in Maine who are served by the judiciary, and especially to acknowledge all that you've done to ensure that Mainers have access to justice, especially those who aren't able to afford legal representation in civil and criminal matters. Your service to Maine has been outstanding. Thank you.
And thank you, Senator Carney, for your commitment to pro bono. You, as you know, have been a recipient of the Katahdin Council recognition. So we thank you for what you've done.
Thank you, Senator Carney. Senator Keim.
Thank you. Justice Mead, I had another sort of kind of line of questioning for you, and it's brought about by your comments around the Fuller statue that was just sort of a point of interest recently. And you made a statement that that the statue should not be what members of the public see as they approach the courthouse, and that it was not consistent with our values. And I was wondering, obviously no man is perfect, and back in 1860, whatever, he was making that decision, things were thought of differently, unfortunately. But I'm wondering how you would apply that same reasoning to many of our founding fathers, and whether or not there should be other statues that we pull down because of decisions that were made that are not in keeping with our views today.
Yeah, and you make the point that as time has passed, different ways of thinking have been acceptable, have been fashionable, and one school of thought is that you shouldn't judge people by the time they lived in if they reflected those times. I think the distinction here and why the Melville Fuller statue was different was because, that decision, the decision, separate but equal, set in motion a dynamic that caused the Black people of the day to take 2 steps backward and lasted into the next century, because separate but equal legalized discrimination and segregation. So that has become a symbol, like many other symbols, of racism, of discrimination. And in the same way that Confederate flags have been taken down from government buildings across the country because that flag is associated with racism, I think the same reasoning attached to that statue. It would appear to be a statement, because you can't say Melville Fuller without putting the case side by side with it. And for me, I wasn't particularly aware of the conversation until I became the chief and was down in Augusta. And an enormous number of people, lawyers particularly, would come to the judges there saying, why do you have a symbol of institutionalized racism out in front of the courthouse? Are you trying to signal this? So the problem for us was, everything today is about messaging, isn't it? It's all about messaging. And by having that statue right there, it seemed to be messaging. So we expressed our concern that it shouldn't be the message, but we don't own that property that was on. It belongs to the county, Kennebec County. And it was their issue in the final analysis. So I don't think that the Melville Fuller statue issue is the same as founding fathers, and whether they reflected the reasoning of the time. That's Melville Fuller's statement was not intended to mean to reach anything except the Melville Fuller statue. And I'll just leave it right there.
Thank you. I guess I mean, so the same couldn't be applied to Thomas Jefferson.
It's not for me to apply anything to anybody. That's not my role.
Mm-hmm. But yes, but the opinion you offered was, of course, has great strength behind it because of your position in that.
Because the Melville Fuller statue sat in front of the courthouse.
Mm-hmm. Thank you for that. So this kind of brings me into a wider issue that I see, that culturally right now, critical race theory is the push, which is, you know, brought about really the discussion around that statue. It's been there for 7 years, hasn't been much of a discussion, and then all of a sudden it was. And critical race theory, I think, is very divisive. And I spent 3 weeks at Harvard once, and what I learned there just recently, a couple of years ago, is that because of my skin color, I'm racist. And if I say I'm not racist, it's because I'm racist. And if I say I'm racist, then I've admitted it. And of course, I need to work on this. And it becomes very difficult for people to have a conversation when automatically, because of their skin color, they are pegged. And I see this institutionalizing critical race theory happening in schools. And of course, it's prevalent in the legislature and the laws that we're working on. But as we need to be very conscious of people and all of their different nuances of what makes them who they are, and respecting people and caring for people, we also have to recognize that that pendulum can swing too far, and we can malign people just because they don't subscribe to what's currently being driven or pushed or is popular. I'm wondering if you could tell me how you see the court being able to balance that swing, and where you see that influencing the courts.
I think in the statement we issued after the George Floyd killing, we acknowledge the fact that issues of race in America are very difficult and they're very complex, and that we don't consider ourselves to be experts in any aspect of it. I think we said, before we can move ahead, we must learn. I think that was the language of the statement. So we in the judiciary are moving forward very affirmatively, learning about race and race relations and the conversations and the language. We are part of the way through the educational programming, and it's a process. It's a learning process. We need to really understand before we can act. And I'll just leave that one right there.
And when you say educational programming, what are you referring to?
In the past, we have had implicit bias training that occurred 2-3 years ago. And we are exploring, we had a panel group with lawyers, Black and people of color, talking about their experiences within the court system and impressions that they may have drawn, but it wasn't clear to them, and the fact that we may have had a different perception. So that was the first step. Our second step is self-study. The judges have been given a list of excellent written materials, books, and need to complete some self-study in the meantime. The culminating event of this particular module will take place in October at our Judicial College, where we'll try and bring together what we've learned to this point and moving forward at this point. And it will be a process, one that probably is never pronounced to be done. It's been very difficult during the pandemic because we can't get together. And a lot of this is really small groups sitting down together, hearing each other. There are different opinions, there are different perceptions there. And the only way we can work through those, I think, is in face-to-face sessions to really hear what the other people are saying. So this is the first module. It will wrap up in October, and then we'll move on to the next ones. The objective being to learn, which is what we announced in our statement after George Floyd killing.
Thank you. One of the other statements you made is that if the rule of law disappears, justice is impossible. And I appreciated that statement. And I would encourage that as you educate, that you also strive for balance in recognizing that the pendulum can swing too far and do harm on the other side as well. Thank you.
Thank you.
Thank you, Senator. Representative Evangelos.
Thank you, Mr. Chair. And Justice Meade, thank you for sharing that story about Russia, because I've been around the world some, and I've had the same experience. It's kind of cool when you meet up with it. People of different cultures, and we are all the same. I wanted to ask you one last question, because some concerns have been brought up about the backlog of cases, mostly due to COVID. And last month, when you appeared before us, I suggested something, and I just wanted to follow up. I gave the idea out that perhaps on the lower level offenses that we could do a one-time amnesty to take the burdens off the court and allow the court to get caught up. Were you able to give any further thought to that?
I did, and I mean, obviously that would catch the dockets up if an enormous group of cases simply disappeared overnight. The problem is that amnesty or clemency or pardons are the exclusive province of the executive. We can't, on the judiciary side, dismiss a case simply because of administrative concerns. It's, we periodically get questions about, well, what if, the state has filed this prosecution, and why don't you just go ahead and administratively dismiss it? We don't do that. Our choices are to have a trial, to take a plea, or the district attorney dismisses it. So I think there's two parts to answer your question. Yes, that would remove an enormous number of cases, but it is not within the prerogative of the judicial branch to declare amnesty. I'm sorry.
It's okay. We sort of went on the honor system for a while there with COVID and law enforcement. And do you know if the idea was broached with the governor or not?
I do not. I would not have been party to that conversation.
Okay. Probably the last time I get to ask you questions. So good luck to you.
You can call me anytime. I won't be able to answer everything, but I see the judicial branch as being a resource to this committee. And you have asked us for data on occasion, and you've reached out to us, and we continue to be responsive to your requests. If you need anything from us, as I say, don't hesitate to call, and if we can help out, we will.
Thanks a lot for that. Thanks very much.
Thank you, Representative, and thank you very much for your thoughtful answers today, Justice Meade. I see no additional hands up from committee members. I'm going to check one more time. So at this point, again, I want to thank you for your time in front of our committee today. Thank you for your public service. And we will move on to the next portion of the confirmation hearing. And before turning to members of the public, we've been joined by one of our colleagues, and I would like to give Representative Hagan the opportunity to introduce himself.
Hello, and thank you, Mr. Chair. Thank you very much. Sorry that I'm coming in so late. A long day of school, and we're trying to get through the Pacific Theater of World War II. So I am pleased to see everybody here, and congratulations to the Honorable Andrew Meade. And I am David Hagan. I am the representative for House District 101, Hamden and Newburgh. Thank you very much.
Thank you, Representative Hagan. It's nice to see you. I will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk through the legislative portal before today's hearing. All such statements should have contained the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak electronically today registered with the committee clerk prior to the start of this hearing and will be called upon by me, at which time they will be promoted to panelist status in Zoom and they can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from committee members, you will be returned to attendee status and the next person will be called. And we had a list of people who, an order that they would be testifying today, and I will ask the committee clerk to begin moving over the first and second persons on that list. Ms. Panett, thank you. And the first that we have is Lee Softly, current Dean of the Law School and former Chief Justice. Welcome, Dean Softly, back to the Judiciary Committee, and please begin your comments when you're comfortable. And you are muted, Dean Softly.
It's been a year. I need the t-shirt that says you're on mute. Thank you so much. It is wonderful to see you all again. And I am, in fact, always surprised when it works and I move from one room to another, although that brief period of time is alarming each time. Senator Carney, Representative Harnett, distinguished members of the Joint Standing Member of the Committee on the Judiciary. My name is Lee Softly. I live in Cumberland County. I currently serve as the Dean of Maine Law, and it's an honor and a privilege to speak to you today about my friend and former colleague, Justice Andrew McDonald Mead. To be clear, I'm here in my personal capacity. I do not represent the university system or the law school today. Justice Mead and I were both appointed to the district court bench in 1990, and we have been colleagues for 30 years. Ultimately, we served on the Supreme Judicial Court for 13 years during my work as Chief Justice, and he was enormously helpful and supportive throughout that time. You should have a few personal facts that explain more about his personality before I address his work as a judge. Justice Mead is the absolute opposite of the TV judges he just described. He's warm, personable, and compassionate. He's also very funny, although I am sad to report that he is a master of puns. He's a rock star who plays a mean guitar, and he can tell you anything you want to know about the history of the musicians of our time, and he adores his family. As a jurist, Justice Mead is one of the most thoughtful, patient, and anchored justices I ever had the pleasure to work with. He brings that endless well of patience to everything he works on. As a lawyer and a judge, Andrew Mead is a born teacher, and you saw that today. It shows itself in his judicial role, in his extensive preparation, his ability to see all sides of a problem, and his willingness to talk through legal challenges until he's confident that he has the right solution. Those teaching skills also show up when he works with the bar, when he participates in moot courts, when he speaks to groups of students or legislators. When we put Law School for Legislators together 6 or 7 years ago, because the law school at that time was unable to take on the work, Justice Mead immediately stepped up to help Justice Ellen Gorman, who designed the original program. Justice Mead's also been an effective and persistent supporter of access to justice, as you heard. His work as the chair of the Justice Action Group, which was designed to respond to emergencies in limitations on access to justice, has led to a number of innovations, including lawyers in libraries and outreach to business partners. But I believe Justice Mead should be acknowledged most of all for his masterful leading the judicial branch through a global pandemic. In the late winter of 2020, when I first spoke to my colleagues about my decision to step down after 30 years on the bench in order to move to the law school, we realized that Justice Mead would, by law, have to take on the role of acting Chief Justice. We did not know he would end up serving in that role for more than a year, and we did not know that the year would be consumed by responding to the virus, which was just arriving. Justice Mead took on the myriad new responsibilities with his usual patient, thoughtful, and thorough approach. During this last year, he had to take on a whole new job with all of its complexities while he managed an institution in total change, a pivot to distance learning, to masked witnesses, to reduce dockets causing delays and heartache. He had to manage a fledgling e-filing system and the challenges that balancing transparency and privacy present in a digital world in the middle of managing the court's pandemic management. He did all of this with an open door, with his usual good humor, and a willingness to listen to anyone who had an idea about how to manage a court system in a pandemic, all while putting the safety of the public first. It was a Herculean task, and he rose to that task in a way that deserves all of our respect. Justice Mead serves the state now by, as long as I'm counting, 31 years, providing thoughtful, unbiased justice, a passionate support for access to justice, and skill at administration that no one knew he had until last year. I urge you to support his reappointment. I'm happy to take any questions.
Thank you very much, Dean Softly. Are there questions from committee members for Dean Softly? Seeing none, thank you very much. It's always good to see you, and we appreciate your input and testimony.
Thank you so much.
Next, I will call upon Paul Chaikin as the main delegate to the Uniform Law Commission. Welcome back to the Judiciary Committee, Mr. Chaikin. Please begin your testimony as soon as you're comfortable.
Thank you, Representative Harnett, Senator Carney, members of the Judiciary Committee. As said, I am Paul Chaikin. I reside in Bangor. Presently, I'm a mostly retired trial attorney, now conducting mediations, ethics consultations, and similar work. For the past 20 years, I've also served as one of Maine's 3 Uniform Law Commissioners. One of the duties of the Uniform Law Commissioner is to bring back to its state legislature for consideration uniform laws for possible adoption. In that capacity, I've appeared before this committee over the past 2 decades. Today's different, though. Today, I appear before you as a person, a former trial lawyer who urges the committee to vote in favor of the reappointment of Justice Andrew Mead. I began practicing law in Bangor in 1975 as an assistant district attorney. Justice Mead began practicing in 1976. We interacted frequently in connection with cases, first criminal, then civil cases. We both chose to be active in the Maine State Bar Association. We served on its board of governors together. He was elected president of the Bar Association in 1990. I was elected its president in 1994. We had numerous interactions on diverse professional matters during our terms of office for the state bar. Then in 1990, Governor McKernan appointed Justice Mead to the district court first and then the Superior Court. While the frequency of our interactions diminished, we still continued to connect through county and state bar activities and programs, and of course through trials. You have his resume. It and the testimony of others today will provide you with the detail of the breadth of work and accolades he deserves. What is demonstrated is not just devotion to his responsibilities as a judge with a full caseload, but his willingness to find time outside the courtroom to do what he could to improve the practice of law in Maine and Maine's justice system. I'll come back to that in a moment. First, I provide a few personal comments about trial judge Andrew Mead. Whether in district court or superior court, trying a case before Judge Mead was a good experience. He was always prepared. He knew what was involved with the case at hand. Likewise, he expected counsel to be prepared. In the courtroom, he conducted proceedings in a manner that involved the litigants. He endeavored to ensure that all understood what was happening, be it the parties, the witnesses, the jurors, or staff. He would speak to them, not to the attorneys. There could be no doubt that Judge Mead listened well. This had a positive impact on all involved. I never observed or heard of him raising his voice or appearing distressed at the conduct or comment of counsel, a party, or a witness. He was patient. He has a solid grasp of the law. He epitomizes excellent judicial temperament. I close with 2 points. First, pertaining to the pandemic. Justice Mead and the Judicial Department as a whole should be commended for the transparency with which decisions were made over the past 15 months. On numerous occasions, the Judicial Department sought input on how to move forward. On numerous occasions, Justice Mead would address members of the bar to explain, to update, to seek further input. Again, he listened well. Second, I mentioned his efforts and successes at improving the quality of lawyers in Maine. Before the pandemic, it was well known that Justice Mead would generously participate in continuing legal education programs. Despite having an oppressive caseload like all other judges in Maine, if asked to appear, to present, to teach, to my knowledge, he did not decline unless his judicial activities and duties conflicted. Such efforts are essential to maintain and improve the quality of the bar in Maine, which in turn improves Maine's system of justice. We are better attorneys because of the way Justice Mead has conducted himself. For that, I am grateful. I am confident there are scores, if not hundreds of attorneys who feel the same way. I urge you to vote in favor of the reappointment of Justice Mead and would be pleased to answer any questions.
Thank you very much, Mr. Chaikin. The committee greatly appreciates your input this afternoon. Are there questions from committee members for Mr. Chaikin? Seeing none. Again, thank you very much for your time and testimony today. I will now turn to Nan Heald, who appears as the Executive Director of Pine Tree Legal Assistance. Welcome back to the Judiciary Committee, Ms. Heald. Please begin your presentation as soon as you're comfortable.
Representative Harnett, Senator Carney, distinguished members of the committee, my name is Nan Heald. I'm the Executive Director of Pine Tree Legal Assistance. I'm a resident of Cumberland County, and I am incredibly honored to appear before you today to speak in support of the renomination of Justice Mead. That a legal aid director has been asked to address the committee in support of his nomination really tells you everything you need to know about the value that Justice Mead places on the work of the civil legal aid providers in Maine and the people that we serve. I'm here also to give you a sense of some of the many, many contributions that he's made to our community and to our justice system through his work on the Justice Action Group. JAG was formed in 1995 to help Maine's legal aid providers recover from serious financial funding cuts from the federal government and new regulations that threatened to disrupt our service delivery to many low-income people around the state. Justice Mead became actively involved when JAG formed a special technology group to enhance services for self-represented litigants and legal aid clients, and to assist court personnel, social service agency staff, and legal aid clients who needed assistance and information about their legal rights. He also incorporated efforts to enhance services to librarians and other groups through a real collaboration that involved innovation and technology, inspiring hundreds, literally hundreds of Maine lawyers around the state to participate in broadcasts from their local libraries and in-house clinics at their libraries in order to allow people the ability to access legal services directly in their communities, as well as new courthouse-based clinics where individuals could meet with a local lawyer in order to understand how to proceed in a case, especially in family law cases where there have never been enough resources to meet the need for people in Maine with that really complicated area of law. In 2014, Justice Mead became the chair of the Justice Action Group. For the past 7 years, he has appeared in front of this committee and been available to the legislature as a whole to talk about the importance of access to justice and the ways that Maine's legal aid providers can provide assistance to your constituents and to the people who might benefit from our services. He has also encouraged and inspired ongoing work within the JAG to increase communication and collaboration between all of the providers between the providers and the main judicial branch, between the providers, the main judicial branch, and private lawyers, and every other stakeholder that you can think of that would be important to our civil justice system. And I will note that while in other states, these access to justice commissions are supported by at least part-time staff, if not full-time staff, in Maine, Justice Mead has been the staff person as well as the leader of JAG, keeping us focused on continued improvement without any additional support. And he has done that even during the past 14 months when he was also acting as Chief Justice for our state judicial branch as a whole. I really could go on and on. I know you don't have the time to hear it, but I urge your support for his renomination. Thank you.
Thank you very much, Ms. Heald. Are there questions from committee members for Ms. Heald? Seeing none, again, thank you very much for your time and testimony today. We appreciate your input. I will now turn to Mark Woodward.
Woodward, yeah.
Woodward, welcome to the Judiciary Committee. Please begin your presentation when you're comfortable.
Thank you, sir. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Mark Woodward. I reside in Bangor, and I'm pleased to speak today in favor of the renomination of Justice Andrew Mead to the Maine Supreme Judicial Court. Preparing today's testimony on behalf of Justice Mead's renomination and reflecting on his contributions to our community was a humbling experience. We think we know someone well until we examine the totality of what they've given their state and invested in its people. I had known Justice Andrew Mead for more than 30 years and have seen him in wildly different contexts, robed and presiding in Superior Court, competing against Russians on an outdoor rink in Leningrad, calmly explaining the role of the courts as a guest of Rotarians, and amped up on stage with his band, the Retro Rockers. Different contexts and circumstances, but the same person, one whose professional and personal life continues to be an investment in people. His professional calling has been the law, and he continues to distinguish himself on the state's highest court, but his personal commitment is deeply human, and his impact at ground level where we all live and interact has been profoundly significant. Years ago, when the long avoided subject of domestic violence was first being openly discussed in Maine communities, I was the editorial page editor of the Bangor Daily News. I interviewed people who recognized the urgency and importance of that dialogue, and we published an editorial series to give the issue visibility and encourage debate. When I asked these citizens which judge could most knowledgeably and effectively give the court's perspective to the issue, there was no hesitation. It was then Superior Court Justice Andrew Mead. When Bangor convened a task force to assess the depth of the opioid crisis and develop a response to what had become a community epidemic, it turned to Justice Andrew Mead for guidance in the critical areas of alternative sentencing. We wanted to identify proven, workable approaches that would directly address the negative impact of opioid abuse in the community while encouraging positive changes in the lives of the men and women who came to the attention of the court. Justice Mead had served for years on the first adult drug treatment court in Bangor and had spoken frequently to civic organizations about the drug crisis. As in the case of domestic violence, he already had been quietly, personally engaged on a profound public issue that demanded our attention and action. This committee will review Justice Mead's resume and his professional accomplishments and engagements, his publications. It's impressive, but it can't do justice to the extent of his reach into the community and describe how one person's commitment to the people who make up that community can positively affect its quality of life. Educating on the law and courts in high school classrooms, engaging students in dialogue at Husson University, teaching First Amendment law at the University of Maine, keynoting Law Day at the Bangor Public Library, Justice Andrew Mead has shared his knowledge and brought his love of the law to every age and every audience. Reflecting on one person's contributions to his community is humbling because it's also revealing. Community engagement is cumulative. It's done in small pieces, often one lecture, one answered question, one person offered hope at a time. In Justice Andrew Mead's case, the cumulative benefit to the public and its knowledge and confidence in the courts is profound, significant, and lasting. And I want to thank the committee for the opportunity to speak in support of the renomination of Justice Mead, and I'd certainly be happy to answer any questions if there are any. Thank you.
Thank you very much, Mr. Woodward, for providing your testimony this afternoon. Are there questions from committee members for Mr. Woodward? Seeing none, again, we very much appreciate your input. Thank you, sir. I will now turn to Lori Boxer-McCumber. Ms. Boxer-McCumber, whenever you are ready to proceed, go ahead. Nice to see you again.
Nice to see you all again as well. Thank you, Representative Harnett and Senator Carney and members of the committee for taking the time to listen to everyone's testimony today on the renomination of Justice Mead to the Supreme Court. I'm here testifying in my capacity as president of the Maine Trial Lawyers Association, but I also individually endorse the renomination of Justice Mead to the Supreme Court. When we surveyed our members, we received extraordinarily high praise for Justice Mead, for his skill, his judicial temperament, and for his judicial demeanor. And as you can see from his presence today, all of that holds true. One survey respondent called the nominee a true gentleman with an enviable combination of intellect and compassion. And having started to work alongside him in my capacity as president of the Maine Trial Lawyers Association, I endorse that comment as well. It's been a pleasure starting to get to know Justice Mead, because you can truly see his commitment to the people of Maine and ensuring that the courts remain as open as possible during this difficult time. Another person called him a model judge. And people also, our board also commented, those who have the institutional knowledge commented that in the past, the responses to surveys have been extraordinarily positive as well. In addition to his superior performance on past surveys, we know that he has the benefit of 14 years of private practice, which our organization thinks is extraordinarily important, to have actually practiced law for a significant amount of time before sitting on the bench. And in addition, he has all of his time on the bench, and all of the leadership positions have shown that he's able to serve the court system well. His overall legal career is impressive, as you've heard today. Our organization really wants to take this opportunity to thank him for everything that he's done during the pandemic to lead our justice system during such a trying time. He's kept all of us, our organizations, us and MSBA and so many other organizations, well informed, and has been very accessible to all of us when we've had questions or wanted to invite him in to present. So everything you've heard earlier at these hearings has been our experience as well. And we appreciate his hard work and his commitment to the court system and Maine people. And we just want to endorse this excellent renomination, and are very appreciative, Justice Mead, of everything you've given to the state. I'll entertain questions if there are any.
Thank you very much. Are there questions from committee members for Ms. Boxer-McCumber? Seeing none, again, thank you very much for your time and testimony this afternoon. Committee, great.
Thank you all as well.
Your input. I'm going to check the attendee room to see if there are any other persons who wish to testify in support of the nomination. If so, please raise your electronic hand and I will have our committee clerk move you over. And I am not seeing any. So I would check now the attendee room to ask if there are any persons who wish to testify in opposition to the nomination. To please raise your electronic hand. And again, seeing none, I believe that that concludes the public testimony portion of today's confirmation hearing. So with that, all public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. Are there any documents that we have not seen, Committee Clerk Panett?
There are none, Mr. Chair.
Thank you very much. We will then vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. This vote must be taken within 40 days from the date of the governor's written notice of nomination, and we are within that time frame. With that, the hearing by the Joint Standing Committee on Judiciary for the Honorable Andrew Mead of Bangor for reappointment as an Associate Justice of the Maine Supreme Court is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, the chair will inquire whether any member present objects to proceeding to taking the vote immediately. If you object, please raise your electronic hand. And I see that there is no objection, and therefore the pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Andrew Mead of Bangor for reappointment as an Associate Justice of the Maine Supreme Judicial Court be confirmed. In accordance with 3 MRSA, Chapter 6, Section 157, and the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. I will ask the committee clerk to please call the roll.
It will be my pleasure, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Mr. Chair, I have 13 members voting in the affirmative, 0 in the negative, and 1 member is absent.
Thank you, Committee Clerk Panett. 13 members of the committee having voted in the affirmative and no committee members in the negative. It is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Andrew Mead of Bangor for reappointment as an Associate Justice of the Maine Supreme Judicial Court be confirmed. Congratulations, Justice Mead. Thank you so much for your service to the state of Maine and for all of your appearances before this committee. Were these regular times, we would be standing up, greeting you personally as we leave the horseshoe to offer our congratulations and best wishes. But as you've learned, this year has been like no other. So our new tradition is to extend a virtual round of applause from the committee members and our heartfelt thanks for all that you've done for the state of Maine and all that you will continue to do.
And thank you, and many thanks to the committee for your support and for the good work you're doing on behalf of the people of Maine. Thank you so much.
Thank you, Justice Mead. And with that, I will turn the gavel back over to my co-chair, Senator Carney.
Thank you very much, Representative Harnett. And once again, thank you, Justice Mead, for all you're doing for the people of Maine. The reappointment nomination confirmation hearing having been completed, we're going to move on to our committee work. We do have a number of work sessions. I give people a chance to say goodbye to Justice Mead. Thank you also, Mr. Hobson, for being here today. And we're going to dive into our work sessions in just a minute. I think committee members might want just a couple of minutes break before we dive into the work sessions. And also, Senator Sanborn, would you like to introduce yourself since you've just joined us?
Sure. Thank you, Senator Carney. I'm sorry I couldn't be with you for the confirmation hearings. I was in my other committee. I am Senator Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And committee members, let's just take a quick recess and return at, say, in 5 minutes, so 3:48, and then we will launch into our work sessions. See you all in just a few minutes.
Alexa,
Hello, committee members. If you are at your devices and are able to jump back into the meeting, please activate your video. Let's see. All right, so we're going to get started back up with our work sessions, and the order of work sessions today is 7:47, 11:34, 17:03, 15:77, and 16:17. So Peggy, if you are ready, could you please give us kind of a brief overview of the bill analysis on 7:47? Representative Harnett, go ahead.
Thank you, Madam Chair. I just received notice that the bill sponsor, who I believe is the sponsor on both 1134 and 1703, is in a work session in criminal justice. I'm trying to find out how long that will tie her up.
Okay, thank you. Thank you so much for mentioning. So I think we'll do 7:47, and then perhaps we may end up jumping to 15:77. But we'll get started regardless. And thanks again, Representative Harnett. Peggy, it's all yours.
Great, thank you very much. So our first bill this afternoon is LD 747, an act regarding civil mental health evaluations of former criminal defendants. And you actually spent a lot of time working on this bill, and we thought we had an amendment, and it still didn't work. So you sent us off to work on it. And I had a really great work session with Tina Netto and Dr. Sarah Miller of the Forensic Service, and Julie Finn with the judicial branch, because you needed all of us to make it work. So what you should have that I emailed to you is an amendment that hopefully responds to this. So if you remember, the concern was there are criminal defendants that have never been competent to stand trial. And at some point it's determined, the court determines that it's usually DHHS brings them information that this person is never going to be competent to stand trial. And so that is actually a court determination based on the information that's given to the court. And the court, when the court makes that ruling, then if the person will not be able to stand trial, then they dismiss the charges. And the question is, what happens with that person then? Under the current law, if the person was charged with some fairly violent crimes, it specifies exactly what they are, then the person the court directs, when the court dismisses the charges, the court directs the Department of Human Services to start involuntary commitment charges, the involuntary commitment process. And if there were different charges that are now dismissed, then the court would notify the department that maybe they want to do that. So DHHS came back and came to you with this bill and said, this isn't working, because if the person needs to be in a secure situation, they already are. And if they don't need to be, they've actually been out in the community, and we don't really want to go through this process anymore. And the courts agreed, and the defense attorneys agreed. And so you should have an amendment that, and I can share it on the screen if you want, that does exactly that. It pulls out the finding of non-restorability out of that big long paragraph A and creates a new subsection 5A and nice succinct paragraph that's a subsection that says, if the court determines that the defendant is not competent to stand trial and there does not exist a substantial probability that the defendant can be competent in the foreseeable future, the court shall dismiss all charges against the defendant, and unless the defendant is subject to an undischarged term of imprisonment, the court may notify the appropriate authorities who may institute civil commitment proceedings for the individual. So the courts are happy with that because that is not a directive that they need to jump in and make something happen. All the parties are satisfied that if the person needs to be in a secure situation, they already are. They have been all along. And so this provides that if the defendant is subject to an undischarged term of imprisonment, they actually have to go back to serve their imprisonment. That's usually for another crime that they'd already been convicted for. So we're no longer making a distinction based on what the underlying crimes were, because the defendant is already in the appropriate situation. If he or she is not dangerous, they're in the community and they're being monitored. If they are considered to be dangerous, then they are already in a secure situation. So that kind of just drops out that whole consideration. And all it says is the court drops the charges and makes sure that DHS knows that those charges are dropped. And DHS has been bringing DHHS has been bringing the court the information about whether or not the person is restorable to competency. So they're involved in this case all along. It's not like this just comes up out of the blue before the court. So hopefully this simplifies the process for everybody and it makes it easy to follow. I'd be happy to answer any questions.
Thank you very much, Peggy. Representative Harnett?
Thank you, Madam Chair. A question for Peggy. The amendment that you just read us, is that the revised 517-21?
It is, yes.
Okay, then in that case, I will make a motion ought to pass as amended.
Second the motion.
Thank you. So an ought to pass as amended by Representative Harnett and a second by Representative Moriarty. And committee members, are there any additional questions for Peggy? We do have some of the folks who worked with Peggy on the amendment in the attendee space, if anybody has questions for them. Not seeing a groundswell of questions either. We have worked on this bill quite a bit. Is there any discussion? Is the committee ready for the vote? It looks like people are ready for the vote. Okay. So the pending motion is an ought to pass as amended on LD 747. The amendment being the amendment circulated to the committee that's dated 4/17, prepared by our analyst. And the motion.
Actually, Madam Chair, it's revised 5/17.
Oh, thank you. Yes, dated 4/17, revised 5/17. Appreciate that.
Oh, right. That's the day I first created the document. So we worked it for a month.
I was looking at the wrong side of the paper.
My bad.
No, mine, totally. Motion by Representative Harnett, seconded by Representative Moriarty. Representative Hagan, go ahead.
Thank you very much, Madam Chair. I was looking in my notes at the wrong bill. May I request a corner caucus for 2 minutes?
Yes, that's totally fine.
Very much.
I think, yeah, we'll just stay here and wait for you.
Staring at the wrong bill for 5 minutes, and I apologize.
That's okay.
Thank you.
Madam Chair, what's up next?
Well, we don't know because the next bill is 1134, but we also know that the bill sponsor is in a work session on another bill in another committee. And so if we're not able to take up the next two, we would move on to our fourth bill, which is 1577.
Right. And
Go ahead, Peggy.
no, Representative Harnett raised his hand.
Okay, go ahead, Representative.
Thank you, Madam Chair. I've been notified that the bill sponsors' presence in the other committee is just about to end, so we might be able to move on to the bill in the order that they were scheduled.
Thank you.
And I was going to note that Senator Moore is here on LD 1577.
Great. Thank you.
If you were looking at your email, I suddenly panicked and thought we were working LD 1676 today. And so I sent you an email while you were in your confirmation saying, here's this amendment for this afternoon. And then it's actually tomorrow morning.
Okay, great. That's good. I hadn't received the email, but I'm glad to know that it's not a rush for
Great.
tonight.
And the text of the amendment is actually included in the bill analysis that I did send to you yesterday. Although there is one more change that the state archivist, Kate McBrien, and I were working on today. So I won't actually have that for you until tomorrow, probably. But she had raised that issue at the public hearing.
Thank you. All right, committee members, it looks like we're ready to resume our work session. And so we'll, Representative Hagan, did you have any other questions or need any information?
Nope, I apologize. I was in 1703, which isn't 747. And I was like totally discombobulated. I don't know where I put my papers, but I'm all set now, thanks.
Okay.
I had to look at the bill. I had to see what I'm doing, so.
Yep. All righty. Is the committee ready for the vote? Looks as though we are. Thank you very much, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Senator Keim. Senator Keim is absent. Representative Galgay-Reckitt. Representative Galgay-Reckitt is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 2 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And for those who voted in the negative, could you please let us know what your report is?
Not to pass.
Yep, same.
Thank you very much. And so the ought to pass motion carries. And with that, we'll close the work session on LD 747 and move on to our work session on LD 1134. The bill sponsor is here, and so we will have her join the panel. And welcome, Representative Talbot Ross. We're pleased that you could make it. And Peggy, at this point, if you would like to, could you please start the bill analysis on 1134?
Thank you. I'd be happy to. This also is a bill that you have worked before, and I think you were actually right about where you had resolved all your questions. Well, maybe you didn't resolve all your questions, but we knew what the language needed to be, and we just couldn't get it on paper fast enough. So we do have an amendment that, just to make it easy, we struck everything from the bill. It's not dealing with warrantless arrests anymore. Oh, we should probably change the title too. Now that I say that. So what it does is it current law provides that violation of a pre-conviction bail condition is usually a Class E crime. There are some situations where it's a Class C crime. What this bill does, what this amendment does, is say it's never a Class C crime to violate a condition of a pre-conviction bail, and there are only a few circumstances where it's a Class E crime for violating those specific conditions. And that's what that paragraph A is, 4, 5, 8, 13, and 19. And we can go over what those are in a second. And then it adds a new subsection that says there's another way. If a defendant is charged with certain crimes and they violate a condition of release, they are guilty of a Class E crime. And that is, those crimes are if the defendant is charged with a crime against a family or a household member, a sexual assault, a violation of a protective order, any of the protective orders. Protection from harassment, the protective orders between family members, harassment, and the protection from abuse in Title 19A. So if any of those are the underlying crime for which someone has pre-conviction bail and they violate that, then that is a Class E crime. All the other situations, if I'm correct, Representative Talbot Ross, would not be considered crimes. There's still a violation of bail, which means that they can lose their bail. And they can be brought back in because they violated their condition of bail. So they can be brought back into custody, but they would not be facing an additional crime. It doesn't affect their underlying crime, but they would not be facing an additional crime. And so that's what sections 1 and 2 do. And then the last piece of the bill, it's on the back page. It's an affirmative defense to a prosecution under either of those 2 sections we just talked about, that the violation resulted from just cause. That's actually current law. And we're just expanding it to that new category where it's a Class E crime based on the underlying crime.
Thank you very much.
I'm happy to answer any questions.
Yes, I was just going to ask committee members, are there questions for Peggy regarding the bill analysis and the amendment? Go ahead, Representative Harnett.
Thank you, Madam Chair, and thank you, Peggy. Just so I'm clear, the last time we were working this, I think we were considering an amendment of ought to pass as amended with sections 1 through 5, but no longer 6. This has now been even more truncated. Am I right?
Yes, so sections 4 and 5 and 6 were all about warrantless arrests. And I think section 6, we talked about section 6 for a while. And there was proposed language about amending section 6 about not arresting somebody, that it was important for the law enforcement officer to summon somebody rather than arrest them unless it looked like there was a safety concern. I don't remember the exact language. That has since been dropped from the bill by the sponsor.
Thank you.
Committee members, any additional questions for Peggy? Representative Moriarty?
Thank you, Madam Chair. Peggy, I just have one question on the the flip side, section 2, titled Affirmative Defense. And we've had so many bills relating to bail and other matters kind of run together here, and one of which, maybe more than one, deleted the affirmative defense language and just substituted defense. It is retaining the affirmative defense here consistent with what we are possibly doing elsewhere?
So the other bills we were talking about, affirmative defenses, were the were related to sex trafficking and the prostitution bills, and those were the bills where we were changing it from affirmative defenses to defenses. So once it's raised, the prosecution has to prove it doesn't exist.
Yep.
Different category of conduct. Here you're talking about bail and expecting somebody to comply with the conditions of bail. I don't know that it was even raised to change this from an affirmative defense to a defense. The reason it's here is to include that new category of Class E crime for violation of conditions of release.
Okay, so you're satisfied there's nothing inconsistent evolving here?
I am. I think you're right about we've been talking about defenses and we don't usually talk about defenses. But I think that's really a different discussion.
Okay, good. Thank you then.
Representative Harnett?
Thank you. And I think Peggy's answered my question, but I just want to make certain that I'm correct. On page 2, the affirmative defense, that's existing law. We are just adding paragraph 1A and changing section to sections. Is that
correct?
Thank you.
Representative Moriarty?
Madam Chair, I move ought to pass as amended with specific reference to the revision of the draft amendment dated 5/22/21.
And as a clarification, does that also include striking from the title the words "and the main criminal code regarding warrantless arrests"?
Oh, yes, it does.
Thank you.
Thank you. Is there a second to the motion? Representative Evangelos?
Second.
Okay, thank you. Before let me call on Representative McCrate, and then I'm going to ask the bill sponsor if she wishes to be heard. Representative McCrate, go ahead.
Thank you. I didn't get my hand down fast enough. I was going to mention the title, but you already did. Thank you.
Thank you. I'm glad we're all thinking of all of the various aspects that we need to work on. Representative Talbot Ross, would you like to address the committee about the amendment?
Thank you, Madam Chair. No, I think it's been a great discussion several times now, so I appreciate the flexibility and patience of this committee and for their deliberate consideration. I'm very pleased with the amendment, and I thank you for all of the time that you've taken to consider this bill. Thank you.
You're welcome, and thank you for bringing it forward. Committee members, is there any discussion on the pending ought to pass as amended motion? Any additional questions for either the bill sponsor or our analyst? I am not seeing any questions or discussion. Is the committee ready for the vote? Appears that we are. Ms. Panett, thank you very much. I think we're ready to proceed.
Madam Chair, Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Nay.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Galgay-Reckitt. Representative Galgay-Reckitt is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 3 members voting in the negative, and 2 members are absent.
Thank you very much. For those who voted in the negative, could you please let us know what your report is?
Mine is ought not to pass.
Ought not. Same.
Okay. Thanks, everyone.
Thank you.
Thank you, Representative. And with that, the motion carries. So we have a vote of ought to pass as amended on 1334 with 3 opposed, reporting ought not to pass, and 2 absences. So that will close the work session on 1134, and we'll move on and open the work session on 1703, an act to amend the bail code. And this again is sponsored by Representative Talbot Ross. And I think she just left our meeting. We'll try to get her back. Could you please reach out to her, Representative Harnett?
Yes, I will.
Thank you. And in the meantime, Peggy, if you could begin your analysis, please.
Sure, thank you. So LD 1703 is an act to amend the bail code. And the purpose of the bill really is to do away with cash bail, or a financial condition of release in most circumstances. And there, Representative Talbot Ross has presented an amendment that I think I sent out yesterday evening. It also addresses some, it addresses the purpose of bail as opposed to ensuring that the release would not reasonably, so instead of releasing somebody, they're held or they're there are conditions, they're not released because current law says the release would not reasonably ensure the appearance of the defendant, and that is changed to the release would result in an imminent risk of willful flight. So it's really, it's changing kind of the focus of why you don't release somebody when they're charged with a crime. And this is pre-conviction. This is before you even have a trial. So if they're not going to show up, that the real focus is an imminent risk of willful flight. The existing purposes are the release would not reasonably ensure that the defendant would refrain from any new criminal conduct. So you can put bail conditions on. The release would not reasonably ensure the integrity of the judicial process, or the release would not reasonably ensure the safety of others in the community. So focus on doing away with financial condition of release in lots of situations, focusing on the purpose of bail in the first place, or why you don't release somebody before the trial, and then changes some of the bail conditions.
Peggy,
Yeah.
Peggy, I'm sorry to interrupt you, but I think I actually might have the wrong document. Is the amendment that you sent out to us one that's in your format, or one that's the one that was still formatted by the sponsor?
It was formatted by the sponsor.
Okay.
And it has red text where she is recommending changes.
It's dated yesterday.
Yes. Okay. That's what I have. And I just wasn't following along with your, so I may just need to take a moment to.
Oh, well, right. I was just trying to do really high level. But so if you want, we can go through the amendment if that would be easier. I mean, the amendment tracks the bill except where the red language is, and I can certainly share that on the screen if that would be helpful. And also, I know that Megan Sway has worked with the sponsor to put together language, and other people have been working with her. And Andrea Mancuso has been working because there's the tension between releasing somebody who's been charged with a crime that is a domestic violence crime, basically, and making sure that the survivor is safe and has room to develop a safety plan and do whatever is necessary to make sure that she or he is safe. And there's definitely that tension between not holding somebody in jail while they await trial because of the crime that they are charged with, and keeping the survivors in that situation safe and protected from any future violations. And so I think Ms. Mancuso has been working with the sponsor and Ms. Sway to develop kind of a compromise position. I think the bill has already addressed that, because if you look in paragraph H.
Wait, Peggy, I'm just gonna, I'm sorry to interrupt, but I think this is something that I just feel a little unfamiliar with personally. And so I'll call on Senator Keim, and then I would really appreciate if you could screen share and just kind of take us through section by section, and do a little bit more of an in-depth analysis. And I'm sorry if other committee members aren't as unclear about this as I am, but I really need to hear a little bit more detail about this one, if you don't mind. But let me just call on Senator Keim first. Go ahead, Senator Keim.
Thank you, Peggy. I was hoping that you could just resend the email. I keep doing a search and not coming up with it. And you said the latest amendment is not uploaded to our file. Is that right?
Oh, I thought I had uploaded it.
Oh, it is. Okay. I thought you were saying that it was different. So that's, proposed amendment 524. Okay, so I misunderstood. I thought it was not uploaded. It was only here. Okay, great. I have it in front of me now. I just was confused by that.
Okay. Okay, do you want, so we can work through the amendment, because it's really the bill with some changes. So maybe that's the best way to do it.
Yeah, I think that would be really helpful, certainly to me, and I hope others will indulge me, even if they're more familiar with it than I am. Representative Moriarty, do you have a question before we do the screen share?
I do, Madam Chair. I picked out what I think are two typos or clerical mistakes, which might be useful to address before we screen share.
Okay.
Okay.
If you agree.
Yeah, they can be addressed at any time, but go ahead if you'd like.
Okay, Peggy, on page 1, it's section 3, subparagraph 5, which appears in the language that appears in red.
Okay.
Should the W be capitalized to indicate that that's the beginning of the sentence, or was there language that was to have preceded the word when?
My understanding is there's no language that it probably should be capitalized.
Okay. The other one is on the next page. It's section 6. Now, 3 lines down, you'll see underscored the words result in an imminent risk of willful flight.
Mm-hmm.
Should the word not precede that phrase?
No, I think that's right, because I think that these are situations where the judicial officer is not releasing somebody. So the judicial officer determines that the release described in subsection 2A will result in an imminent risk of willful flight. And then you get down to the judicial officer shall order.
Well, everything else has the word not in it.
Yeah.
I honestly think it's supposed to say will not result in an imminent risk of willful flight.
Perhaps it would be better to take that up when we're focusing on that.
Okay.
Okay, that's fine.
Thank you.
I think that this may be easier for us to resolve that issue than Representative.
Okay. So are we going to screen share?
Yeah, could you please?
Oops, here we go.
Thank you.
Okay, so this is the amendment dated 5/24/21. So the first 3 sections, this is, we're in the bail code. Section 1023 is bail commissioners, and subsection 1 is their authority. Subsection 2 is how they're appointed. Subsection 3 is immunity from liability. And then we get to subsection 4, where sections 1, 2, and 3 of the bill are. And it is a bail commissioner may not. So that precedes F, G, and H. A bail commissioner may not, notwithstanding section 1026, subsection 3, paragraph A, subparagraphs, impose a financial condition of release on the defendant for whom the highest class of crime charged was a Class E crime, except that a financial condition may be imposed on the defendant charged with a Class E crime that meets any of these situations. So what that's saying is the bail commissioner can release folks, I guess, for these crimes, but cannot impose a financial condition for release for any of these Class E crime, for any Class E crime. The highest crime charge is Class E. So if there's a B or a D, or this paragraph doesn't apply. Unless that Class E crime is one of these. So a violation of 17A chapter 11, that's the sexual assault chapter. It's the whole chapter. It's not just gross sexual assault. It's any of the crimes in that. And again, remember, we're talking about, well, it doesn't matter because the bail commissioner cannot set cash bail, basically, financial condition of release for any crime in 17A, Chapter 11. I'm sorry, the bail commissioner can require a financial condition on these crimes. So Chapter 11. 2, that was committed against a family or a household member that we were talking about before. So a family or household member as defined in the Protection from Abuse statute, or a dating partner. 3, so that's any crime committed against a family or household member or a dating partner. 3, that is a violation of a condition of release committed while the defendant is released on bail for a charge that involves these same crimes that we're talking about here. 4, that is a violation of a condition of release premised on an allegation of new criminal conduct. 5, when the defendant has failed to appear on the underlying Class E charge, sorry. They've already failed to appear, so no cash bail. The bail commissioner can require cash bail. Or if stipulated by the parties, a financial condition imposed under this subsection must be nominal and not exceed $5. Those are 2 new things that perhaps you'll want the sponsor to speak to. And I don't know if you want to stop now and have her speak to that, or if you would like us to move on and come back.
Let's do this section by section, but let me just ask you a clarifying question. So everything that's underlined was part of the original bill, and the red language is the amendment to the original bill.
Yes.
And the paragraph H basically says no cash bail for Class E crimes. And then paragraphs 1 through 6 are different sets of circumstances in which, even if it is a Class E crime, cash bail could be allowed.
Yes.
And should there be an or at the end of paragraph 5 as well?
Yes.
Okay. All right, so let's just check in with the sponsor and see if, well, first of all, committee members, are there any other questions for Peggy on section 3 of the bill that's on the screen now? And use your electronic hands, please. Okay, not seeing any. And
No,
then,
I actually just have one clarification.
okay, go ahead, Representative.
Thank you very much, Madam Chair. I just want the not to exceed $5. Is that a separate situation, or is that relating to the exceptions in 1 through 5?
My understanding that the bail commissioner is authorized to set bail if that's stipulated by the parties. That's what number 6 says, if it's stipulated by the parties. But that financial condition must be nominal and not exceed $5. So the maximum of the cash bail, it looks like, would be $5. And that is new language, and that Representative Talbot Ross has proposed. And I must admit, I don't have any additional information about that, unless maybe it's in the summary.
Okay, let's maybe hear from the sponsor on that. Representative Talbot Ross, could you provide us with any additional information regarding section 3 of the proposed amendment?
Do you want me to stop sharing?
Yeah, I think so.
We can bring it back up.
Yeah. And I think we may just have lost the bill sponsor again.
I see her.
Oh, hello, Representative.
Thank you.
On the screen. Go ahead. So anything you would like to share with us about section 3 of the amendment?
No, what I would really, if the committee is interested, I would love to have Megan Sway brought into the Zoom. We've had numerous conversations over the weekend leading up till today with DA Sarback, and as you've heard from Peggy, with Andrea and Mancuso from the Maine Coalition to End Domestic Violence. And so some of this is in response to those conversations that we just recently had. And I see that Megan is here. I think she can answer any of these, the new language that we put in based on those discussions.
Thank you very much. And while we're waiting for Megan to join us, Senator Keim, did you have a question? Go ahead.
Thank you. Representative Talbot Ross, I was wondering, it seems in this section that the only victims really that are kind of cared for are domestic violence or sexual offenses. Is there a reason why only those seem to be the ones that are highlighted here in response to bail? And I would also, to follow up, like to hear your ideas on the $5 before Megan offers an opinion on that, if you have one.
Yeah, this section here, it's been pretty consistent throughout a lot of the work that we have been doing, is to respect all the crimes against the persons, all of the sexual assault, domestic violence crimes in Chapter 11, Chapter 12. And so this was something that has been cognizant for me for a long time, is not wanting to cause any further harm or add any further burden to those victims. That is where I believe we have to be most cognizant. That is not to say that any other victim of any other crime should not be considered, but for me, Senator Keim, it is limited to the crimes against persons and those that are considered domestic violence and sexual assault. In terms of the $5, I would like for Ms. Sway to answer that question. Again, they came out of conversations with the district attorney who had some concerns, and I think she can answer that.
Thank you.
Yeah, thank you. Go ahead, Megan Sway.
Hi, everyone. My name is Megan Sway. I'm Policy Director for the ACLU. Thank you for having me. So the two changes that we made here were in direct response to DA Sarback's points. The first, subsection 5, we had written this last session when this bill came up, because DAs had said that if someone commits a Class E crime but fails to show up in court, they wanted to be able to assess bail on that person who failed to show up in court. And the language originally was trying to deal with that situation, but the way we wrote it, as DA Sarback pointed out this year, didn't actually capture what we were trying to do. So that's just trying to write this so that if a person fails to show up in court, whether or not they're charged with a Class E violation of condition of release for not showing up, that bail could be imposed by the judge on the underlying crime if they failed to show up the first time. In terms of subsection 6, DA Sarback told us that in practice in courts, often if someone is facing multiple charges, where there are some, say, Class C or D or B charges, and also is facing Class E charges, they will put cash bail on someone in order to get them credit for time served. If you are not in jail during the time, in order to get them credit. And so it's sort of, you get credit if you are in jail for time served before you go to trial, as you all know, because you worked on a bill about this year. And this is a way for defendants to continue that practice with prosecutors. But we wanted to not make it so that someone has a bail set that is so high that if they resolve the underlying charge of the higher crime, that they're then stuck in jail on cash bail on the Class E, because the intent is for there not to be cash bail on most Class E's. And this is just a way to help what I'm not explaining this very well, but this is what the prosecutors and the defense attorneys work out in court. And this was a way to preserve that ability for them to do something that they do often, which is to put a nominal amount of cash bail so that someone can get time served while they're awaiting their other charges.
Can I just ask you a clarifying question? So is the existence of cash bail one of the requirements that has to be met in order to get credit for the time served?
I think the idea is that, yeah, a person is in jail because they're not meeting that condition. And yes, I think the cash bail is what keeps them in. And then often what happens is if they resolve the higher crime and they plead out or whatever, that the prosecutors often will ask the defense attorneys to file a motion for reconsideration of bail on the lower crime, and they will not oppose. And so they dismiss it that way and get someone out. So the point is not to keep someone in jail any longer than they're serving time on their higher offense.
Thank you. Committee members, are there questions for Megan Sway? Senator Keim, did you have a question? Go ahead.
Thank you. So, Ms. Sway, so I guess I just need to restate this. So a person, if they have some amount of bail, that means they can stay in, and without any amount of bail, they can't stay in jail and be serving their time. Is that what you're telling us? I'm sorry that I'm just following it.
Yeah, it's a little complicated. I think what it is that, so cash bail is a condition. If you, and any of the conditions, if you can't meet that condition, you're stuck in jail.
Right.
And I think the cash bail in this case is the condition that is keeping someone in jail. And without that, they would not get time served.
Right. So it's like the most minimal condition that you could, basically it's a gift. Like you're saying, okay, here's this, so you can have your time served. Is that the way?
I don't know if it's a gift because they're in jail, like they're serving the time. Yeah.
But they want to be clearly, or they would be handing over $5.
Well, they can't because they're in jail on that higher crime for so whatever bail is on that higher crime, they can't make, or it's a crime that isn't bailable, that doesn't, they're not able to get out. So it's not a gift because they're still dealing with whatever conditions are on that higher level crime.
So I guess I don't understand then maybe why they need, I thought I was understanding that this was the only bail condition keeping them in jail, and therefore it was helpful, which is a weird word I know to apply, but because that's how they were staying in jail. But so maybe I'm just not understanding that. But I do have my other question, which I wanted to ask you, because you're in support of this. But I mean, what I see happening is with a lot of the laws that we're considering, that we elevate domestic violence and sexual assault and the victims of those above all other victims. And so what we've done here is we've captured that, say, okay, well, we want bail for these people if they commit this type of crime, but all the other victims of these crimes, the bail doesn't matter or doesn't help keep them from, protection or whatever. Can you just help me understand your thinking about why those victims are elevated above others?
Yeah, I think this was a public safety analysis. Our goal with this bill was not to jeopardize public safety, and the times in which for Class E crimes that public safety is really implicated is for these sexual assault or domestic violent crimes. And for other Class E's, safety is not at the same risk. It's part of why we went with Class E's, to really try to focus on this lower group where we're not jeopardizing safety. Our thoughts are, because you can still put other conditions on for Class E, Class E crimes, it's not that we're now saying every Class E is a personal recognizance. You just sign your name and you get out. They could put conditions like, don't go back to that person's property, don't go back to that store. They can put conditions on it to protect victims. So we felt like that was protecting people who are experiencing crimes at a Class E level, but for the domestic violence, the danger is just that much more heightened. And so that's why we did that. But we did try to ensure that we could protect people and put some space between them so that we don't have people returning to the scene if it's a problem.
Thank you.
Representative Harnett, I think your question was next. Go ahead.
Thank you, Madam Chair. And I just don't understand paragraph 6, subparagraph 6. I just don't understand.
It's a way to preserve concurrent sentences to make them easier.
Let me finish.
Oh, sorry, I apologize.
This does not allow people who are charged with, for lack of a better word, the crimes listed in sub 1 through 4 to stipulate to a $5 cash bail.
That's not how I read it. I mean, a stipulation would have to be by agreement. So then a prosecutor there are many domestic violence case charges for which bail commissioners can't set bail anyway. But then the stipulation is just if the parties agree. So if I would imagine on these domestic violence or interpersonal violence cases, a prosecutor would not agree to that.
And the parties are, again, for lack of, is the prosecutor and the defense attorney.
Correct.
Right?
Yes.
The victim is not involved here. There's not pressure on the victim.
No, the party is the state. Yes.
Thank you.
So maybe we should think about clarifying that a little bit, because I also found that confusing, that word parties. Representative Moriarty, I think you were next.
Thank you, Madam Chair. I share the confusion that those who have spoken before me have expressed. I frankly think the football has been lateraled too many times in this case, or rather on this bill, and the result is that it's more complex than it needs to be and harder to understand than it should be. I don't understand the purpose of subsection 6 at all. And I don't know what purpose paying $5 achieves. I don't know whether that would entail a $60 bail commissioner fee as well, in which case you're really talking about a $65 charge. That $5 charge appears on page 1 and page 4. And I just don't understand why it's there at all.
Thank you, Representative Moriarty. And Representative Cardone just raised her hand. Representative Cardone, is that because you know how to answer that question? Yep, you're muted.
I have not studied this bill in depth, but I think Megan's mention of concurrent sentences here is the key. If somebody is in jail on a felony, let's say, on a Class C, and they're now being bailed on a misdemeanor, if they want the sentences to run concurrently, I think there has to be bail on the Class E misdemeanor. Is that what you were trying to say, Megan?
I think what it is, if you get PR bail, personal recognizance, so you just sign your name, but you're still in jail on this higher crime, you don't get credit for that time. And so then, sorry, go ahead.
You don't get credit for the time on the Class E.
Correct.
You don't. So if you're going to plead out to have time served on concurrent sentences, you have to have bail on the Class E. It's nominal bail, but that's what's allowing your time served. I think that's my understanding, and I think that's the purpose of subsection 6 and that $5 concurrent by agreement, $5 nominal bail by agreement.
Okay, thank you, Representative Cardone. So we've got lots of hands up, and I'm just going to call on people. I think, first of all, Representative Harnett, is your hand up anew or residual? Okay. Then Representative Babbage, I think you were next, and then Representative Hagan, and then Moriarty.
Okay, thank you very much. The $5 may or may not apply to 1 through 4, but the part by stipulation of the parties does make me feel better about that situation. The question I had really was, are we putting an additional bail, which technically would be a higher penalty, in order to achieve something that's even that's good for the defendant? It seems so, but the reason I bring this up, I once was in a room of high elevated jurists, a lot of great minds, and was kind of flummoxed and asked the question, do you actually sentence harsher in order for a defendant to have adequate drug treatment time? And as there was some nodding in the room, another attorney pointed out that the Supreme Court has said that's against the law. And but this benefit to the defendant would be by stipulation of the parties, and therefore that would not be an equal comparison. Is that right? Do you understand what I'm saying there?
I think so. I mean, the intent of setting it at $5, and if the committee wanted to go to a different number, I chose $5 as a number to signify that it's really nominal, that this is not that we're, and that if a judge was going through a bail list and saw a $5 bail, that would signify to them that this person has that $5 bail because they're trying to get time served on that Class E. And it's supposed to be an amount that is not so big that a person who is houseless, who is kept over the weekend, if for some reason they had a higher charge and they resolve that charge, the $5, hopefully, I mean, if they don't have $5, they don't have $1, and that's an issue. They could file a motion to do new bail, but it's supposed to be something that allows the parties, the state and the defendant, to agree that the defendant, while he is locked up in jail on this other crime, is getting time served for whatever time he's serving on this Class E as well. I don't know. I feel like I'm definitely making a hash. I see Representative Moriarty.
Okay, well, let's do this. Thank you for endeavoring to answer our questions. I think I understand it, but I'm concerned about committee members. Let me just take a quick effort. So if somebody has been charged with a Class C and a Class E, and they are in jail, and there is no cash bail on the Class E, and the Class C gets dismissed because it was the wrong person, but there's substance to the Class E, the person who's in jail pre-trial will only get credit for time served on the Class E if there's some condition attached to the Class E. Is that right? Okay, and the $5
financial condition, yes.
And that $5 is that condition.
Yes.
Okay.
And so you wouldn't want the Class C to be resolved, and they've spent all this time in jail on the Class C, and it's dismissed because it was the wrong person, and then they wouldn't have gotten time for all that time they were in jail because there was no bail condition, financial condition on it.
So they could have been in jail for a month on the Class C, which they didn't commit, and somebody else has been charged with that. And unless there was the $5 cash bail on the E, if they were sentenced to 30 days for the Class E, ultimately, they would have to stay in jail.
Correct. Yes, correct.
Okay. Thank you. Let me take some other questions. Representative Babbage, is your hand residual? Okay, thank you. Representative Hagan, I think you were next.
Thank you very much, Madam Chair. I just had a couple of questions and then I'm ready to make a motion. The bail commissioner, what kind of pay do they get after this?
Currently, and after this bill, the bill doesn't change it. they get $60 for each bail bond that they fill out. And so, and it's paid by the defendant.
Okay, I thank you for that. And then this morning, as I was going through things, I was concerned with varying testimony from the, and my notes from the previous hearing on people who just don't show up. They just don't come back, as far as flight goes. What would you say to that?
I think we tried to address that in.
I might have missed it.
No, that's fine. Sorry, I didn't mean to. I don't know what's wrong with my computer. I think in section 3 and the sub paragraph 5,
yeah.
if they have a class E and they don't show up for court, a bench warrant will be issued for their arrest. And when they are brought to court under this change, the judge can then set cash bail on that.
Okay. Thank you.
Of course.
Go for it. And
go ahead, Representative.
I'd like to make a motion on this one.
Okay, go ahead.
Ought not to pass.
And is there a second on the ought not to pass motion? By Representative Poirier. And let's see, I feel like it would be behoove us to continue with the discussion and get answers to our questions, and then we'll move on to a vote on that motion. Representative Poirier, did you have questions in addition to the second?
I do have a question that I would like answered.
Okay.
I just would like to know how the district attorney would prove the imminent risk of willful flight. That just seems like something very difficult to prove.
Yeah, I think it's for folks who are going to flee the jurisdiction. So I don't know that it's any harder than failure to return to court, except for that what we're trying to do here is not punish people who are poor. So sometimes people don't return to court because they can't afford transportation to get back there, or their life is in chaos. And that's not a reason to keep someone in jail before they've been determined that they're guilty. And so this was a way of trying to ensure that that it's appropriate for prosecutors, if they are concerned that someone's going to leave, to put restrictions on that. But that's the condition that we're looking for. And I don't, in terms of proof, I don't know that it would be different than other ways that they're proving any of these conditions or any of these purposes of the bail code.
Okay.
Committee members, would it be useful to have Peggy screen share and go through the next section of the bill, which is section 4? Representative Harnett?
And if I'm out of order, just let me know. I'm still struggling with paragraph 6, and I don't know if others are or not. And I'm wondering if it would be helpful to have a criminal defense attorney try to explain it in a way that is simple and clear, because I think I get it, but I would not be able to explain this to somebody else. I don't think at this point.
So
Madam Chair, my hand's been up. I thought I was to follow Representative Hagan.
Okay, I'm sorry. Go ahead, Representative Moriarty.
And I agree with what Representative Harnett just said. I'm not beyond page 1. This is not the bill on which we held a public hearing on Friday. This has really taken a nosedive. I don't know why we're talking about concurrent sentences at all. This goes back a while, but my memory is that concurrent sentences, that if you're sentenced for 2 or more crimes, the sentences run concurrently unless the judgment specifies they are to be served consecutively. So I think it's a non-issue. On Friday, we were talking about a simple Class E crime, and one example was drinking in public. Something relatively insignificant, but a crime nonetheless. And I don't know why we just don't use that as the example of what this bill applies to and work our way through it and not digress into concurrent sentencing and a combination of felonies and misdemeanors. And we've really lost where we were on Friday. I don't understand this.
Thank you for those comments, Representative Moriarty. Representative Evangelos?
Thank you, Madam Chair. I'm sorry, my questions are simple, but I just want to make sure I understand the basics of the bill. So it's $5 plus 60, Megan, right?
Not necessarily. Yes, if it's, okay. Backing up. So section 3, the bail, sorry, go ahead.
I'm sorry, Megan Sway, let me just, rather than, if you could give the most streamlined answer to Representative Evangelos' question, because I am concerned that the committee is not able to address this bill this afternoon, and we do have to report back our responses to the budget in addition to some other work. And so I'm just concerned that we are not going to get to a place where we can understand the bill this afternoon. So if you could answer Representative Evangelos, and then we're going to head from there.
I agree, Madam Chair. I just want to make sure that if the person is indigent, they might have $5, but they might not have 65. So I just wanted the clarification on that. I don't care when we get the answer, if it's in your charge of that, but I just want to make sure I understand the mechanics of, okay, it's $5, Charlie, if you want, I'll turn it over, or wait a minute, I need 60 more. I don't have the 60. That's my question. I don't care if we answer it today, but I want to make sure that.
That I can answer. Answer. We put in the bill that if you can't afford $60, that is not a reason to stay in jail. That a person who cannot afford the bail commissioner fee should not be kept in jail because they can't afford that $60. And so that's in the bill.
So who pays the bail bondsman in that case? Nobody?
Well, there's a provision in the law that allows sheriffs to have a fund in case people can't pay, but I can't tell you how often that is used. I don't know.
Okay, thank you.
Okay, so question for you, Representative Talbot Ross. Is this the paragraphs 5 and 6 in section C? Are they things that DA Sarbeck raised, issues that he raised? And he is not here. And so I think we should consider a motion to table. I would like to hear from you, Representative Hagan, because you made the ought not to pass motion. And it seems to me that committee members are still quite confused about the bill, and that it would be helpful if we could continue the work session when DA Sarbeck is here.
I thank you for that, Madam Chair. I'm opposed to this bill, so I'm going to say that I would be opposed to tabling, but obviously it is important for people to get a better understanding and whatnot. I just haven't liked it from the beginning, so and all the way through, and I have studied all day long today. So I would vote in opposition to tabling, understanding that of course it would pass, and that's perfectly fine.
Thank you for understanding and for those comments. Senator Sanborn?
Move to table.
Is there a second? Seconded by Representative Cardone. And it's a non-debatable motion, so we'll vote on the tabling motion. And committee members, we have typically done a show of hands on a tabling motion, but on this one, I feel like it would be appropriate to have our committee clerk call the roll. And so Ms. Panett, if you could please call the roll on the motion to table. Oh,
Would you like me to call
yes,
the roll?
please do, Peggy.
Okay, I have a really old voting sheet, so bear with me with the changes. Senator Carney?
Yes.
Senator Carney votes yes. Senator Sanborn?
Yes.
Senator Keim is absent. Representative Harnett?
Yes.
Representative Harnett votes yes. Representative Babbage?
Yes.
Representative McCright?
Yes.
Representative Cardone?
Yes.
Representative Galgay-Reckitt? Representative Moriarty?
Yes.
Representative Sheehan?
Yes.
Representative Hagan?
No.
Representative Poirier?
No.
Representative Evangelos?
Yes.
Representative Newell? Okay, I'm going to call those that were absent. Representative Representative Galgay-Reckitt? Representative Newell? Both are absent. 1, 2, 3, 4, 5, 6, 7, 8, 9. Am I missing somebody? 1, 2, 3, 4. Obviously didn't keep track. I have 9 to 2 with 2 missing. Did I skip somebody?
I think that Senator Keim was also an absent.
Oh, right. Okay, 3 absent. That makes. This is why we hire Soupy to do this. I have 9 in favor of the tabling motion, 2 opposed, and 3 absent.
Okay, thank you very much, Peggy, for stepping in. Thank you, Representative Hagan, for your contributions to the conversation. And so we've tabled the work session on 1703. We will schedule that for as soon as we possibly can, and we'll try to ensure that DA Sarbeck, who brought up these issues, is here to help us understand them better. So that the work session on 1703 is now closed, and we will move on to the work session on 1577. The bill sponsor, Senator Moore, is here. And Representative Talbot Ross, we have you on the last one as well. So I'll just put you in the attendee space, if you don't mind. And we'll bring Senator Moore over. And Peggy, if I believe this is a bill that we have a proposed amendment on that the sponsor is not in agreement with, but if you could speak to us both about the bill and the amendment, please.
Sure. So the bill amends the Parental Rights and Responsibilities section of Title 19A to specifically provide for the law enforcement to help enforce a parental rights order. The Maine Commission on Domestic and Sexual Abuse proposed an amendment at the public hearing, and I did share that with Senator Moore, and she emailed all of you and noted that that was really not going to solve her constituents' problem. Senator Moore has since spoken with Lucia Chomo Hunt, who had worked on a revised amendment, which I think we distributed. If not, I can share it. And I must admit, I haven't really looked at the revised amendment, so hopefully one or both of them can speak to you about it, because I think there might be I think the wording might have changed Senator Moore's concept of that amendment.
Okay, Senator Moore, would you like to address the committee? And welcome.
Yes, thank you. Thank you, Senator Carney. And welcome. It's good to see everybody at the end of a long day. I know you're not finished yet we had a long day ourselves with the budget report back. Yes, when I first mentioned to you, yeah, this was a constituent request to put the bill in, so I was quite concerned about amending it and deleting everything that he was so passionate about and all the concerns that he had. But in conversation with Lucia Hunt and the most recent amendment, what she added as part of the working group and what we were asking the working group to do is she added the sentence that says the related issue of how best to enforce or timely modify existing child custody orders. And of course, child visitation falls under our child custody orders. So I am fine with this. It's not exactly what my constituent wanted. They're requesting the law enforcement to be able to enforce it, but I think it will be very helpful for the work group to take a look at it, and it may expand the opportunity for even other child custody orders and just taking a look at how do we go about enforcing it? Who does it? Who doesn't? How is it going to be handled? So I'm okay with the working group taking a look at it. It's a start, and I think that my constituent will be pleased with that, at least knowing that he brought it front and forward for us to really bring the matter to the front and look at what we can do as a legislature.
Thank you so much, Senator Moore. And we did hear from a number of proponents and opponents that this was an issue that needed to be looked at.
Right.
Let me ask, Peggy, do you have the most recent version of the language?
Yes, I think I sent it, but I do have it and I can screen share it if you'd like.
Yeah, I think that would be really helpful to the committee because then it's probably more efficient than us
trying to find it.
Right.
And we appreciate that you're more organized than we are sometimes.
Sometimes, not certainly not always. And I do know that Lucia Hunt is here and can speak to it as well.
Yeah, I pulled her over to the panel.
Okay. Right. So I think the language right here is and the related issue.
Can you go to the top, Peggy?
Yeah.
No working group. Okay.
Okay, to scroll.
Yep. So this document, we've seen everything other than the blue highlighted part previously. Right.
Not that title, Madam Chair.
Okay. All right. Would you like then let's scroll back up to the very just to give people a chance to read the whole thing. Peggy, if you don't mind.
Yeah.
Senator Carney, I will add that the committee amendment that came out actually amended the bill by striking out the title and inserting in its place what you're seeing right there on the page.
No.
Oh, no, it doesn't match. I apologize. I just saw that facing emergency situations. My apologies. I see what you're saying.
Right. So this kind of broadens the study. It was originally looking at just the working group shall study the issue of whether an ex parte emergency child custody process can be created within Maine's family law statutes. And this, I can, if you don't mind. So now it's the working group, it's this whole thing, including whether an ex parte emergency child custody process can be can be created, and the related issue of how best to enforce or timely modify existing child custody orders.
Thank you. That is very clarifying and helps us focus exactly on the purpose of the working group. Committee members, are there questions for Peggy? And thank you, Representative Moriarty, for pointing that out. Go ahead, Representative. Yes.
Okay, thank you, Madam Chair. The question, I guess, goes jointly to Peggy and to Senator Moore. I note there's a December 2022 report date, which means that the 131st would take this up in the spring of 23. The question for Senator Moore is whether her constituent is prepared to wait that long.
And thank you for the question. And my constituent has been very patient throughout this whole pandemic situation. And I feel that he would be very, maybe not as comfortable with it, but we were not going to be able to give him an immediate response to it. And he is able now to see his son on a regular basis. And, you know, it's been, but he's had some court expenses having to get an additional order. And finally, the ex-wife is actually following that, you know, so I think he's willing to live with this. I think he's just trying to solve the problem in the future for other situations. Thank you though for asking. I really appreciate that.
Sure enough, you're welcome.
Committee members, other questions for either Peggy or the bill sponsor? I think we probably are good with the screen share, Peggy, if you don't mind. So committee members, any other questions for Peggy or the bill sponsor? And Lucia Hunt has also joined the panel, but I don't know if anybody has questions for her, or we feel like we understand it adequately. I think we understand it. Is there a motion? Representative Harnett.
Thank you, Madam Chair. I would move ought to pass as amended to reflect the amendment dated May 25, 2021.
And is there a second? Seconded by Representative Moriarty. And with that, I see a bunch of hands up at this point. Representative Harnett, is yours residual? Okay. Representative Hagan, go ahead.
Thank you very much. I'm sorry, I got a phone call right at the last second. I missed the motion.
So this is Representative Harnett's motion ought to pass as amended based on the language that Senator Moore has presented to us this afternoon. And it was seconded by Representative Moriarty.
Thank you very much.
Would you like to see the language from this afternoon again? It's a little different.
No, I was watching and paying attention, and then I got a quick phone call and I was like distracted. It was bad timing. That happens, of course.
Right.
But I'm good, thank you.
All right, thank you. And Representative Babich, did you have a question or discussion?
Just a quick ask. In the whereases, the fourth whereas says this gap. I'm not really seeing a reference there. Can you help me with that?
I think the gap is about the only remedy for emergency custody situations right now is protection from abuse, which isn't always appropriate. There might not be any abuse going on, but that's how you get into court fast. So I think that's what that gap is, the need to address emergency situations.
And we heard about that from a number of people who testified on both sides of the original legislation.
But you know what? It's your bill. If you want to change the language, you can change the language.
No, it's not that. It's just that I'm not seeing the conflict stated above, but that's all. Just.
We can take a look at that. Representative Harnett, did you have?
That could be language review. Yeah.
I don't know if this will help Representative Babich. I think the gap, although we might find better wording on that, is that there is a lack of a process in the first whereas clause. There's been identified of a lack of a process to request temporary emergency custody orders. So maybe it's this lack of process is closely related.
So insert that instead of the word gap.
Yeah. I don't know if that helps.
Yeah, thank you. I mean, it's small, but I just thought it was unclear.
Okay, and Representative Harnett, would you welcome that as a friendly amendment to your ought to pass as amended motion?
Yes, I would.
Thank you. And is that acceptable to you, Representative Moriarty, who seconded it?
Yes.
Great. Okay. Other discussion on the ought to pass as amended motion on Senator Moore's bill? Not seeing any discussion. I think that we are ready for the vote. And Lucia Hunt, thank you for joining the panel. I've been moving you back and forth, but I'm going to send you back to the attendee space because I think we understand the bill pretty well. Thank you. And then Ms. Panett, I think we're ready. And this is, again, LD 1577 and ought to pass as amended motion.
Thank you, Madam Chair. Representative Babbage has his hand up. Is that? Thank you. Sorry.
No, thank you.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Kime. Senator Kime is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 2 members voting in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. And for those who voted in the negative, what is your report, please?
Ought not to pass.
Okay, thank you both very
Thank you.
much. And with that, the motion ought to pass as amended on Senator Moore's bill carries with a vote of 8-2 with 4 absences. Thank you so much, Senator Moore, for this legislation and for being with the committee this afternoon.
Thank you. Thank you all for all of your hard work. Have a good evening.
Thank you, you too. And with that, we'll close the work session on 1577 and open our final work session of the day on 1617. This is an act to establish and practice restorative justice. And we have an amendment. And Peggy, if you could please give us the bill analysis on the amended version of the bill.
Sure. So the bill was a concept draft, and Representative Talbot Ross brought in an amendment and it's about restorative justice. And her amendment was amending the definitions in the Department of Corrections title, which is where the Office of Victim Services works. And the Office of Victim Services is currently required as part of its responsibilities in working with victims is to assist victims with obtaining victim compensation, restitution, and other benefits of restorative justice. Well, restorative justice isn't defined in 34A or the criminal code. There is a definition of restorative justice program in the juvenile code in Title 15. So we tried to just copy that into the amendment that Representative Talbot Ross brought for the public hearing, but it didn't quite match up. And so instead of trying to define restorative justice program, we're just using the terminology restorative justice that will amend section 1001, which is the definition section for all of Title 34A. So now any place it's used in that title, which is the corrections title, this definition will apply. The definition itself is based on the language from the juvenile code, which it defines restorative justice program. So we just use the restorative justice piece of that. Restorative justice means a practice in which offenders take responsibility for causing harm and engage in a facilitated process with victims, family members, community members, or advocates and others impacted by the harm that focuses on repairing the harm, addressing needs, and preventing future harm.
Thank you very much, Peggy. And the bill sponsor has joined us again. Representative Talbot Ross, did you have anything you wanted to add?
No, I want to thank the committee for, again, for having careful deliberations about this bill. It's been a work of a couple of years by stakeholders and practitioners to make sure that we get a definition of restorative justice in the criminal code. We are committed to repairing the harm, and that means that I think it was a question during the public hearing, but what that means is all of those involved agree to come together and work out a way in which that we all move forward. So both the community and any other stakeholders in the situation, plus the person who has caused the harm or been accused of causing the harm, and any victims. And it is a place that I hope, Madam Chair, that we can eventually get to as a society, is to work out our differences in repairing the harm in ways that don't further harm and trauma. So that's the meaning of this bill. And we'll do more work on restorative justice and bring it back to this committee next term, as you know, through another avenue. Thank you.
Yeah, thank you so much, Representative Talbot Ross. Committee members, are there any questions first for Peggy? Go ahead, Representative Hagan.
Thank you very much, Madam Chair. Just a few questions that I had during the public hearing. One was, when the victim doesn't want to meet with the perpetrator, as it were, or whatever word I'm looking for from TV.
So that
we
may
just go to the regular thing, right? The regular.
Go ahead, Peggy.
Right, that's my understanding, is that it has to be an agreement of everybody that's involved. So if the victim has no interest in going forward with meeting the perpetrator, the actor, the defendant, whoever it is, then it doesn't happen.
Okay. And then may I follow up? Go or no? Go ahead.
Yeah, I think Representative Talbot Ross just wanted to add something to that answer, and then you can ask your next follow-up.
Okay, thank you.
Thank you, Madam Chair. Just very briefly, if you look at where we're referencing, the statute, it reads that the duties of the victim services coordinator and other victim advocates. So, Representative Hagan, one of the duties already. This is already in law, that we assist victims with attaining victim compensation, restitution, and other benefits of restorative justice. So to answer your question more specifically, the victim is driving the decision-making in terms of whether or not a restorative justice component will be part of the resolution of whatever's going on. So the victim drives that decision-making for the most part. Thank you.
Thank you very much. And am I to remember from the public hearing that this deals with class, I want to say A, B, C, D crimes?
I don't think it's limited to any particular crime. Restorative justice doesn't mean you don't get a sentence.
Can you explain that?
I'm sure Representative Talbot Ross could do a better job. I will take a little stab at it, and then she will correct me. Restorative justice is the process to identify what the harm was, why it happened, how trying to get the community to move forward. And sometimes there's nothing in restorative justice that says the person who committed the crime does not serve any kind of penalty or punishment. That might be the outcome.
So if I committed A or B or C, the person was offended, in whatever terms we would use, they're okay with it, then I don't receive jail time?
I don't think that's necessarily the case. If you're talking about like a diversion program or this can be part of deferred disposition. But even in deferred disposition, if you if you meet all the requirements, there sometimes is, depending on what the crime is and how serious it was, there might still be some kind of a sentence, whether it's community service or imprisonment or.
Okay. Yeah, keep going, sorry.
And I just want to double check and make sure that, I mean, I'm not the one with experience in working with these programs, and Representative Talbot Ross is.
All right. We use them in school, it works well, but with these big crimes, with arson, rape, or murder, or whatnot, I was curious about if the victim feels, okay, I'm okay. After this process, do we reduce any kind of jail time that would have happened normally?
Let's let the bill sponsor respond to that. Thank you for the
I
question.
just don't know.
Yeah, no, thank you, Madam Chair, and thank you, Representative. There's quite a bit to unpack there, though. So restorative justice is both an ethos and a tool. So it is just one more tool, Representative, that we have in which to address a situation, whether that's criminal or it's in any other vein. Yeah. It is just it's an additional tool, but it doesn't supplant all of the other tools. It doesn't supplant adjudication. It can through diversion, but it's one more tool that's available to both the victim, the person who's been charged or named or accused, for the community to take advantage of. It's just one more tool. And so to the degree in which the tool gets used, that's not this bill. I mean, I can't tell you that someone's going to get off on a Class A crime because we define restorative justice in the criminal code. That's not this bill. All this bill does is give us a working definition. And so whether it's applied to prosecuting someone, I can't tell you that it will ever be used to prosecute, to supplant prosecution. I can't tell you that it would ever be used to supplant a juvenile adjudication, or we're not there and we don't make those decisions. This bill won't touch any of that. It just provides a definition within the criminal code for what restorative justice is. The use of it is something completely different, not this bill.
Okay, and can I keep going, or should I could wait. Other people have their hand up, so I could back off and continue later.
Okay.
Thank you.
Yeah, thank
you
you
very much, Representative Talbot Ross.
And just to clarify, it's Title 34A, which is actually not the criminal code.
Right.
Yeah.
Corrections, I'm sorry.
Yeah, no, that's okay. The correction, want to make sure that we're all understanding the whole situation. Okay, Representative Moriarty, go ahead.
Thank you, Madam Chair. That was the very first point I was going to make. Peggy, we're not amending the criminal code. We're amending, I think, is the Victims Services Statute.
We're actually amending all of this is the general definition section for the whole title.
Well, what is the title called? I don't know it.
Corrections. Title 34A is called corrections.
Okay. So this has nothing to do with the sentences that can be imposed for any of the crimes defined in the criminal code.
Correct. It is how the only place it's currently used.
Wait. Just, sorry. I think I can make it easier. All we're doing is putting in a definition for a term that the statute already uses.
Correct.
Right? Isn't that it?
Yes.
Okay. I think that's all we need to say.
Thank you, Representative Moriarty. That was a very succinct way of presenting the kind of the meat and potatoes of this bill. But I do want to open it up because I know that there may be additional questions, particularly Representative Hagan may have additional questions. Committee members, are there additional questions? I am not seeing any additional questions. Representative Talbot Ross, did you wish to be heard on anything before we wrap up our work on this bill?
No, I appreciate, again, the discussion, and I apologize. I'm staring right at the statute for corrections 34A, so my apologies for that. But we literally are doing exactly what the Representative Moriarty just said. We're putting a definition in, and my apologies if I help lead us down any rabbit hole, I guess. But I thank you.
Yeah, I don't think you led us down a rabbit hole. I think it's after 5:30 on a very long day, after a very long session of committee work. And so we're all supporting and helping each other out. So thank you all for your role in doing that. And so committee members, is there any more discussion on the bill? Questions? Go ahead, Representative Moriarty.
Madam Chair, I move ought to pass
As amended?
as amended.
Representative Sheehan?
Yes, as amended, yes.
I second the motion.
Okay. Is there any discussion of the pending motion? Okay, any additional questions before we move on to a vote? Okay, so the motion on 1617 is ought to pass as amended, and the amendment is the definition of restorative justice that will be inserted into the corrections statute, defining a term that is found in other places in that statute. And any discussion? I think we're all set. And Ms. Panett is here to take our vote, so we'll move on to a vote. Thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Till I can get my brain wrapped around things a little bit better, I could change my vote in the big house, as it were. But I'm going to go no for today.
Representative Hagan votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell. I will recall the absentees. Senator Keim. Senator Keim is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 1 member is voting in the negative, and 4 members are absent.
Excuse me. Thank you very much, Ms. Panett. And Representative Hagan, can you please just let us know what your report is?
For now, until I have a lot more work to do in my head as far as all this goes. And I'm going to go ought not to pass, and then I could easily turn on that one. So more research for me.
All right. Thank you very much, Representative Hagan. And so with that, we'll close the work session on LD 1617. The motion carries 9-1 with 4 absences.
Thank you all very, very much. I hope you have a good evening.
Thank you, Representative Talbot Ross. And committee members, we have one more piece of work to do. We owe the Appropriations Committee our report back on the budget. And so let's move into that. And I know that it's been a long day and we've all been working on a lot of different things and pulled in a lot of different directions. Sam and Peggy have both been working really hard to distill and get us the budget information in a format that really is digestible. And I would just like to highlight, I know that Peggy emailed this chart to all of us, the colorful chart, and I found it extraordinarily helpful. And if you have it, it might be a good idea to, actually, we could even have Peggy screen share it. If people, do you think that's a good idea, Peggy?
I'm happy to. Sure.
Let's do that. I think
That
if
easiest. Okay.
we're all oriented toward one screen, I think that'll help us rather than juggling. And Peggy, did you or did Lauren want to walk us through this? Or I can walk people through it too.
You know what? If Lauren is prepared, Lauren's been working hard on absolutely everything. If she's prepared, I don't know if she can walk you through the chart. She might be able to better walk you through the actual pieces of the change package. So I sent you 2 documents. One was the chart and the other was the actual pieces of the change. Oh, look at that, it just disappears. Of the change package itself. And so, and Sam's here too. So I'm not sure what's easiest to do. Is it to walk through the chart? The chart, Sam lined up the initiatives with, that's what the change package, that first column is.
Okay, well, first of all, we are so lucky to have so much support to get us through the budget report back. Thank you all very much. Let's see, who would like to take the lead on presenting this? Lauren, are you able to do that, or should I be walking people through it?
I wasn't necessarily prepared to walk you through it. I'm happy to do that, but it might be a little clubbed together.
So I do think Sam has probably spent more time on it than the other 2 of us. That doesn't mean it's a whole lot, but
yeah, Sam. I was just going to turn to him. So Sam, would you like to?
Yes, I'm happy to do that. So the way I'll do it,
do you want to switch so you share the screen, Sam?
Oh, sure, I can do that. Yep. Let me. I have a lot of windows up. Let me see.
Yeah, stop sharing, Peggy. Did I stop?
Yep. Can you see it now?
Yes.
Okay. All right. So you're kind of working off 2 documents here. This first one is the document that provides a roadmap to all of the initiatives and language sections that fall under the purview of this committee. The second packet you'll see, and I'm just going to do a quick switch to the next screen so you can see what I'm talking about, is this. So if you look on the left here, you'll see the number of the initiative, and that corresponds on the little chart here to this number. So I'll just walk through it one by one. So is the committee, would the committee like to vote on each initiative? I know different committees have been handling this in different ways. Some have been voting on each initiative, some have been just focusing on specific things. So I wanted to check first how you wanted to proceed. I could also just go through everything first.
Sam, as a member of AFA, sooner or later, would you please vote on each initiative? That's how we go through it, and that's how we discuss them. and that's how we address them, is by initiatives. So just to have sort of one total blob is not all that helpful.
Senator Carney, I think you're muted.
Thank you, Sam. Thank you so much, Representative Cardone. So let's go through we'll vote on each initiatives. I think for us to have, Tom, I'm just gonna tap into you as co-chair. Do you think it makes sense to vote serially, or to go through the whole packet and then go back and vote?
I think serially, because I think that we've already done that to a certain extent, I thought.
Yeah,
And
all of this is
I had my hand up for a question. I'm not having trouble pulling up the chart, but I am having trouble finding the email with the change package that it's compared to, with the what we've already voted on, the document that Sam showed prior to this one. Am I making sense?
This one?
This one, yes. Where can I find that?
It's came in at 4:01 yesterday.
Okay, thank you.
And it may have a different, the first couple pages may be a little different, if I'm recalling correctly.
And I did post it in the Google Drive if that's any help.
Well, Tom, what we'll do is we'll toggle back and forth between the two. So we're going to take each initiative and we'll vote after Sam walks us through each individual one, and he'll screen share so that we can follow along with the initiatives. So Sam, do you want to go ahead with one?
All right. So the first initiative is for the AG's office, and this provides funding to continue one limited period research assistant MSCA B position in the criminal division. And I'm going to toggle to the other page here. So you'll see this initiative here. You'll see the appropriation here, and you'll see that this is through the federal expenditures fund. And you'll also note this position was previously continued by financial order and is scheduled to end on June 10th, 2023.
Committee members, are there questions about this? Go ahead, Representative Hagan.
Thank you very much. Can you make that a little bit bigger, Sam?
I think I can, yeah.
Okay, I just can't see. Thank you.
Let me get rid of this there. There, that's better.
That's perfect. That was a great and easy to answer question, Representative Hagan. Representative Harnett, did you have another question? Okay. All right. Are there any questions about Initiative 1? And so this, Sam, this comes out of the Federal Expenditures Fund primarily?
Yes.
Okay. Committee members, are we ready to vote on Initiative 1? If you're not ready to vote, please raise your electronic hand. Okay, it seems like we are ready to vote on Initiative 1. And so Sam, I think if you could end screen sharing just for a moment while we do the vote. And Representative Cardone, is it preferable that we do okay, and Ms. Panett is here, we'll do a separate roll call vote on each one.
I don't care whether you do a roll call or just a raise hand, but to have a breakdown of the vote for each initiative is the most helpful.
Okay, let's try it with the raised hand initially, and if it gets cumbersome, we'll do it a different way. But for those who are in approve of Initiative 1, raise your electronic hands, please, and keep them raised. Okay, so and then just leave your hands raised, please, until after Ms. Panett lets us know that she's been able to record.
I have 8.
Okay. All right, and we can lower our hands and then thank you very much. And Sam, if you want to go on to initiative 2, I think we're ready for that.
Madam Chair, do you want to take opposed?
Oh, thank you. I assumed that there were 2 opposed,
Heather,
but
your hands up.
so for those who are opposed, please raise your hands now, your electronic hands.
Thank you.
Thank you. And thank you for, all right, I think we're all set and we'll move on now to initiative 2.
A little bigger as well. So initiative 2 is also with the AG's office. This establishes one assistant attorney general position dedicated to supporting the Department of Labor in ensuring compliance with state labor laws and protections. I did try to go back and look in the biennial what the recommendations of the committee were in the biennial for related initiatives. So there wasn't quite the same initiative in the biennial. There was, however, if the committee will recall, a proposal to add an AAG for workers' comp litigation, as well as a paralegal and legal secretary. There was discussions with the AG's office and it was determined those were not needed, and the committee then therefore voted for the proposal 0 to 13. So unanimously said, recommended that it not go forward. That does appear to be different from what I can tell than the DOL position that is proposed here, but I did just want to note that just to remind the committee of some related history.
Sam, my understanding is that's also a different position.
Okay.
For what that's worth.
Yeah, I understand it has to do with enforcement of wage and hour laws.
And then you'll see here that you'll see the numbers there in the initiative. And other special revenue funds.
And can you remind us, Sam, what other special revenue funds means?
It means it comes from somewhere else, and maybe Representative Cordone can help me with that a little bit.
There are several other special revenue funds, but it means it doesn't come out of the general fund, which is the fund that we're all worried about. I don't know whether this one, exactly where this one comes from. It isn't federal funds, but I know that there are special revenue labor funds. I don't know that it's new money or maybe existing money, but it doesn't come out of the general fund.
Ms. Mater, do you have some additional information?
Sure, if you'll allow me. So other special revenue funds, that's essentially an allocation. And so it allows the Attorney General's office to spend up to that amount. And they can receive funds from the other state agency. In this, it looks like it's the Department of Labor to pay for that allocation. And where those funds come from is not clear from this initiative. They could very well come from the general fund within the Department of Labor. And then they're sending that to the Attorney General's office. So I just wanted to make that clear that there could be an impact on the general fund. It's just kind of in another department. This specific initiative, I'm not sure, but just to clarify that one point for you.
Thank you. That's helpful. Representative Moriarty, I think you had your hand up next.
A question, Madam Chair. Why isn't this before Labor and Housing?
Because it's an expenditure within the Department of the Attorney General, which is within our jurisdiction.
Okay, and are we actually voting on an expenditure, or has that been withdrawn?
We're voting on approval of an addition to the budget in the change package that has been proposed. So this is an addition to the budget.
Attorney General's budget. Yeah.
Okay, I guess I understood the Attorney General changed his mind on this.
No, that was the workers' comp when they were going to take in-house some workers' compensation work. So this is totally different. If you look at the blue column is the biennial budget, but what we're focusing on is the stuff in the green, the column with the green header.
All right. Okay.
Yeah.
Okay. Thank you.
Thank you. That was a good clarifying question. Representative Harnett?
Thank you, Madam Chair. And this is a question for Lauren. The OSR here, the other special revenue, this is just another example of the AGs. Certain departments fund certain assistant attorneys general positions in the Attorney General's office, like DEP pays for a group of attorneys. This is another example of that, right? But it's being paid by the Department of Labor.
Yes, yes, that's exactly correct, at least as I understand this.
Thank you.
Okay, so so it's the Department of Labor is sending money to the Attorney General's office to hire an attorney to work on wage violation issues. Okay, thank you. I think we've figured it out, team. All right, is the committee ready for a vote on Initiative 2? We'll follow the same process. If you are in favor of Initiative 2, raise your hand and leave it up until we've heard from Ms. Panett that she's done all the counting. All right, so there's 7. All right, and then those who wish to vote against the initiative, please raise your hand. Okay, so we have, yeah, I didn't put down my hand either, excuse me. Okay, and so there are 3 opposed. Thank you. All right, and I think we can move on to Initiative 3, Sam.
So Initiative 3, we're on to the Maine Human Rights Commission. So this initiative would provide funding for increases in technology and general operating costs. So you may recall the governor's biennial budget did propose funding for increases in tech and general operating costs, and the committee did vote 10-1 for the initiative with a revised budget. That was ultimately not included in the biennial budget. And I'll switch over so you can see sorry, a lot of scrolling. You can see here the funding, part from the general fund and part federal expenditures. And I'll stop share so you can talk to each other again.
Thank you. And I do think we have Melody Piper from the Human Rights Commission, who I will bring over to the panel in the event that there are specific questions. Committee members, are there questions about Initiative 3? Melody, did you have any additional information about Initiative 3 that we should hear about before we move on?
Good afternoon, members of the committee. I'm Melody Piper, Operations Director of the Human Rights Commission. On this particular initiative, I really do not have any new information except that the increase is necessary for us to maintain operations. Move over. I think this was the technology initiative.
It is.
Yes, that's necessary for us to begin leasing machines from the state and purchasing software or joining the Office 365. The commission hasn't in the past done that. Every other agency, I believe, already does that. But we've tried to do it in-house and it's just no longer possible with our limited staff. So this initiative addresses that need. I hope that answers your question. Thank you.
Thank you, that does. Committee members, are there any questions for Melody Piper? Go ahead, Representative Babbage.
Yeah, I just want to make sure, what's the total amount we were voting on, the revised and current? I just want to understand that, if you could.
Let me pull it back up again.
Thanks.
But these are modest amounts, but I just want to know what precisely we're.
All right, so the current at the top here, sorry, I should have shown you the revised, that's important. So the revised totals are right here. And actually that is all general fund, sorry, in the revised, I apologize.
And so it's the 34,996 that we're voting on, Sam, is that?
Yes.
Thank you. Thank you for the question as well, Representative Babbage.
Thank you. Okay, gotcha.
Representative Harnett?
Thank you. And I think I'm just suffering real late day fatigue here. Sam, we voted on this 10-1, correct?
Yes.
Were we voting on the revised number or the?
That's a great question. I don't have the packet in front of me. I should have gotten that out.
Right. So if I could just, this was a pretty difficult part of the budget earlier this year, and Melody worked with us quite a bit to try to make this happen. My understanding is the administration wants to support the changes that the Judiciary Committee voted for. It's moving some funds around between federal expenditure funds and the general fund. My understanding is that what you supported is basically what shows up in the revised.
So we voted 10-1 on the 34,996.
I believe so. I'm pulling that packet up right now. Because you had to rewrite all the pieces of the Human Rights Commission from what was included in the original budget.
And what was included in the original budget is what's referred to as current? I'm sorry.
I believe so. I believe so this is a change package. It starts with what was listed in the budget, and that's what current is. And this is what the change package is asking you to approve is the revised piece. So you'll see some of the other pages say delete or add. This one is revised.
And so current has already been proposed and accepted and voted on. And so no, okay.
It was already proposed, but I don't believe it's been accepted and voted on and accepted.
Okay, thank you.
Those were the pieces that were not included in the budget that was enacted in March.
Thank you.
And understand that current and revised go to the numbers below, not the ones beside or above. Yeah.
Correct. Yeah.
All these little things we don't think about when we're designing information.
Yeah. And I just want to highlight something that Peggy said earlier, committee members. The initial budget proposal was not workable because, as Melody Piper said, the Maine Human Rights Commission desperately needed to make some pretty significant technology changes. And so when we were doing the budget work in March, we essentially rewrote the initiatives related to the Human Rights Commission so that the numbers worked out so that they could do the desperately needed technology changes. And so these initiatives that we're voting on now, I believe, particularly number 3, still relates to those urgently needed technology changes. Representative Babbage?
Oh, no, I'm good. Thank you.
All right, so thank you, Sam. So committee members, is everybody ready to vote on Initiative 3? Again, these are the necessary technology changes that the Human Rights Commission requires. And let's do it by a show of hands again. So those who are in support of Initiative 3, please raise your hands and leave it.
Senator Sanborn, you need to be on screen. I apologize. Thank you. 8.
That's what I have.
Okay, so let's all take our hands down. And then those who are opposed, if you could raise your hands and leave them up just until we tabulate. Representative McCray, are you? Okay, great. Thank you. So the vote on initiative 3 is 8-2 to approve. We'll move on to initiative 4.
And I did just, while you were voting, I did pull up your biennial budget report back so that we can reference that if we need to go back and check what those votes were too.
Thank you.
I think it starts on 39.
Yeah.
Right, you got it. Okay.
Yeah.
Thank you, Sam.
So we are still with the Maine Human Rights Commission in this initiative number 4. We'll continue the administrative reorganization of a senior paralegal position to a paralegal position, and to a part-time paralegal position, reducing the hours from 80 to 64 hours biweekly. So the biennial also proposed reorganizing a senior paralegal position to a paralegal position, and also reducing the hours from full to part-time, and the committee did vote 10-1, but again, you revised the budget in your report back. So just tab it smaller so it fits. So here you're also looking at a revised, and you're looking at a savings because it is a reduction in hours for this employee. If you would like to go and compare those to the numbers in the report back, we can do that too. Would that be helpful to go check that in the biennial report back?
Committee members, if anybody is interested in looking at the report back, could you raise your electronic hand so we can jump over to that?
Sure.
Go ahead, yeah, thank you, Sam.
So this is going to be at the end there, right, Peggy, because it's the revised version.
Yep.
Yeah.
Right, I think it's page 40.
I'm almost there.
Uh-oh, your numbers are different than mine.
Yeah, of course they are. All right, I think they're.
I wrote, it says 40 on the
at
page.
the bottom, I see.
In the corner.
Perfect.
Yeah.
That's very useful. All right, so that's right here. It's right
The
there.
numbers don't exactly match up.
They're close, but not quite. So 25,889, 26,227 compared to 23,340, 23,544. So close, but not exactly the same. And again, your vote on that was 10-1. So, and I can go back to any of those documents if that's helpful.
Committee members, does anybody have any questions for Sam before we stop the screen sharing so that he can refer?
I mean, just ballpark, the original was to reduce hours to part-time, which evidently would have been 40 to 45 hours. We're reducing it to 64 with that much less of a savings, right?
Yes, that's correct. I would like to say.
Jump in, Melody. That's good.
Yeah, we determined that we do need to make a reduction for some savings in the budget, but our commission council still needs significant amount of support. So we did change the reduction and make it so that she had a little more support from somebody. And also it makes it a little easier to hire somebody for that position, make it more attractive as well as the fact we need it. Cause yeah. So I hope that answers your question.
Yep. Thank you.
Thank you.
Representative McCray.
Thank you, Madam Chair. I'm obviously coming in late to this, but I guess I don't understand reducing a position here when it seems like there's a need for more support, not less. Is there a quick answer to that?
Melody, you were able to help us with that?
I think, yeah, sure, I can try to address that. The commission was trying its best to come to the committee with a minimal request for help in our budget, and some of the initiatives that we presented, I think Peggy might remember as a whole, the whole package. We tried to really keep it across the board, an even impact. We could always use the position. Of course, we always need new staff, but we definitely, more importantly, need some of the other things that were in our initiative, such as the technology. And we were concerned that because of, the current economy and everything, that any request may be denied. So this was our best effort to come to you with a reasonable request. So that's why this position was reduced in efforts to help out with some of the other initiatives.
Thank you for that. I will obviously go with the will of the committee who's been here, but I'm remembering from my time on judiciary how difficult it was for the Human Rights Commission to do its work because of the lack of support.
That is definitely the case, and we would not cry if you didn't. Obviously, we would not be upset if this was one particular initiative that you didn't agree with. It's just that combined with the other initiatives, we really just needed the technology and some of the other initiatives to be supported. And they were all kind of part of our plan to make that happen, but
yeah, they were kind of a package deal, as I recall.
Yeah, but however, I mean, this isn't, if you're willing to accept the other items without elimination or partial elimination of the hours of this position, I should say reduction, we wouldn't be upset. Put it that way. It would be helpful. We really do need support. We have a lot of cases pending litigation right now. Our commission council is overwhelmed with cases, including cases from housing discrimination, and we really could use the full-time paralegal. However, we still really, really need the technology funds. So,
And you're reclassifying some so that you can keep current staff, right?
we're reclassifying. You're not talking about this particular initiative?
No, but I mean, your total budget, if you're looking at the entire Human Rights Commission budget,
Yeah.
what you're trying to achieve is reclassification and technology.
Yep. There's a couple different things that we're trying to do. Try to self-fund as much as we possibly can without an ask.
Right.
So they're all kind of tied into each other. And I don't believe we have a chart anymore that showed my original submission, which was everything kind of lumped together to kind of, I shouldn't say, to demonstrate what we were attempting to do, which is a break even, which was somewhat impossible because all of our positions are split funded. Most of them are split funded, but yeah, so it is a package deal, but again, it wouldn't hurt to have this position stay at full time.
If I could say, as far as AFA goes, it's not necessarily a package deal. And this cut was questioned in AFA as well.
I mean, yeah.
Right.
It wasn't I mean, it was a plan, basically a budget plan, I should say, as a package deal, trying to come forward with an ask that was reasonable, not increasing our general fund significantly.
But you're also so far behind on everything, on the work that the commission is doing, that it is not unreasonable to be asking for a full-time senior paralegal.
No, it's not unreasonable at all. We just do know that as far as right now, I think I've testified to the committee that I'm trying to keep up with the technology needs of the commission single-handedly. And, that is not my primary responsibility, but the ask for technology was it was greater to make sure that there's no work stoppage for our staff. One person is not able to keep up with the ongoing demands of 14 computers breaking down at all times, including during budget hearings. So that's why we really wanted to make sure that we were able to fund the technology, and some of the other things we were able to make some adjustments with. But I would agree that we definitely could use this position staying full time, but we just really want to make sure we can get the other initiatives support for those as well. Thank you.
Thank you very much, Melody. And Representative Cardone, that's very helpful information. Representative McCrate, you've had your hand up for a while. Go ahead.
Well, thank you. Just to follow up, I was going to ask Representative Cardone for her take from appropriations. Again, I'm new to the party, but I would love to see us support this position staying full time.
Then vote it out. And if you've got a majority vote out, I can't tell you what the Republicans will do on AFA, but the Democrats will support that out vote.
Okay.
It doesn't hurt you to vote it out at this point. The worst that can happen is that it'll get put back in.
Thank you, everyone, for that good in-depth conversation about Initiative 4. Is the committee ready to vote on Initiative 4? It looks like we are. And so all who are in favor of Initiative 4, please raise your electronic hands. Oh, Sam, go ahead.
I just wanted to just clarify, and maybe Representative Cardone could help me with this question. So if the committee votes not in favor of this initiative, so there's kind of two things here. There's the current and the revised. They would need to make clear what their actual intent is, whether they want the current, the revised, or to do away with either of them altogether.
Good point.
Yeah, do it. Make clear in your notation that if the vote is that this should stay as a senior paralegal position, make that clear in your vote notation. Yeah.
Thank you.
I mean, I'm your rep on AFA, so I'll know that. But it's clear if it's clear from the report back, that's all the better.
Thank you.
And so so would it be, should we vote on both the current and the revised, or should we simply vote on the revised and indicate that we are not supporting any cutbacks in these positions?
I think you can do that.
The latter?
Yeah.
Okay. All right. So committee, did somebody speaking?
Melody, I just wanted to clarify one thing. The position was reduced to a regular paralegal, given it initially had been given supervisory responsibilities of another paralegal. That position is being addressed in the budget, and it will it's no longer a senior paralegal. But other than that, everything else you've said is correct. Sorry.
All right. Thank you very much. Representative Harnett, your hand is up. Go ahead.
Thank you very much. And again, I apologize for being so confused. Melanie, what you're asking us to do is to not reduce it by 50%, nor to reduce it to 64 hours, but to keep it fully funded at 80 hours for 2 weeks. Is that?
As a paralegal.
As a paralegal, not as a senior paralegal, but as a paralegal. Is that correct, Melody?
Sorry, I lost Zoom for a second, but I believe what you just asked is just rewording it so it says paralegal instead of senior paralegal.
And you wanted it 80 hours every 2 weeks, not 64 hours, correct?
Well, I mean, if yes, definitely, as long as it doesn't burden the other initiatives, because again, we're in a dire situation where that is as important, but so is the technology needs that I can no longer perform on my own, like in 40 hours, given everything else. So yes, we definitely would like this.
What I think I'm hearing from Representative Cardone is we can't think of them as a package deal. We have to vote on the initiatives individually. Is that correct, Representative Cardone?
Yes.
So if we want it to be 80 hours, that's what we're voting for.
Yeah, the danger is we do not want the current to be the default to rejection of the revised. So I really don't see an objection to making sure that the votes against, for those of us that are going to vote against this, are recorded in both places so they know there are no cuts to this position. But, you know, whatever.
Representative Cardone, is it meaningful to the AFA for us to vote on the current as well as the revised? Or if we just vote on the revised and provide explicit direction, is that going to be adequate?
I think so. I think the latter is fine. I know what you mean. This isn't anything that was already voted into LD 715. So they're both sitting out there. You don't need to go take a revote on the current, I don't believe.
All righty, thank you.
I mean, on the earlier package.
Right.
Okay, great, thanks. Representative Moriarty?
Thanks, Madam Chair. I'll try this. I see a number in parentheses, which usually means a reduction. Are we voting to reduce something by $23,000 plus?
No, you're voting to eliminate the reduction.
Yeah.
If you vote this out, you're voting to eliminate the reduction.
But to keep it funded as it is currently?
Yes.
So what we're
couldn't this say it more clearly than that?
So Representative Moriarty, the proposal in the change package is to reduce this position. And what we're talking about doing is rejecting the reduction and requesting that the position be fully funded.
So no net change. No change then, basically.
You vote no for no change, right?
Yeah, I mean, well, well.
Yes for no change, don't you?
Vote it out.
Let's take the votes and we'll be
voting against this initiative in order to save the position.
So if
that right? Okay.
Yeah. If you use the word vote out, if you want to save the position, vote this initiative out of the change package, out of the budget. That will mean something to AFA. And use the word voted out.
Okay. So let's do this, because I think it will be clear as we walk through this. For those who are not in favor of the reduction proposed in revised initiative 4. So if you are not in favor of reducing this position, raise your electronic hands and leave them up. Okay. And now let's all take our hands down. If you are in favor of maintaining the reduction, please raise your hand and leave them up until Soupy is able to tally. So you're in favor of the reduction, Representative Cardone? No, okay.
Double hit.
So it's 1 to 8, really.
Representative Hagan has not voted yet.
It's talking on the phone.
Okay. Okay, so it's 1 to 8. And then for those who voted against Budget Initiative 4, is our report back to AFA that we want this position to be fully funded at 80 hours biweekly without burdening or reducing the other initiatives. Is that correct? Seeing lots of nodding heads. Is that an adequate report out, Sam?
Just that I think, if I'm correct, it should be as a paralegal versus a senior paralegal, correct?
Yes, thank you. That's exactly right.
Thank you.
All right. Everybody okay with that?
Yep. Initiative 4 is out.
Okie doke.
So initiative 5, still with the Maine Human Rights Commission here. I'm going to go a little slowly here and make sure I get this right. I'm sure Melody can correct me if I don't. So this initiative would provide funding for the approved range change of 6 investigator positions from a range 24 to a range 26, retroactive to August 2018. So in the biennial, this also proposed reorganizing 1 main human rights investigator supervisor position to a main human rights investigator position. It also proposed moving 6 investigator positions from a 24 to a 26, also retroactive to 2018. So the committee, in your recommendations, voted 10-1 for revised initiatives, including reorganizing 1 supervisor to investigator, but with a revised budget and funding for the prospective range changes for 6 investigators, with 1 of those also being retroactive to August 2018. From what I understand, the reasoning for that was because these were, except for the 1, management initiated range changes, which means that they cannot be retrospective as employee initiated range changes can be. But I think somehow that got lost in translation in the change package. And it may be that Melody has better or more information on this, because I think this got a little mixed up in the process somewhere along the line.
Yes, I can, so this is the initiative related to, I believe when we wrote what the committee had 10-1 voted for. However, the reason the budget, the governor's budget didn't reflect the same information from what the our budget analyst had said is she was confused about what the committee had voted 10-1 on. So she did not enter it in accurately and actually put the federal expenditure lines in there, which we already had said we did not have. So this is just this is essentially just, it's what you've already approved. It just clarifies, we're addressing that the budget analyst, and she was willing to acknowledge this, that she failed to bring this to the commissioner and the governor's attention when she put in their recommended budget. So the general fund is supposed to 100% fund this initiative, as well as the budget analyst recommended that we need to say it reallocates. The language, there's a second sentence I added in there just so that when the Bureau of Budget gets this initiative, if it's approved, it gives them the authority to go into the position detail record and reallocate some of the positions that are 100% federal, to give them a 5% general fund allocation so that it can be funded across the board. Otherwise, we'd end up with 2 investigators that would not. So basically the other two out of the 6 investigators would have no funding for this action because we do not have the federal revenues at this time to support that. I hope that clarifies it a little bit. You already approved this. The intent was there, and the Bureau of Budget had an error when they entered it in and acknowledged it. Right. And we're also clarifying the language and the amount you already approved in your 10-1 vote. It just didn't get entered in right.
Right. Sam, if you go back to the document you were just in with the initiatives, Melody had submitted to the committee. It's on page 14 of that packet. What it should look like. Yeah, okay. That's page 3. Yeah, there you go. So that's what it should look like, right, Melody?
Yes, that's correct. The one that says proposed to JUD, that's basically what the vote was that the 10-1 already represents. And plus 1 sentence, the reallocation language has to also be added in, or they would get this and they couldn't effectuate it. Essentially, they couldn't make it happen. Budget being they. Thank you.
Okay, so should we be voting then on what is on the screen right now rather than the document we were looking at a short while ago?
I think so. So this is a revised change package. And Melody's been working with the Bureau of the Budget to get this right. They hadn't gotten it right at the time the change package had been published.
Thank you. Okay.
Yeah. And I think that what you have on the screen right there is definitely what they've recommended from the Bureau of Budget. That's how this should look. And it's not different than what was already voted on, except for the additional language that reallocates language. Didn't change the amount. It's just more authorizing language for the Bureau of Budget to actually go and touch the position detail records to make changes.
Okay.
What you're seeing there is merely the combined totals of what's on the page, but it's all general fund, right?
Which is what you voted on. Yes, that's correct. And the Bureau of Budget, between the first submission the commission had, when we just said we just don't have the federal revenues to support this. And now, yes, that is the difference. It's the federal revenues are being, we're basically putting everything in the general fund.
Right. Same numbers. It's all
Yep.
general fund. Yep.
And the Bureau of Budget didn't realize that when they entered in the change for the governor's recommendation. So that was the error that was made, is they did not go in and make it was a little bit of a legwork to make the entry work, but it's the same exact initiative basically that you've already voted on, just with that added language.
Okay, so let's, Representative Harnett has his hand raised. I would like to give him the floor. Go ahead, Representative.
So again, I'm looking at page 3, and I think Chris might have just answered for me. The revised numbers on page 3 are the numbers we're voting on, but it's all general fund and adding that additional sentence, which is what we had done in our prior report.
Yep, that's correct.
Okay.
Ooh.
Thank you very much, Representative Harnett. Committee, are we ready to vote on, and then, yes, Sam, that's super helpful. So what we're voting on is the MHRC proposed to JUD, that revision. So if everybody can take a look at it, and then we're going to stop the screen share so that we're able to vote. And so for those who are in favor of the proposal that was just most recently screen shared, you can raise your electronic hands and keep them raised, please. Okay. All right, and Senator Sanborn, are you available to vote? No, okay. And then let's take our, Soupy, are you all set with that?
Oh, Senator Sanborn just appeared.
Okay. All right.
8.
And then let's take, everybody take our hands down, and for those who are not in favor of the screen share, if you could raise your electronic hand, and that would be Representative Hagan. And Representative Hagan, could you please let us know what your report, what your vote would be?
Just no. Thank you.
Thank you very much. All right, so I think we're concluded our work on Initiative 5.
So we are on 6, still with the Maine Human Rights Commission. This could continue one limited period management analyst 2 position and eliminate 1 position and transfer all other to personnel services to fund the position. The committee in its report back in the biennial had recommended continuing 1 management analyst 2 position with personnel services account funds. And let me go to numbers, I'll hop back up here. All right, so we are right here. 6 here. So this is again federal expenditures.
Thank you, Sam. Committee members, are there any questions about Initiative 6? Is the committee ready to vote on Initiative 6? It appears that we are. So for those who are so Sam, is it, I'm looking at Initiative 6, is it, does it not, is it just a wash, essentially? Or am I looking at the wrong document?
That's how it looks to me. Lauren, can you verify that for me?
Sure. So I think in future biennium, it's not a wash anymore because it eliminates one paralegal for forever. And so there's some savings in future bienniums that's maybe not captured here by the offset of continuing a position that ends in 2023, if that makes sense. There's kind of a lot going on in this one initiative. But so there's essentially one position that will continue until 2023, but the initiative also eliminates a position. And so those savings from eliminating a position will continue on. And it won't be a wash anymore. But Melody might be able to offer how those things work out better than I can.
Thank you. Yeah. So again, this is Melody Hyper. I believe the intent was we self-funded this without any additional or changes in federal revenues. And I don't foresee that there's going to be an issue ongoing in continuing the funding for this position. It's probably a couple $1,000s a year, or that it'll change here and there. And the other position would have progressed at a similar rate with some minor adjustments, but we don't foresee this being an issue. And we can always adjust another line if we did find that that wasn't, going to cause a hardship for us with the federal revenues. I hope that answers your question.
Yeah, I think it does. It does. Thank you very much. Both Lauren and Melody, thank you. Okay, committee members, are we ready to vote on Initiative 6? Appears that we are, and so let's follow the same pattern we've been. If you are in favor of Initiative 6, please raise your hand and keep it raised until after Supi has been able to tally the votes.
Get 8.
All right, let's take our hands down. And then for those who are opposed to Initiative 6, Representative Hagan. And Representative Hagan, what is your report back to AFA on that one?
No, thank you.
Okay, thanks. Sam, do you need more information than that?
Nope, I think I'm good.
Okay, great. All right, thank you.
So the number 7 is a one-time funding for retroactive pay due to a prior employee. That is in the amount of $5,760, and it's just in 21-22. And then that's it.
Any questions, committee members? Melody, is this an obligation that the commission has already incurred with regard to the employee?
Yes, the employee has, I believe it's been at least a year since they left state service, and the amount will continue to accrue interest until funding is identified. So it's just pushing it off further and further, and the employee is owed these amounts. because they signed their reclassification was employee initiated. So yeah, we do. It's just going to be an ongoing obligation plus interest.
Thank you. And Representative Cardone, did you have something you wanted to contribute?
I was just going to ask Melody if this is one that would be accruing interest. She's already answered it. Yeah.
All right. Any other questions about Initiative 7, committee members? All righty, let's go ahead and vote on Initiative 7 then. If you're in favor of it, raise your electronic hand and just please keep it up until we've done the tally. You all set? Yep, okay. And so let's lower our hands, and those opposed to the initiative, please raise your hand. And if you can, Representative Hagan, your report to AFA will be?
No.
Okay.
Thank you.
Thank you.
Got number 8. So we are now on to the MCILS.
Just a moment, please. Representative Harnett has his hand up. Sam, I'm sorry. Go ahead, Representative.
Understand what the no vote means? Does that mean we have an obligation and we'll just continue to accrue interest on it?
That for me.
Yes.
I just
That's funding for the retroactive.
I'm opposed to all spending. I'm not sure I understand the question. I'm sorry. I had a phone call.
Well, this is a legal, my understanding is this is a legal obligation that the state has to pay to an individual. So by not appropriating the money, we just simply continue that obligation and incur a greater debt.
I think that, yes.
Okay, thank you.
And Representative Hagan, the previous one was just essentially a wash, and you're a no vote on that as well.
Well, yeah.
Okay. Thank you for clarifying. All right, Sam, I think we're ready to move on.
So we're on the Commission for Indigent Legal Services. There's only one initiative, and that is reorganizing the executive director position from a range 52 to a range 37. That's not actually lower. It's actually it raises the top of the range. So it would be in salary specification 2 and funding the position at step 12. The biennial didn't include an initiative related to this, but the committee did recommend 14-0 to do exactly this in the biennial report back.
Sam, that was one of our initiatives that we added to the biennial budget. Is that correct?
Yes.
And what was the vote again, please? I was shuffling paper.
Sorry?
I was shuffling paper. What was the vote again when we reported back to the?
It was unanimous, 14-0.
Okay, thank you.
Can I raise a question here? This was one, I've been feeling under the weather, so I didn't get to meet with the commissioner, the DAFS commissioner today. But one of the questions I asked to pose is that it looks like in wording, the change package includes the same initiative that Judiciary had in its change package, as that Judiciary put together as a new initiative. However, the numbers don't match. And I don't know, Sam, do you know why the numbers don't match and what is the correct number to be using?
I can look at the number. I'm not sure why they don't match. I can try to find it here and see if we can. That would be Peggy right down here somewhere.
Right there.
Here it is. Oh, look, I landed on it.
You've only got like not less than $10,000 on that, and they've got like 32,000. And I'm not sure what that number says.
Right. So if I could, we were just looking at the top range for both the top salary at both of those ranges. And that was the difference. They might be looking at, the difference between what the salary is now, what's being paid now, and the top of the new range.
And it's
That might
funding
make a
it at a step 12.
Yeah.
Okay, so I think that's right. I think they're funding it at different, they're bumping it up some steps.
Okay, because I think the current salary is about 104,000. So you might want to take this vote, making it clear that you're voting either in or out on the higher number on the governor's change package, as opposed to what you had in your initiative, if you believe that that's the correct number.
Thank you. Okay.
Is the current salary relevant to our vote though, or not?
It's relevant probably to what the numbers are, but not necessarily to whether we're approving this initiative.
I was going to say, we're changing the range though, aren't we? I mean, the category.
No, I think your range is the same. The wording is the same in the initiative. That's why I couldn't figure out why the numbers were different.
I think we're comparing apples and oranges a little bit here. Representative Babbage, you are correct in that we're changing the range from what it is now. But I think what Representative Cardone is saying is that we're changing.
It's compared, yeah. I got you.
Maintaining consistency with the initiative that we did in the biennial.
Thank you.
Yeah. Committee members, any other questions before we move on to a vote on this initiative? Looks like everybody's all set. So we'll follow our same pattern. Please raise your electronic hand if you are in favor of this initiative and leave it up until we've done the count. Okie doke. So Soupy, just let us know when you're all set.
All set.
Okay, and then those who are against the initiative, please raise your hand. And Representative Hagan, are you a straight no on that?
Correct. Thank you.
Okay. And then the report back, we should flesh it out a little bit. And Representative Cardone, you had suggested some language to make clear that we weren't necessarily restricting. You'd suggested some language so that we made clear that, I can't remember exactly how you phrase it. I don't know, Sam, if you remember.
To go with the governor's change package numbers as opposed to the biennial report back numbers that judiciary had initially proposed. And
right.
I'll make that clear.
Okay. Thank you so much.
Yeah, and we should get some clarification from DAFs. If they didn't get it already today, we should get some clarification on what those numbers are.
Great. Thank you.
Great. So next one is MITSIC, and this would provide one-time additional funding to support staff for MITSIC's activities. The biennial budget didn't include any initiatives, but this was one of the additions that the additional new initiatives that judiciary had recommended in its biennial report back. So this is next page, and it is in the same amount that the committee had recommended in its biennial report back that you'll see reflected in the change package here.
Thank you, Sam. And do you recall, Sam, are you able to let us know what the vote was when we added this initiative?
See if I can just pull it up here. Should be here somewhere. And if Peggy finds it quicker than I do, tell me. Would be down here in one of the additions because we did add it.
I have it as 9-4. We actually wrote it in, Sam. It's not a separate one. We wrote it in on the
right. Yeah.
the baseline page. It's page. Yeah. It's typed.
Right
there
here.
You go.
Yeah. You two are amazing. Okay, so that was the initial initiative. All right, and so now committee members, if we can turn our attention to a vote on the initiative in the change package. And again, please raise your hands and leave them raised if you are in favor of the initiative, number 9. And Representative Cardone, are you still with us and able to vote? She may have had to step away for a moment. Okay.
7.
Yep. All righty, and then those who are opposed to initiative 9? Representative, I just want to clarify, Representative Cardone, we're voting on initiative 9. Were you a yes or a no on that? You're a yes? You're muted, I'm sorry.
I'm in favor of it. I was away from my screen.
Okay, that's what we figured. Okay, and then Representative Hagan, you are a no on initiative 9?
Yes, I am. Thank you.
Thank you.
Representative Moriarty has his hand up.
Yeah, I was just going to ask him. On initiative 9, Representative, you were a yes, correct? Representative Moriarty?
It was, yes.
Okay, thank you.
Yep.
Thank you.
So we are on number 10, and we are with the judiciary now. So this initiative would provide funding for increased guardian ad litem costs due to an increase in child protection case filings. So the biennial also proposed increasing GAL funding due to increased caseload. From what I understand, there were discussions that indicated that that funding might not be needed because of limited court activities. So the committee did unanimously vote against the initiative, but you will see then that the initiative is then again reflected in the change package. Peggy, I don't know if we got any additional information about the necessity of those funds.
So I think what the change package is doing is amending the original budget submission and deleting, agreeing with what the committee did in response to the judicial branch saying we don't need it. So I think the change package right there is deleting.
Oh, I see the delete at the top.
Yeah. So I think this is consistent with what happened before. I mean, what the earlier vote.
So it's not a savings because it never was. It's a kind of fiction. It never existed. Right.
Right. It was an additional appropriation
Got it.
that now we're going to just erase.
Got it. Thank you.
To further complicate this, just so you know, and I don't know that it matters what you do. We've already voted to hold this in AFA because I had a discussion with Ted Glessner and some others from Judiciary on the budget. This guardian ad litem cost is can be deleted. If we don't raise the rates for MCILS attorneys. If we raise the rates for MCILS attorneys, they want to raise the rates for guardian ad litem attorneys as well. And if the rates were raised as proposed from 60 to 80, they would need an additional $968,000 for guardians ad litem. So all of that is in the mix with MCILS. I'm not sure it matters what you do on this at this point, because we got to deal with it at the AFA level. We're aware of that and we're holding that. So I just wanted to let you know what's going on with this initiative right now.
So Representative Cardone, would it make sense for the committee to vote to hold this while other issues are being addressed? Or would it make more sense for us to simply not vote on it?
Either way, you could vote to hold it based on needs to be projected with MCILS rates. I mean, that's what we're doing anyway.
Okay, so to hold it based on projected needs related to changes in MCILS?
MCILS rates, yes.
If you do have questions for Ted Glessner, he is in the attendee room now.
I have a question for Barbara. The 254 that we have here, how is that related to the 900,000 you mentioned?
If we don't do anything with and Ted, I'm getting this from Ted. Ted can explain this, but if we don't do anything, if we leave the guardian ad litem rates where they are at $60 an hour, they don't need that increased money. If we raise the guardian, if we raise MCILS rates, the judiciary wants to raise guardian ad litem rates to match the rates of the attorneys that are representing the parents. This is primarily in child protective work. So they would want to raise those rates. Their projection for what they would need based on $80 an hour rather than $60 an hour is 968,000, correct, Ted?
Correct. Yep.
Okay. But they're only asking for that money if we do something to raise MCILS rates.
But that's really not before us right now.
Well, it isn't. It is before it's before AFA, yes. And to the extent that AFA is looking for your report back, it would be helpful. But I just wanted to make clear to you that this isn't a straight in or out. This particular item isn't a straight in or out. It was proposed by the governor based on the assumption in her budget that we're not going to do anything with the MCILS rates, because as you will see, as you saw in the change package, she didn't fund those rates. That doesn't mean AFA won't do something with it, that AFA won't fund it. And we are looking very carefully at your prior report back on MCILS.
Thank you, Representative Cardona. And we actually we have some additional MCILS bills that we'll be reporting out in the next couple of days related to on that same topic. And so committee members, in order to potentially support a potential need that will arise out of the work that we're doing related to MCILS, I would like to propose that we vote to hold this initiative based on projected needs that are related to potential changes in MCILS rates. And so that would be my proposal for our vote. And Representative Cardone, can you just give me a thumbs up if that's the right language to use?
Yes, that's what I would use.
Okay, so committee members, if you are in favor of that proposal and report back to AFA, please raise your hands and keep them raised. And Representative McCrate, you do not have a hand up. Did you intend to? Yeah, okay. All set. Okay, and let's take our hands down. And then those who are not in favor of that report back to AFA, please raise your hands. And what is your report back, Representative Hagan?
I don't have one. I did not understand what just happened. So could you please explain it? Because I'm not for or against.
I'll give it to you in a nutshell, that this is money that is proposed to be deleted, but the judicial branch may in fact need it if the rates for MCILS attorneys are raised. Then the judicial branch would like to also look at raising the rates for guardians ad litem in child protective cases. And so they would be able to put this money to yes vote on that then?
Yep, yep.
Great, thank you.
Thank you.
Great. So we are on number 11. So still with the judiciary, this would establish 10 deputy marshal positions to provide entry screening at courthouses. You will see the numbers right here at the top here. You'll see the funding for that, student personnel services.
Okay, Representative Cardone, go ahead.
I don't know if Ted Glessner is still here, but that Ted is I spoke with Ted about.
He is here. And we
Okay, and he can explain this to you as well. This will establish 10 judicial marshal positions. In order to have complete coverage of all the courts in the state on all the days that those courts are open, the court needs 20 positions. This gets them halfway there. And this is something that Chief Justice Softley has been begging for years and years. And we keep inching a little bit closer. What I understand from Ted, and again, he can confirm this, is that the governor's office said, we'll give you 10 positions now, and then we'll look at the final 10 in a supplemental budget. But this really is a very important public safety issue. Right now, I think, Ted, am I correct on this? I think we have coverage whenever there are court dates in most, if not all, courts. But these courthouses are open most days, if not all days. And as most of you know who have served on this committee for any length of time, the problems with violence at courthouses happens primarily in family matters, protection from abuse. It is highly conceivable that somebody could walk into a courthouse on a day when there's no judge there, but seeking a PFA, a protection from abuse, and somebody else could come in with a gun and start shooting. So these clerks, as well as the public who have access to these courthouses, even when there are no judicial proceedings going on, need to be safeguarded. We need to make sure that people know that our courthouses are safe. And that's what these positions are going to do. 10 gets us halfway there.
Thank you, Representative. Ted Glessner, did you want to add anything?
I think Representative Cardone did a great job. That's totally accurate. In order to have all the courts open all the time, we would need 20 marshals. And so there are days now when we have to keep courthouses closed to the public. The staff might be there working, but if we don't have entry screening. We just had an incident in Bangor weeks ago where someone came in the front door with a makeshift weapon and actually attacked the marshals. They had to use a taser to subdue him. It was a very serious situation. And we don't want to have a situation where we have clerks in a courthouse and just because there's no activity, the door is open and someone can come in. So we're very appreciative if we can get these 10 positions. And as Representative Cardone said, that would get us halfway there.
Madam Chair, may I ask him how many courthouses, how many marshals currently?
Well, off the top of my head, the overall number is about 90 marshals that we have. And the number of courthouses is right now, I believe, 44. When you think about the courthouses, you think about people doing entry screening, and then also there has to be a marshal in the courtroom anytime there's a judicial officer there. And the math just doesn't work.
Thank you.
Thank you. Thank all three of you. And Representative Hagan, did you have a question?
I just have been in courthouses quite a bit my day. Just I've never not gone through screening and never not seen quite a few people, guarding the place. So have question as to why we need more.
Did you want to answer that, Ted Glessner?
Yeah, I would just say, Representative, that you would go to most courthouses most days and you would see what you described, adequate coverage there. But there are still not enough. When you go to all the courthouses, there would always today be some that we could not have open because you don't have enough people to cover.
All right, is everybody ready to vote on this initiative? Seems like we are, and so let's follow our same process. This is Initiative 11, the 10 deputy marshal positions. And Senator Sanborn, if you are able to activate and vote. Oh. All right. And then Representative Hagan, are you a straight, what is your vote on that?
I'm going to be a no on that. Thank you.
Thank you very much, everybody. And now we're closing in on the end here. We're on the last page of, well, we got a couple more pages, but we're doing well. Go ahead, Sam.
Initiative 12 provides funding for the reclassification of an IT field tech position to an IT operations administrator position. And the numbers on that are here, 20,289 and 20,284 in the next year out of the general fund.
Okay. Committee members, any questions before we vote on this? Representative Hagan, did you have a question?
Well, I just can't see it. Can we go bigger?
Right in the middle, Dave.
It's this one right here.
Thank you.
Sure.
And Representative Cardone?
A question for Ted Glessner. Ted, are any of these reclassifications by the employee that would be accruing interest?
No,
None of them accrue interest. Okay.
no, that's correct.
All right. And Representative Babbage, is your hand up as a result?
I'm sorry.
No, that's okay.
Yep.
Just wanted, because I think we're going to be moving on to a vote. Are you all set, Representative Cardone? Yeah. Okay, so committee members, we're going to vote on Initiative 12, the reclassification of the IT position. Please raise your electronic hand and leave it up. And Representative Harnett, did you have a question?
I did. Thank you, Madam Chair. And why is it, Sam, that we did not have a vote on this and all of these ones coming up?
Oh, you mean in the biennial?
Yes.
They weren't included in the biennial. These are initiatives that were not in the biennial.
Thank you.
All right. You all set? Okay. And then Representative Hagan, what is your vote on that one?
I'm a no.
Thank you.
Thank you.
All right. Sam, we're ready for the next one.
Next one is number 13, which would provide funding for the reclassification of one Division Supervisor 1 position to a court operations coordinator position. And the numbers on that are here. This is 11,658 in 21-22 and 12,243 in 22-23.
Thank you very much, Sam. Committee members, any questions? I think Senator Sanborn, your hand is a residual, right? Okay, great. All right, committee, I think we're ready to vote on this. Please raise your electronic hand and leave it up. You let us know when you're all set. Good, okay. And then Representative Hagan, are you on straight no on that one?
Surprisingly, I am a no.
All righty. I think we're ready for the next one, Sam?
We're on 14, which would provide funding for the reclassification of one Windows administrator position to an IT enterprise architect position. I don't know what any of that means. It's technology. So
I
we're on
Ted Glasser
14.
can help us with that. If you wouldn't mind, just a few words on that, Ted.
Well, the few words are that that number is wrong. It says 56,957. You see that? That's not our number. It actually looks like a total rather than a single number. So that position is very similar to what's going to come up as Initiative 16. That's what the number should be, very close to the 10,578, not 56,957. So I don't know how that happened, and it wasn't like that on earlier documents. So I apologize. This is the first time I'm seeing that. So.
I was kind of excited to ask how much an IT architect gets.
A lot of people are prepared to apply for that position, Representative.
Okay, and so Representative Cardone, thank you, Ted Glessner, for that clarification. And Representative Cardone, if you could just chime in here and let us know what the language is that we would use to report this, a vote on the corrected dollar amount back to AFA?
Ted, do you know what the corrected dollar amount is?
I don't know exactly, but I will tell you that it should be approximately the same as that initiative number 16, the 10,578.
I'm just checking to see. I don't have her. Hang on just a second. I'm going to look at the commissioner's testimony and see if she gave us the correct dollar amount, if she noted this problem. Hold on.
Okay.
While Representative Cardone is doing that, I think maybe it would make sense, Sam, if you could take us through the initiatives 15 and 16, just so that we're all kind of familiar with it for when we move on to vote.
So initiative 15 provides funding for a range change for one revenue manager position from a range 16 to a range 17. And that is the amount for that is 8,878 in 21-22 and 8,877 in 22-23.
May I ask Sam, again, just to clarify in my mind, if you would, are we talking about the difference in dollar amount at the top of the range, or are we actually talking about the difference in pay that the current personnel would receive?
So this would be the difference in somebody being paid for a year at a range 16 versus being paid at a range 17. So I'm assuming they are a range 16 now, and this would up them to a range 17.
I'm not understanding how, if a person's been with us for 10 years versus 20 years, is that calculated at all? Or is a range a flat rate? Or
it's in the salary schedule.
Okay.
So it's part of the salary schedule.
I guess
Sorry. Sam, can you give me the page number of that?
Yes. The page number is 151.
Thank you. Sorry, sorry, Chris.
No, but I'm saying you can't be examining the precise salary of each one of these people. It's got to do with more
it's a set salary schedule.
Yeah. Okay.
And this, I think, is just applies to one person, Representative Babbage.
Right.
Should I go over 16 while we're?
Yes, please.
I can tell you that for 15, it does not look like she's noted the changes. She just talks about the deputy marshal's position on page 151. She doesn't note that there was any error. So that might not be an error that they caught.
On initiative 4, I think it's initiative 14.
15, yeah.
Oh, 15?
Yeah, or
14.
Sorry, 14, you're right. I apologize, yes.
Yeah, no, that's good. Okay, so Sam, if you can describe 16 to us, and then we'll go back and we'll vote on 14, 15, and 16.
Sure. So 16 provides funding for the reclassification of a senior database administrator position to a senior database administrator and security officer position. And then the amount for that is, as indicated, 10,578 and 10,575 respectively.
All right.
14, 15, 16.
Okay, so, and Representative Cardone, can you suggest the language that we would use in our report back on initiative 14 to indicate that there's an error?
If we're gonna vote it in anyway, regardless of the amount, I would just note figures are inaccurate, need corrected figures or something like that. Again, this is going to come to me and I'm going to present it to the committee, and just to remind me of that, I'll know what it is.
Great, thank you. Okay, so committee members, let's vote on 14, 15, and 16 together, because I suspect that our votes will be the same for all of them, but we will just note them separately on our report back. So if you are in favor of each of those, raise your hand and leave it up.
May I ask, we're not approving 56,000, are we?
No, we're going to note that the figures need to be corrected in our report back for initiative 14. So the report back will say initiative 14, yes, but figures need to be corrected. 15, yes, 16, yes, or no, depending on how your vote is. You all set? Okay, so those who wish to vote against 14, 15, and 16, please raise your hand.
Barbara, can I ask a question, if I may, Madam Chair? The general fund, once out.
1 second, Representative,
Okay, sure.
you don't have
sorry.
the.
We didn't finish.
Megan, are you a no vote on 14, 15, and 16?
Can we go over that one again, please? Reinstate it. Talk about it more, or re-explain it.
Yep, so initiative 14 is a reclassification of one position. The figures are inaccurate and need to be corrected, but that is the increased salary for the reclassification of that position. Initiative 15 is changing the salary range for one position, and the dollar amount is the difference in the two salary ranges. And then initiative 16 is another reclassification of one position. And the dollar amount is the difference between the old classification and the new classification.
Thank you, I'll be no.
Okay, thank you.
So the clarification I'm asking for is, these general fund approvals that we're making, did they become part of the permanent force, and the special revenue funds allocations will need initiatives specifically for them again in the next biennial?
I'm not sure I understand your question. If we approve general fund, add new positions, they do become part of the baseline budget, unless they're limited period positions. If it's a one-time general fund, it doesn't get into the baseline. Somebody with a higher pay grade than me can tell you what happens in terms of those positions and OSRs and what happens once they get voted into a budget. Perhaps Lauren can answer that.
Okay, Barbara, am I right though that the special revenue funds would have to be re-examined in 2 years?
Not, they would get re-examined as part of the baseline budget. It's part of that
Part
whole
of the
budget
baseline.
that you get, that as part of the whole budget that you get from the beginning. They wouldn't be new initiatives.
Okay, thank you.
Okay, I think this brings us to our last one, number 17. Go ahead, Sam.
We have
Please.
two more after 17. We have 2 languages, but this is the last initiative. So this would provide funding to move all current deputy marshal positions up 2 steps. And that aligns with the new hiring policy that all new deputy marshals begin at step 3 of the range. So this is a new initiative to the change package. And this is the fiscal for it. So 127,334 in the first 2021 to 22, and 90,474 in 22 to 23.
Go ahead, Representative Harnett, with your question.
Thank you, Madam Chair. Sam, this is, again, this is basically saying we're going to increase the salaries of people that are already employed to make them equivalent with the salaries of people who are going to be hired?
Yeah, so it's bumping people up so that it is in line with the new policy to hire everybody at step 3.
Okay. Thank you.
Other questions, committee members? Go ahead, Representative Cardone.
I just wanted to check with Ted Glester. Ted, did the 10 that we previously voted to fund, were they all at step 3? They're at the current at the new level?
Sorry, yes, they would be funded at step 3.
Okay.
Thank you. Committee members, are we ready to vote on Initiative 17? All right, if you're in favor of Initiative 17, please raise your hands and keep them up.
I guess so.
8. 8. And Representative Hagan, are you a no on that?
I'm a no. Yes, thank you.
All right. Then we.
Great. So we have 2 more on the next page. So 4 more to go. This is our language sections. So language part KK removes the requirement that is currently in statute that the state purchase a bond when acting as a public guardian or conservator. It would retain that requirement for private guardians or conservators, but remove it for public ones. So the committee did recommend this go forward. The committee voted 12-1 in favor of that language in the biennial, but didn't make it into the budget. So let me show you that language here. Where is it?
I don't think it's in the change package.
Oh, it's not actually, we
yeah.
can't see it. Okay.
Yeah, I thought.
It probably is in here though. It would be in the biennial.
Yes. Yeah. So I think it just did not get incorporated into the budget that passed. Does that make sense, Representative Cardone?
Yes.
So it's still kind of out there and pending.
Yeah, it'll get incorporated into the new budget. That's it. It just wasn't one of the things we put in that continuing services budget.
That's what it's called.
Yeah, and these bonds are not required because the public guardian is already immune from liability, right?
Right.
Okay. So are there questions on this, committee members? Representative Moriarty, your hand is up. Did you have a question? No. Representative Cardone, did you have a question?
Nope, sorry.
No, that's all right. I just want us to all. So, okay. So committee members, if you are in favor of this language change, please raise your electronic hand and keep it raised.
This actually saves money.
It does. $8,000 a year, right?
It might even be 14.
14.
Oh,
But it's not in the Judiciary Committee's budget.
okay.
This was based on a bill Donna Bailey brought in front of this committee in the last legislature. So I told her she literally earned her salary by bringing that bill.
All right, so we have 8 yeses on this, and then Representative Hagan, are you a no on this one?
No.
Okay.
And that part that we are voting on is specifically what letters?
It's KK. We don't have a copy of it
I see.
in the materials, but we voted to approve it last time. It's just
Gotcha.
eliminating a bond expense that we don't need.
And Sam had it up on the screen if you do need to look at it.
No, I remember it, but I was looking for it. Yep.
Oh, sorry, I was premature. Sorry, Soupy.
Got you. Thank you. Thank you, sir.
I got a 8-1.
Thanks, Soupy.
All right, now I will go back. So next one, EEE, amend statute to authorize remaining all other balances in the MCILS program to carry over each fiscal year. And sorry.
I think that
Is
was
there
actually,
language?
that was part of your report back to appropriations. It wasn't part of the original bill.
Yes, this was your initiative to baseline the MCILS funds so that they don't keep having to go back for each budget to get additional funds. One that I am very much in favor of and am pushing the committee to the AFA to adopt, so that we don't run the risk of lawyers not getting paid while courts are up and running. It jeopardizes the ability to provide legal counsel in constitutionally obligated situations.
And this actually is a permanent replacement because it amends Title V. What you had recommended earlier in the year was to make it apply in 2021 and 2021-22. So you would have to do it every year or every biennium. This actually puts it into the statute and makes it clear that it is one of those, you call it a carrying account, where it carries forward.
Thank you. Any questions, committee members, for Representative Cardone or Peggy or Sam on this? Not seeing any questions, so let's move forward with a vote on Part EEE, the language change, with a show of electronic hands.
Oh, still up there. Okay.
Thank you.
And I think that Soupy has us all set. And then for those voting against, a show of electronic hands for a no vote, please. Thanks, everybody.
Almost there. So FFF with MCILS allows MCILS to establish standards and training for assigned counsel through technical rulemaking. The committee did vote 11-1 in favor of the proposed language. They did correct the summary. The summary language was incorrect in the biennial, if you recall. And this does correct that language. So you'll see here the revised summary instead of reference to compensation, changes that to standards and training.
Any questions, committee? All righty, let's vote in our usual manner. If you're in favor of Part FFF, the proposed change,
Sorry, I have to see Representative McCright. Thank you.
Thank you.
Thank you.
All set? Okay. And those opposed to the correction in the summary on FFF?
Thank you.
All right, I think we're all set on that.
The very last one is kind of it's just the companion language to the prior initiative that had changed the salary range for the executive director of MCILS. So this changes that language in statute. And you had previously voted on that initiative, and this is again the statutory change that accompanies that.
Sam, can you just remind us what the vote was on this when we did the biennial?
Let me see.
Remembering.
Peggy, can you see which initiative that was?
I wonder if I might have it here.
Check which number it was here.
What do we, which?
That was number 8. So that vote was 8-1.
Thank you very, very much, Sam. All right, committee members. Do the usual show of hands, please, on that last part GGG, our last vote tonight.
And why is that necessary, Sam? It's not the same as 8?
So eight was the money. 8 was actually doing it. This is changing the language in statute.
Gotcha. Thanks.
All set? Okay, and then now let's lower our hands, and those opposed to the change in GGG. All right, I think we're all set. Sam, do you need any more information, or Peggy, any more information from us in order to be able to report back to AFA tomorrow or whenever?
I think I'm all set. I think I'm good.
Okay, thank you very much. Peggy, Soupy, or Sam, do you need anything else from us before we say thank you and good night to everyone?
I don't think so.
All right.
I don't think so.
Fine, thank you.
Start up tomorrow morning at 10, I believe. Thank you for all the hard work today, everyone. Appreciate it.
Obviously a team effort.
For sure.
Indeed.
Good night, all. Thank you.
All right, take care, everybody.
Thank you, Ann.
See you now.